I called someone because I was checking it at you. Said, this is Philip Katz. In case she was like, I know, I've been working on it. So. Anyone's sitting here.
Picking up both of your guys' conversation as well as the two coding minutes. Don't let them confuse you unless they absolutely have to. Of course, most of our favorite perhaps you don't turns out well and switch it out. Yeah. So
Good morning, everybody. Sorry, it's a little loud. We'll get started here in just a few minutes, but I'm going to give people maybe 5 more minutes to this, and then we'll get started. Thank you. Good morning, everybody. We're going to go ahead and get started here. My name is Philip Katz. I'm an attorney at Koenig Dunn Divorce Law, and I'm the chair of the family law section of the Nebraska State Bar. Some of you have probably seen some of my many emails I've sent out about this seminar. Before we get started, I wanted to thank a few folks. Adam Astley, who's out there and actually wore a suit for me today, has been the chair the last 2 years, has done a great job. He's been a great resource. As you guys know, the bar was deintegrated like a year and a half ago, and they had to get rid of some positions, create new positions. Catherine Bellman, who did everything for the Bar Association in these events, is no longer with them, and her position effectively got divided among 3 new people who had to learn on the go. So I wanted to thank Sarah Hughes, who you see out there, who is the CLE Director and Publications, and Lori Benson, who is the section facilitator, and just wanted to thank them. We have a great lineup of speakers today. Before we presenting, I think, on some very interesting issues, I wanted to just touch on a few housekeeping issues. We do still have evaluations like we've had every year. We'd really like to have your feedback, how you feel about the presentation, everything from the content to where it's being held, when we're starting, if you like the food, all that stuff. But they're going to be sent out. They're going to be sent out, I believe, on Monday via email. And if you take the time to fill those out, I'd appreciate it. It was in the interest of saving paper. If you've looked at your binders, we clearly didn't abide by that concern too much there. But there's also going to be lunch provided down in the atrium. At the lunch break, you'll just head down these stairs and head to the left. Just before we go to lunch, though, I'm going to ask you to stay in your seats. Liz Neely, who is the Executive Director of the Bar Association, is going to talk to us for about 5 or 10 minutes up here about NSBA updates, as well as new benefits the Bar Association is offering its members. And then the last thing I wanted to mention was at the end of the day, we have a reception with hors d'oeuvres, open bar from 4:30 to 6. Please come enjoy the free drinks and food. And also, we're going to have one presentation today that involves crowd participation. It's this Turning Point software where you're going to get a chance to use a clicker and find out if you would be disbarred if you answer incorrectly. So that's going to be the presentation just before lunch. So we're going to hand out these clickers to each of you, and when you go to lunch, just leave it there and someone will gather the clickers, but they're like $75 a pop or something, so if you could leave those, I'd appreciate it. And so that covers that. And then lastly, although I really do want you to hopefully listen, these are interesting subjects you're going to be hearing about today. There is a free Wi-Fi network. It's the conference center one. The username is LVCC, and the password's 1234. So, at any rate, our first speaker today is Susan Sapp. She's an attorney at Klein Williams. She has a general trial practice and practices in several areas, but one of her primary areas is in the area of adoption law. She's a fellow with the American Academy of Adoption Lawyers. Today she's going to be presenting, as you know, on navigating the changing waters of step-parent adoption and assisted reproduction with the Obergefell decision and marriage equality coming to Nebraska and all 50 states. It certainly has had its effect on adoption and how we handle those issues. And with that, I'll hand it off to Susan.
Thank you, Philip. Good morning, good morning. We are going to talk more about how babies are born than you've talked since about 8th grade health class. So bear with me. What you're going to know when you leave this morning is how to answer questions about step-parent adoptions in light of the marriage equality changes across the country. 2, you're going to learn whether you want to handle the step-parent adoption, and if you decide to, then how to do it correctly and get it done. So we've got a lot of material packed into 45 minutes. We'll try to save some time for some questions at the end. I want to give you a review about assisted reproduction so that you know the lingo and you know the questions to ask when a child has been conceived through assisted reproduction, or ARTS as we call it. ARTS may come into play in a heterosexual couple or a same-gender couple, and you need to be prepared to ask the right questions. Understand that there are several means in the ARTS world of getting a pregnancy completed: intrauterine insemination, gamete interfallopian transfer, zygote interfallopian transfer in vitro, embryo transfer, gamete donation, embryo donation, and collaborative reproduction. Collaborative reproduction is surrogacy and gestational carrier. Do you need to know all the science of those? No. You need to know, how did sperm get to egg? How did bun get in oven? That is the bottom line that you need to figure out. That's at the level I can understand it. Now, on more than one occasion, I've talked to folks who've said, oh yeah, we had, the baby was conceived through artificial insemination or in vitro. And the temptation is to say, okay, done, check. You got to ask some more questions. Ask, what clinic did you have this done at? I don't care the name of the clinic. I just want to start the conversation about whether this occurred in a clinic or at home with a turkey baster. I kid you not. It matters because if someone donated an egg or a sperm sample at a clinic, they would have signed waiver documents and anonymity documents, and you would not be dealing with potential parental rights in the donor, where if this was a homemade, I'll spare you the details, but if there's a homemade situation, then you've still got somebody who has legal rights, even if the sperm was transferred via turkey baster. So as much as you may not want to hear the details, you've got to ask the details about how did this child get conceived. And then you've got to do a legal risk analysis for whose rights are out there. It could be, seriously, mixed sperm of several guys who donated prior to the turkey baster's usage. It could be one guy. It could be a guy married to the gestational carrier's friend. It could be a sister-in-law of the intended mom. It's probably always going to be her egg if you're talking about a homemade situation. But you have to know the story, and therefore you have to know the lingo. When you're talking about collaborative reproduction, we're still on page 1 of the outline. Collaborative reproduction can be any time there's a gestational agreement. It could be embryo donors, assisted reproduction with gametes, or traditional surrogacy. And it's important to understand the lingo when you're talking to folks. Traditional surrogacy involves an individual who both provides genetic material, meaning her, and acts as a gestational carrier. Gestational carriers are always women. So it's either someone else's egg, and then you had the embryo or the gamete introduced into her body. So it's her egg, could be her egg or someone else's egg. It could be a donated egg. It could be the intended mom's egg. Sometimes in a true, pure gestational carrier, just a rented womb, if you will, it is the intended mom's egg and the intended dad's sperm turned into an embryo implanted in gestational carrier. So she's literally not genetically related to this child at all. That's true gestational carrier. Traditional surrogacy is either a donated sperm or intended dad's sperm injected into surrogate, and it's her egg. So she is genetically related to the baby. That can matter for adoption purposes. Nebraska, of course, has very little statutory law in the area of surrogacy. We have one statute, 25-21, that states that a surrogate parenthood contract shall be void and unenforceable. That doesn't mean doing surrogacy or gestational caring in Nebraska is illegal. It just means it's unenforceable. So you've got to advise folks of that fact. And then a surrogate parenthood contract shall mean a contract by which a woman is to be compensated for bearing a child of a man who is not her husband. So that begs the question, what if she's not compensated? What if she's the sister-in-law of the intended mom who's just carrying the baby as a favor? Bottom line, don't tell folks if they're doing a homemade or a clinic surrogacy or gestational carrier that rights can be enforced. There is case law around the country, but of course none in Nebraska, as to what happens when you've got a true gestational carrier, intended mom's egg, intended dad's sperm, makes an embryo, gestational carrier carries the baby, has no genetic connection. Would that be enforceable because of the lack of genetic connection? Case law around the country would say yes, but this statute certainly blurs that issue in Nebraska. So turning to birth certificates on page 2, section C, understand that right now, as of this moment in time, Nebraska law basically is if it's your womb from which the baby's born, it's your name that goes on the birth certificate as the mother. Whether it's your genetic material or not, the womb owner goes on the birth certificate. Then statutes allow the womb owner and a guy to agree that the paternity is properly in the guy. So if you have a gestational carrier and she's not the egg owner and she's not the sperm owner, those came from the intended parents, gestational carrier will go on the birth certificate, intended mom will not, intended dad can go on the birth certificate with the agreement of the gestational carrier and the dad. They can sign paternity papers at the hospital, go on the birth certificate, and then you've established legal parenthood with the dad. So what do you do with the mom, with the intended mom whose egg formed the child, but she was not the womb owner? Right now, we have to do what can only be described as kind of a strange step-parent adoption. So intended mom whose egg helped form the baby has to be the adopting mom from the womb owner. So that's how we do it now. New legislation would be helpful, but I don't know when and if we're going to get that done. So one of your questions on intake is, the first one is, how was baby conceived? Number 2 is, who's on the birth certificate? Whose genetic material was used? And what are the rights, either contractual or statutory, of the person whose womb gave birth to this child? When you're working in this area, language matters. The lingo matters. You want to be sensitive to folks who are involved in this process and avoid using words that are offensive like, are you the real mom? That one doesn't go over well. Most people who are raising a child consider themselves the real mom because they're the ones up at night and cleaning up the throw up and changing diapers. So if you call somebody else the real mom, like the biological mom, that can be offensive. So you can't go wrong with biological mom, intended parent, putative father, biological father. Stick with those rather than more of the qualitative words. Now we're talking about a new set of lingo, second parent adoption. If you've got a child born to a female partner in a female-female marriage, then you've got a second parent adoption. Or you might have the male partner, male husband of someone with legal custody of a child, and so then you've got a potential second parent adoption. So understand that some of this is on its way. I haven't seen any new birth certificates since the Ogerfeld decision. Currently, the last one I looked at said mother, father. So at some point, they're going to have to change that, that form. So we'll have room for father, father, mother, mother, maybe parent number 1, parent number 2, but things will change in that regard as well. Okay, so we know Obergefell on page 3, of course, we know the Supreme Court found that it's constitutional now for same-sex marriages to be protected in all states and also recognized in a state, even if the marriage occurred, say, in Iowa, which is the case with a lot of our clients. So what we know is that the In re Luke decision should not be applicable anymore. In re Luke, just to refresh, held that only legally married couples could jointly adopt, meaning an unmarried couple, same-sex or different sex, could not jointly adopt, nor could one parent basically duplicate their rights in another parent without giving up those rights fully to the other parent. So at that point we knew step-parent adoption couldn't occur unless people were actually married. Well, now that we have full recognition of all marriages, same-sex or otherwise, everything's changed. So I'm at page 4 of our outline. So we know that under 43-101, any adult person or persons and any adult child, so Obergefell affects adult adoption as well, can be adopted by the spouse of such child's parent, except that no person having a husband or wife can adopt a minor child unless the husband or wife joins in the petition. So now the reverse is also true. If you've got a same-sex marriage, you can't have one petitioning spouse. They've both got to petition together. What we had done since the In re Luke decision is same-sex couples were able to adopt, but they were having to adopt as single parents. So when they were home studied by the licensed child placement agencies prior to placement, parent A, well, they had to decide who was going to be the legal parent first. So parent A was home studied as the adopting father, and parent B was home studied as the roommate and non-legal father. So we had to set up wills and POAs and things to give as much protection to parent B as he could have, not being the legal father. But that was always really a problem, because if legal parent A died, there was some uncertainty as to how family and friends would handle that matter and whether parent B would continue to have the same rights as he had while parent A was alive. So it left kids a little bit in limbo. So now both parent A and parent B can be home studied together as a couple, and there should be the ability to do a legal adoption for both folks. Adult adoption, 43-101. You should be getting questions about adult adoptions so that you can have, I suppose, same-sex adoptions that we did 20 years ago, and we've always had parent A be the legal dad and parent B wasn't. Parent B can now adopt the now 20-year-old as an adult under 43-101. So that's a change as well. Okay, so as you're talking to folks and they're coming into your office and saying, can we do a step-parent adoption? What are your questions? Number 1, on page 4, Roman numeral 3, assess the legal relationship between the parties. So you need to ask very thorough questions about conception. You need to get copies of marriage certificates, birth certificates, family, child, and social history that's fairly exhaustive, because you've got to assess what parental rights are out there that need to be dealt with so that you can effectuate the adoption that's being requested. Then you need to ascertain the parentage of the child. And again, you've got to ask the right questions: sperm donation, gamete donation, where did the embryo come from, where did the egg come from, who was there, who's also a possible suspect. Because maybe there was a homemade insemination attempted at or around the time there was actual sexual intercourse with somebody else. So you can't just assume it came from the sperm donation if there was active sexual activity with somebody else. So in every adoption, you need to do an affidavit. 43-104.08 has an affidavit form that the biological parent has to fill out, or the placing parent or the adopting parent, about the parentage of the child. So you've got to ascertain who are all the suspects, where are all the possible sources of sperm, and you've got to deal with the potential rights that might exist in each person. Under 43104.22, the criteria for whether someone's consent is necessary, if somebody is not actually the biological father and you have DNA that shows someone else is, that's very, very helpful, because subsection 11 of that statute says that someone's consent is not necessary if they are not indeed the actual biological father. So let's say you have a child who was born in a marriage or during a marriage, but was not the child of the husband. They had separated, gone their separate ways, just hadn't gotten around to seeing one of you guys to get a divorce, and so mom was sleeping with somebody else or had in vitro fertilization with somebody else. The married dad is still the presumed dad, but if you get DNA that this other person is the dad, it's a rebuttable presumption. Now, I get different reactions from some judges. They'll say, well, you've got a DNA, but I still want you to notice the husband. They're making it up. I don't think that's necessary, but that may happen. But I usually attach the DNA results and just say, okay, presumption rebutted, it's really this guy. And so the presumed legal father within the marriage, we don't need his consent. Sometimes we can get his consent. He's happy as a clam to give his consent. Sometimes he's difficult about it. So getting the DNA is one way to prove that. You could also get something from a clinic that says, husband wasn't anywhere near this conception. We did sperm donor number 292 sperm with donated egg and made a zygote and a gamete, which was then placed in this woman, and that's where that pregnancy came from, and therefore cannot be legal husband. So you've got to almost draw a picture sometimes about where all of this can come from and figure out whose rights, but those are some of the basic concepts: looking for the biological father, proof of the biological father, and always having to deal with anybody who was married to the womb owner at the time. So if you've got a gestational carrier who is married, you better deal with married husband of gestational carrier, because she's going on the birth certificate, she's married to somebody else, this guy doesn't have anything to do with it except that he's married to the gestational carrier, but he has legal rights that have to be dealt with. Even if you've got egg and sperm making a zygote that went into the gestational carrier, you still have the carrier's husband to deal with. So, any questions on that part? Yes, Philip.
I have a question. I also wanted to let people know I'll have a microphone up here, and if you have a question and you don't think you can be heard, just raise your hand and I'll run it over to you. My question is, the ACLU, after this ruling, has told us they've had a lot of attorneys in the state giving them feedback saying, what are you talking about? If these folks were married in Iowa in 2002, and we had one parent be parent number A who did the adoption, the child, now we're recognizing the marriage. The child was conceived of during the marriage, so the marital presumption applies, and they don't need to do anything. So I was wondering if you could address that.
You're not going to be able to get the married parent onto the birth certificate. And so that's always going to be a question. I think if you want certainty, you've got to go in and do an adoption, because at placement, whoever placed rights in parent A, whether it was gestational carrier or a young adopted or biological parents, from Colorado who did a private adoption and placed with parent A, they didn't relinquish rights to parent B, and there was no transfer of rights. There's no court order that gives that transfer, and so it would be the same as if you had a step-parent who wasn't around or wasn't legally married to the adopting parent at the time of the placement. They would not have rights without doing a step-parent adoption. So to me, it's the same. Other questions? And I tend to be very conservative. I'm not going to leave kids with a question mark about their permanency. If we need to take some extra steps to make sure that an adoption is solid and legally valid, do it. Why shortcut it? It's too doggone important to have things unravel. There have been lots of messes. Just one caution, getting someone adopted here does not solve their immigration status. You've got to, I don't do immigration stuff, that's way over my head. Involve a qualified immigration attorney in figuring out, is this person here legally? If they're adopted, what has to happen with the rest of their immigration status so that they can be either here legally on a continuing basis or better yet, a citizen? Because an adoption by a citizen doesn't make you a citizen. We've had a couple of cases that didn't get handled properly, and kids went to get Social Security cards and get jobs and go to college and were deported because nobody got them here legally. So just as an aside, take the extra steps to get it done right and properly to begin with. Okay, other questions? All right, let's head into the next section, practice pointers in dealing with the rights of biological fathers and sometimes biological mothers. What we have in Nebraska is a putative father registry. It's around the country, it's called a Notice Plus registry. Some states like Indiana have only a registry. Your notice is if you have sex with somebody and a child might be born of that union, then your notice is the fact that you had sex with somebody that you might have made a child with. And there's no additional notice required. Years ago in the late 80s, in the Shoecraft decision, our Supreme Court made it clear that that was not going to fly. Just a sex registry was not going to work. So we added in a notice provision back in 1995 that indicates that you have to give, first of all, you have to ascertain all the information possible about the potential fathers. We call them putative fathers. That just means possible or potential. You gather all that information and you have the person in the best position, usually the birth mom, sign an affidavit as to the truth and falsity of the information, who's the dad. She signs under penalty of perjury. Then you do due diligence to get notice during the pregnancy, if possible, to all the putative fathers. Sometimes you end up looking for somebody whose nickname is Ace and slept with somebody in the back seat of a car outside the Lucky Lady Lounge outside of Omaha somewhere in late October of 2014. Those are the kind of searches you do sometimes. You have to do due diligence to find folks. Judges are a lot less tolerant right now than they were 10 years ago of us saying, well, we can't find them. People are findable. If you have a name, even a birth date, an age, you can find people most of the time. So when we absolutely can't, because all we know is nickname Ace and it was a one-night stand in the back of a car somewhere, then we have to do a publication. So you either need to do actual notice by certified mail or, as a last resort, publication. When I run a publication, I put details in. If I can get permission from my client to put her name in the publication, then I do because I think it's a stronger notice. But the statute doesn't require it. You can use initials. So if your nickname is Ace and you slept with somebody with the initials C.S. on around October something 2014 in the backseat of a car outside of the Lucky Lady Lounge, you better know that the child is going to be born in that union. If she's planning to place for adoption, you've got some certain rights. That's the form of the publication. If I run one like that, I also run it for John Doe because I'm not sure that Ace is actually the guy's name. I don't know what it is, so I run John Doe as well. So we have to have those same considerations now when we're dealing with same-sex adoptions as well as we are in traditional heterosexual adoptions that we have been doing over the last number of years. You give them notice during the pregnancy, ideally. Sometimes we don't get informed about an adoption until birth mom goes to the hospital because she didn't know she was pregnant. And you're scrambling after the fact to get notice out to folks. Sometimes you're talking about an older child adoption. We'll come back to older child adoptions because they're much more complicated. And frankly, the step-parent adoptions that you all are most likely to see are some of the most complicated because you're dealing with an older child. There may be a familial relationship. There's probably been an adjudication of somebody as the father. There may be somebody on the birth certificate. So we'll come back to that as more complicated. But starting with the most simple ones, if you're dealing with a newborn, you get that notice out the door to all your putatives. Sometimes there's 5 or 6. And if you can't get them to pick up certified mail, which is common, then you call Griner and get Griner to do special process server You call them and say, hey, I've got some paperwork for you. You want to meet me somewhere? I've met people in the rest station outside of York on I-80 outside the bathroom to give people documents. I've had them sign a receipt in front of a notary so I can prove that I gave them actual service. I've had the sheriff go serve people. I've served people at work. I've had people from my office go serve people and get them to sign a receipt. Substantial compliance is the watchword. So your first course and the hopeful, successful course is to use certified mail to get that notice, but you've got to be creative sometimes, because sometimes people don't want to pick up their certified mail because they have a number of other issues going on, and so something coming from a law office, certified mail, is not of interest to them. So getting actual notice, and don't give up. If you get this certified mail returned, don't just say, oh, well, they must not live there. They probably live there. Get somebody out there and serve them. So then they have up to 5 business days after the birth, or after the last date of publication, or after actual service, whichever is later. So if you get your notice done during the pregnancy, then you have 5 business days after the birth. If they have not filed an objection within the 5 business days, or at least have it postmarked within those 5 business days, then the statutes say their rights are not recognizable thereafter. So their ability to file an objection is gone. That part of the statute has been upheld a number of times, and I still remain confident that because the birth father has theoretically 9 months and 5 days to file an objection, that will remain constitutional. There was an interpretation for a few years that people thought you had to file that objection as the birth father within the 5 days. Somewhere between birth and 5 business days, you only had that tiny little window. And that was not what the legislative history said. That was not what it was supposed to be interpreted to mean, and so it was clarified a couple of years ago to say anytime during the pregnancy or up to as late as 5 business days after the birth or after the last notice. So understanding that the more time you can give birth father, the stronger your notice is and the stronger the registry is. So don't intentionally wait until 2 weeks before the expected date of delivery and then scramble around and not be able to get service on them, have baby born, and then you're still trying to get them. Get it done in the 6th, 7th month if you can, and give them an opportunity to go through whatever they're going to go through in deciding what they want to do, whether they're going to object to the adoption or not. The objection process has 2 pieces. They have to file an objection with HHS within 5 business days after the birth or after the notice, which is ever later, and then follow up within 30 days after that filing with a lawsuit seeking paternity and custody of the child. It is in that proceeding that their rights are assessed as to whether their consent is necessary. That criteria is found in 43-104.22. So that's newborn adoptions. Let's go to the other end of the spectrum, and the one that you're going to most likely see, I'm at the bottom of page 5, you're going to most likely see folks who have been adjudicated to be dads. If someone has been adjudicated to be the dad, you've got to deal with that differently than in a newborn situation. Having said that, however, just because somebody was adjudicated to be the dad, and by adjudication I think the statutes mean a court says you're the dad. Maybe it's in the context of child support, paternity, juvenile court, guardianship. But if there's some order somewhere that says Bill Smith is the dad, you've got to deal with him as an adjudicated dad. You can't stop there, though. Just because somebody's on adjudicated dad, or just because they're on the birth certificate, that doesn't mean they're your only suspect. So you've got to still ascertain from the birth mom or somebody with information about it as to the other suspects, because you're in search of getting notice to the actual biological father. Adjudicated dads, however, require a process in section 43-104.25 of the statutes, and that involves sending the same notice that you would send the newborn putative dads. And the purpose of sending them that notice is not to trigger the 5-day filing with HHS, because that part of the statute doesn't apply to adjudicated dads. The purpose in sending them notice of the planned adoption and waiver of rights and relinquishments and consents and social history, medical history, is that about 75% of the time they can't wait to sign those documents and send them back to you. And that's the shortest distance between 2 points. And what is their follow-up question? How soon is my child support over? And you can answer that question. The answer is the month following the month in which a decree of adoption is entered. So you can tell them that, and you can tell them that you will assist with that filing so that they are relieved of future child support obligations once that adoption is done. So follow the same process, send them the same letter, send them the same notice, send them to everybody in the statute that applies. And we're always talking about kids born out of wedlock. So you look at the statute to see everybody who gets notice, guy on the birth certificate, guy she lived with, guy who's adjudicated, guy who might be the father, and you send them all notice and you deal with all of those as well. And anybody who's adjudicated, if they don't sign a consent and a relinquishment or a waiver of rights when you send it to them, then you have to go to the court which adjudicated them, and you have to file a motion for that court to make a determination as to whether their consent is necessary. And you have to serve them notice of that hearing in the same manner you would serve someone else with service of process. If they don't show up at that hearing or file an objection or do something to make some noise in that proceeding, that's a reason that the adjudicating court can find that their consent is not necessary. So it puts in the hands of the court who's most used to dealing with this dad, this baby, this couple, this relationship, in a position to determine whether or not consent is necessary or not. You have to go to that court most of the time anyway, so it's not an extra stop most of the time, because under 43104, you have to go get the consent of any court that has jurisdiction over the child anyway. So you can combine that motion. You can make a verified motion for consent to that court saying, hey, court, you have jurisdiction over this child. Will you consent to the adoption we're going to do over here in Lancaster County Court? And at that same time, you can ask the court to adjudicate whether or not the adjudicated dad's consent is necessary or not. So it's a different process, and be cautious about that. All right. Page 7, section C, familial relationships. I don't know what that means. Supreme Court uses that phrase and did not define it. I don't know what a familial relationship is. Is it living together for 2 days, 2 weeks, 2 months, 2 years? Is it 2 days of child support, 2 months of child support, 2 years of child support? I don't know. But you have to be on the lookout in your intake when you're talking to folks about all the putative fathers, past relationships, past involvement, and you have to ask enough questions to ascertain whether or not the actual biological father had a familial relationship with this child. The reason is, in the Corbin decision in 2009, the Supreme Court said if the biological father had a familial relationship with the child, then you can't hold him to filing an objection with HHS within 5 business days after the notice. It didn't say what we were supposed to do instead, and it didn't say what the criteria was for determining a familial relationship. It just said that's an exception to the statute. So what do I do if I have a familial relationship? Same thing I do if I have an Indian Child Welfare Act case. I pound my forehead and I put on my thinking cap and try to figure out how to be in compliance. I still send the notice letter to the guy with the familial relationship. I still send him consents. I still send him waivers of rights, medical history, social history. I still ask him to consent, and often they do. They haven't been adjudicated anywhere. They've never had a paternity proceeding or a guardianship proceeding or a juvenile court proceeding. So there's not an order. So they don't usually have a child support obligation, but maybe they have paid some. Sometimes they want to be involved in the process. Sometimes they deny the familial relationship. But usually if I can get a conversation going with them, I can ascertain what their position is. And if I If they won't talk to me, then I send them the notice, and I evaluate the risk of whether or not this is really a familiar relationship. Sometimes it's very clear. Okay, yeah, they lived together, and he took the child to daycare every day and stayed home with the child on the weekends while she worked and split all the bills 50-50. That's probably a familiar relationship. I got to deal with that. So giving him notice of the intended adoption, not holding him to the 5 business days, and then giving him notice again through service of process of the adoption hearing. I send him a copy of the petition without the home study attached, and I give him notice of the hearing date, and I make sure I can prove that, file my proof of service with the court. And if he doesn't show up at that hearing, I've got a much stronger argument that his rights don't have to be recognized thereafter. And I get prepared to put on evidence that, yeah, we lived together from when the child was 6 months to 15 months, and then he ran off with somebody else, and we have never heard from him since. It's been 5 years. I've got a pretty decent abandonment argument at that point, and I would plead it that way. Usually, I don't recommend pleading abandonment if you've got a clear-cut newborn baby, gave him notice well before the birth, he didn't file any objections, he didn't file in county court, he didn't do diddly squat. I don't plead abandonment then, because I've got a clear reason that his consent is not necessary under 43-104.22 because he didn't comply with the 5 business day objection or the 30-day lawsuit thereafter. So don't plead abandonment and make yourself prove something greater than that which the law requires you to prove. But in a familiar relationship guy, when I'm sure I've got familiar relationship, I'll go ahead and do the finalization, and you tell these people from the get-go that this is legal risk. We have a familiar relationship dad, we send him notice, we asked him to consent, he didn't respond, we have to send him notice of the hearing again, and until you get that decree of adoption, I don't think you should exhale, because he could still come to that hearing and seek to block that adoption. I wish I had clearer guidance for you on familiar relationship situations, but I mostly just want you to be aware that if you have one and it feels uncomfortable to you, you should feel uncomfortable, and feel free to round table it, call me, and we can kind of talk through. But until the statutes get updated to deal with that situation, we have a lack of clarity. Okay, so what do you do with a mom who's not around? Bottom of the outline, page 7, section D, married dads, married moms, abandoning moms. We've talked ad nauseum about unmarried dads, and section 43-104 and all of its subsections through .25 tell you exactly what to do with an unmarried dad. But what do you do with a married dad? They're still legally married. If he's the bio father and he's the married dad, you have a very high burden, and your only options under 43-104 really are to prove abandonment. Oh, death, put a birth certificate or a death certificate on there, that's an easy one. Something short of death is abandonment, basically. And when you've got a married dad or a married mom who's disappeared, that happens more often than you might think. You have a married dad, mom ran off, hasn't been seen for years, and married dad has divorced her and has married someone else and wants new stepmom to adopt. So it's step-parent adoption in reverse. Or it may be a same-sex marriage now that had been a heterosexual marriage at the time of the conception. We can now do those step-parent adoptions, but you've got to deal with your abandoning mom. Whether you have abandoning dad or abandoning mom, 43-104 requires you to get a guardian ad litem appointed to give substitute consent under 43-105. You're not going to get around that. You don't have to have a home study in a step-parent adoption, but you do have to have the child abuse, adult abuse registry, and the full criminal history fingerprint check. They've changed how they've done that. I think they realized maybe they were not doing that correctly, but you make the request to the State Patrol, and the State Patrol gets the fingerprints and gets the criminal history check and actually sends it to the court rather than sending it back to you as the attorney. So that's a change. In any step-parent adoption, same gender, different gender, you're going to have to go through that process. If you've got a married parent, you're going to have to go through the substitute consent process. So you file, at the same time you file your petition for adoption, you file a motion to have a guardian ad litem appointed for the limited purpose of giving substitute consent. What that person does is come in and basically tries again to find abandoning mom or abandoning dad, and does a report on the efforts to find that person, talks to the step parent, talks to the biological parent, makes sure that this adoption looks to be in the best interest of the child, and is prepared then at the hearing on the adoption to sign a consent for the adoption in lieu of or in the place of the abandoning parent. So that's the goal. Any questions on this part? Yes, go ahead. Well, you wouldn't use the 5 business day filing if you had a married parent, because, well, you probably wouldn't get to, most of the time you're not going to get to a substitute consent in regard to an unwed father, because the last line of 43-105 says it doesn't apply. But let's say you had a familiar relationship dad. You might ask for appointment of a guardian ad litem if it was a substantial relationship. I've not done that, but that's a pretty decent idea. Thanks for bringing that up. And so on an adjudicated dad, let's see, would there be a situation where you would need a substitute consent with an adjudicated dad? Because you're giving notice to him as you would service a process, you could use either actual notice or you could use published notice if you can't find him. The adjudicated statute applies to unmarried adjudicated dads. So you wouldn't necessarily need a substitute consent there unless a judge ordered you to. And they make up lots of stuff lots of times, so they might tell you to go get one and you have to, even though it's not in the statutes. Other questions? All right, I just want to tell you about some things to just make you aware. Yes. Oh, sorry, I didn't see it. I don't think that's a safe answer. The question is, what if the adjudication occurred, the divorce occurred, the paternity action occurred in Kansas, another state, and everybody's here now? The statute says you've got to get the consent of the Nebraska court. So I think in most cases you're going to need to get that case transferred to Nebraska. And I think Philip had talked about doing that earlier. And so there's, what act did you transfer it under?
There was a prior something that had a custody determination, probably registered that. Probably also want to register.
Yeah. So you could register here in Nebraska and then go to that court. I don't think you could ignore it. I don't think you should ignore it. Same is true if the child was born out of state and then is in Nebraska. The statute says to file, 43104.05 says to file in the county court where the child was born. Well, if the child was born in Kansas, there isn't a county where the child was born. So you would follow, in my opinion, the venue statutes as to appropriate venue. If you went to the county where people resided now in Nebraska and filed that objection as the birth father, I believe a court would accept that because they have venue. And you can't go to the county where the child was born because you'd have to file out of state. So you're going to have to make some adjustments based on the facts of your cases and using applicable law. Yes, question?
Whether you need the consent of the district court. If you've got an adjudicated parent but you don't have a custody order, does that make a difference?
My position has been to err on the side of caution, and I've had this conversation with a couple judges. They're saying, look, if we've made no custody visitation orders and we've just done child support, do we really have jurisdiction over that child for purposes of 43104? And my position is probably, I'm not sure, but just go ahead and do it. So, and most of the time they do, because again, we don't really have a definition, never have had a definition of, in 43104 as to what exactly they mean by jurisdiction over the child. And there the court Well, if you're only going to that court, there's not been an adjudication there, you're just going to that court to get their consent under 43104, you can usually just mail it into them with a verified motion for consent, a letter from you saying this is what's going on, we just need your consent, here's the process we're going to file in this county. They usually just send you back an order. I'd say 80% of the time I don't have to appear. The same is true on the other end. Let's say you get an adoption done and you are ending the child support obligation of the father who used to have to pay child support. Usually, I don't send a decree of adoption to a district court to get child support ended, because it takes a very confidential, non-public document and makes it public by filing it. I write to that judge and I say, hey judge, we did a step-parent adoption in Lancaster County Court last month. The date of the decree is such and such. I'm writing to ask you to end the child support obligation of so-and-so, of this father, because he's no longer the father of the child. And if you want to see a copy of the decree, I'll send it to you for an in-camera review. 90% of the time, they just send me back a signed order. The child support is over. So be cautious about filing adoption documents in a district court or guardianship proceeding, because you'll make them public. Cautionary tales, real quick. Openness. I don't know if you saw the case in Nebraska. All it really did was prove the point that bad facts make bad law. Couple A couldn't have a baby, couple B can. They say, okay, we'll have a baby for you because you're our friends. They put together probably an unhealthy adoption paradigm that was basically co-parenting, and they do the adoption. They were not separately represented by attorneys, which I always think is a mistake. And nobody told them that since the 1980s, the Supreme Court has said an adoption that is contingent on your continued rights for visitation, contact, communication, that hangs on to some of the sticks in the bundle of parental rights, is not a valid adoption. Adoption is not where you share custody of the child and you take the child to your family reunion, their family parties, and you have the child a certain number of hours a day. That's co-parenting. I don't think anyone would tell you that that's healthy, but that's what they envisioned. Well, it went south, as you might imagine, and it went up to the Supremes, and the Supremes said that's not a valid adoption, and they undid the relinquishments. So now we're in a position that you can't even really sell to people the concept of open adoption. You've got to basically tell them it's unenforceable. You can't have any promise of communication or contact, and I put some scary language now in my relinquishments that's on page 9 that makes it really clear that even if they talked about communication and contact, it's not a contingency of the adoption, it's not the basis of the relinquishment, they know it's not enforceable, they know they have no rights, they've given up all their parental rights. I say it about 27 different times in different ways, so it's clear. So be very careful in that regard, especially if you've got somebody who's an adjudicated dad or a married dad. You can't promise them continued communication and contact as a matter of right in exchange for the relinquishment.
Susan, if it's an open adoption from another state, say Iowa or wherever, where there is contact perhaps permitted and it's still, the relinquishments are still enforceable, but then the subsequent step-parent adoption is done here,
right? Is
there exposure there?
I wouldn't make any promises, because you can't carry over. Some states allow communication and contact agreements. They allow court-ordered adoption agreements that are enforceable. But if you were doing a step-parent adoption or a replacement for adoption, sometimes adoptive placements fail and we have to replace kids in subsequent families. If the adoption is occurring under Nebraska law and it's going to be finalized here, you can't make promises of openness. Just be careful on reimbursable expenses. ICWA and the Interstate Compact Act, if you have kids crossing state lines for purposes of adoption to be placed with and adopted by somebody other than their immediate family, you've triggered the Interstate Compact Act, and it's a misdemeanor not to comply. So read that last section of the outline. ICWA was just changed, new legislation in 2015, and there are some very, very broad BIA guidelines out there that have changed how you need to do notices if you do juvenile court work. You're probably already aware of this, but ICWA now has additional teeth. So if you are dealing with a child who is an enrolled tribe member eligible for enrollment, and the parent is a tribe member eligible for enrollment, as the tribe defines membership, you don't need an enrollment number. If the tribe says you are a member, I don't care if you've enrolled or not, then you've got to deal with that as an Indian child. So the presumption under the guidelines is all children are Indian children until you prove to the contrary. It's a very scary set of guidelines. Read them. They're under attack as to whether or not they're mandatory or truly guidelines. But the new ICWA legislation for Nebraska has enough teeth to worry about before you even get to the guidelines. So read it carefully and watch your reimbursable expenses. If you promise a step parent that they don't have to pay child support on a go-forward basis if they relinquish for adoption, no problem. There's a case that says it's okay to forgive arrearage, but it's an old case, and I would be very, very careful with doing that with our current court's composition. I'm not sure that they would uphold that as not being duress and coercion. If you had a dad who owed $35,000 in arrearage and you say, we'll forgive that, that's really owed to the child, by the way, not the parent, and you say, we'll forgive that in exchange for your relinquishment, I'm very concerned about how that would go, so I just don't do it. All right, any questions? Thank you very much.
Thank you, Susan. All right, we're just going to take a moment to get set up for the next presenter, John Turco, and we'll be right with you. Thank you. After Mr. Turco's presentation, we will take a brief break. Feel free, obviously, if you need to take a break now, you need to take one, but we will be taking a scheduled break right after this next presentation. John Turco seminar materials.
Well, I'll ask.
Which would you like?
Just skip.
Forget it's not touchscreen.
Yeah.
I know, I use some
We're low tech.
iPad, yeah, iPad centric. All right.
Microsoft Surface. Can I use the dual fingers or
What do you-
scroll up and down?
Yeah, you should be able to.
Well, no, if I do or if I do.
You know, I've never done that, so
Oh, really?
I usually don't.
Well,
You know what? Let me.
that's the device.
There, I just sorry.
I just want to be able to smoothly.
Thank you.
What I'm going to do here is I'm
One more thing before we get to the next speaker. We've had a lot of people walk in and register, and we have kind of a shortage of seats. We do have some available in the front, but if you have your bag or briefcase or whatever on the seat next to you, if you could put it on the floor, that'd be great, so the people who are walking in know that they have a place to sit and table space to put their materials down. Thank you. Okay, we're going to go ahead and get started as you sit down here. The next speaker is John Turco. He is the principal and owner of John Turco and Associates, which is a bankruptcy firm here in Omaha. John has been doing this for a number of years, and I think most of you who know him would consider him to be one of the foremost experts in the state on bankruptcy. He's done several presentations before, I believe, on issues at the intersection of divorce and family law and bankruptcy. As you may recall, I send out a question, I send out a request on the family law listserv to provide your questions to John, and he would try to work your questions in to his presentation today. So I believe he has several issues that he prepared himself, but I know that he also addressed those questions if you provided them. So with that, I'll introduce John.
Good morning. Well, I do consultations all day long, probably like most of you do, so I'm going to try to treat this as a bankruptcy consultation. And there's been some issues that have been popping up with bankruptcy and divorces, and it's been my contention for years and years, and I've been doing this about 26 years. That's pretty much all my firm does. We don't do divorces. We don't do child modifications. We don't do anything else but essentially Chapter 7 and Chapter 13 bankruptcy cases and individual business cases, but we stay away from those Chapter 11s. So on the listserv, Phil put out the question, what are the top questions that divorce attorneys have that they want to get answered, and that they're always, issues that are always coming up. So I literally just went through and I'm going to try to answer these questions, and it gets a little bit dicey because of the law that changed 10 years ago. And we keep on calling it the new law, but it actually occurred October 17, 2005. And that law changed substantially what happens in divorce matters with respect to bankruptcy cases. And I think that's the first question. I'm used to the touch screen, where you touch the screen and it moves, not this. Here we go. So let me see if I can go back to Windows 7. I think so. Okay, can everybody see them? I mean, I have written materials, and if you don't have written materials, I've been told by a person outside at the registration area that all of these materials are available through a hyperlink on the website. So when you get back to the office, you can get that. I also want to mention that my firm in September of 2014, we kind of put on a little mini seminar, and it was basically addressing the same issues that we're today. The dischargeability potentially of property settlements, and those materials were essentially case law and statute. So I did make a note in my materials here that if there is a link to a website, and if you link to that website when you get back to your offices, you can get all of the relevant 8th Circuit case law, the Nebraska case law that's pertaining to these issues. Okay, first question that came off the list, and this was really a can of worms question. The first question that was asked was the question that covers many of the issues. So when under a divorce decree, a spouse agrees to take responsibility for jointly held debt with the hold harmless provision, but then shortly after entry of the decree files a Chapter 7 bankruptcy, can that spouse be held collaterally responsible via a contempt action filed under the divorce case? That's one question. Let's start there with that part of the question. In 2005, the bankruptcy law changed to make it so that you cannot discharge any property settlement obligation at all if a spouse or an ex-spouse files a Chapter 7 bankruptcy case. Prior to that change, they potentially could. They would have to file what they call an adversary proceeding. The spouse that was going to get stuck with all of this debt, they would have to go to the bankruptcy court within a certain time period, and they would have to object to the dischargeability of the debt on the basis that this would be an undue hardship to the spouse that's going to get stuck with all the debt. That no longer exists. So if you see a panicked ex-divorce client come in and say that my my ex-husband or ex-wife just filed a Chapter 7 bankruptcy, and how is this going to affect the property settlement, and am I going to get stuck with all of this debt? Simple answer, no. They will not. Chapter 7 bankruptcies no longer discharge the debt. It's in the. I can quote the code for you here, but you don't have to worry about it. It's under 523A15. But there is a problem with Chapter 13. What Chapter 13 does, it does discharge a true property settlement. So you have to pay particular attention to which chapter the ex-spouse is filing. And there isn't anything, and you really got to be on your toes and file a proof of claim and potentially object to the bankruptcy plan in a very timely sense, or else your client can get burned. Now, if in fact it is a true property settlement, there's really nothing you can do. But as probably most of you know, sometimes there's a hybrid. Sometimes these so-called property settlements are, quote, in the nature of support. And if a property settlement takes on, let's say, for example, the case of the spouse that makes very little income, and the ex-husband, let's just say for this example, the ex-husband takes on the responsibility of paying all the credit card bills, takes on all the responsibility of taking the other debts that were pursuant to the marriage, and then soon thereafter, and let's say that the divorce decree simply says, as a property settlement, the husband here has to pay all these bills and hold her harmless. And then he subsequently files a Chapter 13 bankruptcy. She can be in trouble. I mean, he can discharge those debts. However, whether or not a property settlement obligation is in the nature of a true property settlement, or whether it's really kind of a cloaked support obligation, is up to the exclusive jurisdiction of the bankruptcy court and of the bankruptcy judge. It doesn't matter necessarily what your decree says. Your decree might be silent as to whether or not it's a support obligation or a non-support obligation. I'm getting a little bit behind here on the. Let's see here. What the bankruptcy courts have ruled, and this has gone all the way up to the 8th Circuit Bankruptcy Appellate Panel, what they're saying is that if the spouse that is going to now acquire all of this debt because the other one filed bankruptcy, to decide whether or not that debt is in the nature of support or whether that debt is a true property settlement, they're going to look at 5 factors. And this is a pretty recent case. It's in Ray Fagley. Again, all this material can be linked off my website. In Ray Fagley set forth 5 things that the bankruptcy court, with its exclusive jurisdiction, could look at. It said it was going to look at the language and substance of the agreement of the in the context of surrounding circumstances, using extrinsic evidence if necessary. It's going to look at the respective employment histories of and prospects of financial support. It's going to look at the fact that one party or another receives how much marital property they received, the periodic nature of the payments, and whether it would be difficult for the former spouse and children to subsist without those payments. So essentially, it's going to be a totality of the circumstances. The bankruptcy court is going to look at the totality of the circumstances. However, again, what's important here is that if the spouse that's going to get stuck with the debt doesn't object to the plan and doesn't file a priority claim in the bankruptcy proceeding, they could, if they don't object timely, they could get stuck with this debt, and this debt, this property settlement, even if it's in the nature of support, is probably going to get wiped out. And it's a very short time period. That's at the very bottom there, where I underline, and finally and very importantly, the ex-spouse needs to be on alert and must timely object to the Chapter 13 plan. If you believe your client has a property settlement that is in the nature of support, you have to file an objection to the plan and file a claim in the bankruptcy and check the box that says priority debt. Now, if you have to do that in good faith. If it truly is just a property settlement and it's not in the nature of support, we had a case in the last 12 months in Ray Sutton. It was a local case, Judge Saladino ruling. We represented the ex-husband, and it was the debtor, our client, had paid his child support for 20 years. He had paid every dime of it. Occasionally, he paid on the property settlement obligation, I think it was like $60,000. He had side deals with his ex-wife. He paid for a child's car, for example. And none of this is written down. This is all verbal. So he's getting a lease payment, making a car payment for one of their children. He's paying all of his child support, but he's not paying any of this property settlement obligation to her. She files an objection to his bankruptcy and says, hey, this is in the nature of support. And I want my $60,000. Oh, by the way, it's now $130,000 because he hasn't paid me in 20 years. So we had a trial on that, and the outcome was it's dischargeable. It's a property settlement. In that particular case, the ex-wife was very, she had plenty of wealth. It was clear that she did not need it for her basic subsistence. It had been over a 20-year period, and so again, using the In re Fagley analysis, the court went through all the steps and ruled against her. And so we have a ruling locally that occurred within the last 12 months based exactly on the 8th Circuit ruling. Up to the question, I think I might have missed. Is there a way of getting around the protection provided by the Fresh Start provision and the federal preemption argument? It is my understanding that the federal circuit courts have come around on this issue, acknowledging that the Fresh Start provision and the federal preemption argument was being abused in divorce matters. And I think my answer would be maybe. If you're going to be abusive, and if you're going to go through a divorce proceeding, and then as soon as the decree becomes final, the next day you file bankruptcy, I think that's a good faith issue. You have multiple tools available to you to cause trouble in a bankruptcy. I hate to reveal this information, probably see a lot of it now, but it's not just the statute that says whether the property settlement is discharged or not. If you're acting in bad faith, and if you file a bankruptcy like the day after the divorce decree is entered, and it causes a lot of harm to the other spouse, I think I would just make an object to the Chapter 13 plan, maybe just on the simple basis that this is in bad faith. The debtor does not come to this proceeding with clean hands. This was a setup. And so you could object to the confirmation of the plan based on that. You could even argue potentially that it was fraud, that this was a fraudulent type of a situation, and the person who took all the debt never had any intention of paying for any of it. I'm sure you've never seen that before. They agree to take it, but then they don't pay it. Now, I think it's one thing to make the argument that they're not paying it because they just don't want to pay it. I think it's another situation where they've been ordered to pay a property settlement, they've been ordered to pay the credit card bills, but frankly, they just can't do it. They don't make enough money. So it's not like they're trying to act in bad faith. They just don't have the money to pay the bills. So what are they supposed to do other than file bankruptcy? That would be the counter argument. So I think you do have some other tools there. I think good faith always applies. You could always object to the plan. You could file a motion to dismiss. You could bring in evidence during the divorce proceeding that showed that that this is what the ex-spouse was going to pay, and he agreed to pay it, and he had the means to pay it, and now he just doesn't want to pay it. So I think some of the state courts, I read a case recently, I think it was a Nebraska Supreme Court case, and it was kind of funny because they were applying the old pre-2005 law in this case that was ruled upon in 2001, and I'm sorry I don't have a cite for it, but in that case, Nebraska Supreme Court case, it was a 2010 case. This is way after the law had changed, and they're still citing the old bankruptcy law where the spouse has to come in and timely object to the bankruptcy, and that was no longer the case. It was a Chapter 7 proceeding. So this case went all the way up to the Nebraska Supreme Court, and they're fighting over whether it's wiped out or not. And they go through this whole analysis about, you could have objected and you didn't object, and so you waived your rights. And I'm reading this, and I'm like, when was this case filed? And it was like, it was under the new law, not the old law. It's like, this is, somebody didn't do their research. The law changed. They're fighting over nothing, which was kind of funny, I thought. So keep in mind that when you go into a bankruptcy, you're supposed to go into a bankruptcy in good faith. When I'm talking about both bankruptcies, but in this case, Chapter 13, is the debtor truly turning over all of their disposable income to the Chapter 13 trustee for distribution to the creditors? It's not like they're just going to get away with it and get away with not having to pay anything back. We have probably one of the most professionally run Chapter 13 offices in the country. They're all over everything. They object to everything. And if I know I see Mark Bertolini here. If anybody's done any bankruptcy work, Chapter 13 work, they are all over you. So nobody's getting it. It's being highly monitored. But the advantage of being determined, and I'm kind of skipping all over the place, but the advantage of being determined to be a priority creditor and having your property settlement be determined to be in the nature of support is that priority debts have to be paid in full through the bankruptcy plan. Unsecured, pure property settlement debts are just general unsecured creditors. They might get 1%, they might get 2%, they might get 100%, but they don't have to get paid as long as the debtor is making his best effort. So there's a huge benefit to having the court rule that your claim is a debt that's in the nature of support. Any questions so far?
Yeah, I was wondering, a lot of times property equalization settlements are produced like judgment and versus
Right.
going it, they have to have some automatic lien against a real estate bill in that county, personal property. So is that, you think,
So by changing, I think what you're saying is if we have a property settlement and reduce it to a judgment, does it change the nature of the debt so we get away from this? Well, if you reduce it to a judgment and they go into a 13, you mean if it's in the nature of support and then they go into just a judgment? Okay. Correct. I believe under Nebraska law, you cannot use your homestead exemption to avoid a property settlement. Does anybody have any separate knowledge on that? You cannot use, normally if you have a judgment creditor, let's say you have a medical bill and they get a judgment against you for $20,000 and then they transcribe the judgment to district court, creating a lien on all property you have in that county where they transcribe the judgment. If it's your homestead, you can file bankruptcy 7 or 13 and you can file a motion to avoid the lien and strip that lien off the property so it's gone. However, that is not, and so I tried that once. I had a spouse that had a judgment lien against the property. I thought, well, that's a judgment lien. Let's just try to strip it. It's her homestead. Doesn't work. That you can't strip a lien against your homestead if that lien is the result of a divorce decree. See, I knew that. I knew it was there. Yeah, keeping up with the sections of the bankruptcy code are hard enough, but I know, and thank you for that cite, but you can't strip off a property settlement or a lien against a personal residence. But you can against regular creditors. That's something to keep in mind. Okay. Any other questions before we dig in deeper? So you got to be careful. Well, let's talk for a second about let's talk about prevention of trouble. So when you're representing a client in a divorce proceeding and you're working on their decree and you are aware of these issues now, I mean, you're aware that, hey, this other spouse here, they could file bankruptcy and wipe out the property settlement. So what do we do? What kind of wording can we put in that decree to make it so that they can't discharge this? Bear in mind that it doesn't matter what that decree says ultimately, because the federal bankruptcy court judge has exclusive jurisdiction to determine that issue. However, lay foundation. Now, I know that sounds easy, but the other lawyer is not going to want you to lay any foundation in that divorce decree to help you or help the other client avoid a wiping out of a property settlement in a divorce decree. But if you think that a property settlement, like you're ordering, you want that decree to order the other spouse, husband or wife, to pay those bills, and you want to make sure that he can't go into bankruptcy, Chapter 13, and wipe them out, then I think you need to lay some foundation in your decree, spell it out. Why is this in the nature of support? Go through the Fagley case. Use the criteria there. I'm like, okay, it says here the language and substance of, okay, so the language and substance of this agreement in the context of surrounding circumstances. Well, mention it that the parties are contemplating this and they're contemplating it as in the nature of support. Put a sentence in there saying, based on the employment histories of the parties, this spouse couldn't afford it, this one can. So really just lay some foundation in your decree so that when the bankruptcy court judge, when the decree gets offered into evidence at the trial of whether this is a true property settlement or really in the nature of support, he gets to read that, and you're going to really help him out in terms of.
John, if you put language in there, if there was a downward deviation to child support, and you mentioned that you said the responsibility to pay this debt was partially decided in consideration of the downward deviation in child support, would that be pretty solid?
Well, that would help. I mean, because then you're saying that it is truly in the nature of support, and in fact, it's of the same nature as child support. And I guess, I don't know how to write these decrees, but we're keeping the child support on the lower side so that the other spouse can pay these debts to protect the ex-wife or the ex-husband. And yeah, put as much foundation as you can into the decree. It really helps the bankruptcy court judge, and then he can make his decision. On the other hand, while attempting, don't be insincere. If it's really not in the nature of support, don't say it is, because that's when you're going to get, either it is or it isn't. And I always advise, I said, well, I don't know, maybe both spouses need to file bankruptcy, then we can stop fighting about who owes what. I mean, and that's another practical thing that you take a look at. Okay. Any more questions on question one, which I think question one is probably the most important question, and it has a lot of entanglement. But moving on, and we can come back to it. But question two, what suggestions do you have as to strategy when one or both parties in a divorce are considering filing a Chapter 13 bankruptcy? If there is a 5-year payment plan, which one or both parties may be obligated to pay, and how does one spouse protect themselves from the possibility of the other not making the required payment, which would lead to a rescission of the Chapter 13? Never, 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 never put a couple that are going to get a divorce into a joint Chapter 13. Don't ever do that. It costs, even with the additional attorney fees, it's just a bad idea. It's like they're getting divorced, and then you want to create a new contract, a financial contract for them, and the potential for one party not to pay and the other to pay, even if innocently done. Even if, what if they lose their job, or what if they become disabled? Well, then the other party, the bankruptcy court and the bankruptcy trustee, they don't care where the money comes from. They really don't care. If the payment's not there, the case is going to get dismissed. So, with that in mind, if the parties do get along and they sign a waiver, file 2 separate Chapter 13s. And sometimes we do that. Sometimes we say, okay, you file your Chapter 13, whether you succeed or fail is on you, whether you succeed or fail is on you. Sometimes, however, you have to realize that there are certain debts that have to be paid back. Let's say there's a $25,000 or $50,000 IRS priority tax debt, and the parties are ordered to pay it. And it doesn't matter what the decree says. Even if the decree says, well, husband pays it and the wife doesn't have to, and then they both file bankruptcy care, they're going to go after her. They don't care what that decree says. So you kind of have to have that mature discussion with your prospective future clients. It's like, look, if he fails in his case, you're going to end up paying the entire priority tax debt. That's just what's going to happen. So sometimes the clients are fine with that, and sometimes they're not, and it doesn't matter if they have the same law firm or different law firms, and if they're both in a Chapter 13, you do not get a discharge in Chapter 13 if your priority debts are not paid. Priority debts are tax debts incurred within the last 3 years, child support, alimony, and the ubiquitous in the nature of support claim. So again, that can be a huge problem, but for sure don't file a joint case. Sometimes, and this is pretty common, we have a couple that come in and they're in agreement that they both need to file bankruptcy. Let's say that he's making $25,000 a year and she's making $75,000 a year. Well, the one that's making $25,000 a year should be in a Chapter 7. Doesn't make enough money. The one that's making $75,000 a year, they probably make too much money and they have to go to a Chapter 13. But it's interesting because the one that's making $75,000 a year, if he ends up paying, or if they end up paying alimony or more support, that reduces their income. So you can kind of play with the, well, how do I explain this? I get people that come in and says, well, I don't want to pay this alimony, I don't want to pay this child support. I'm saying, well, look, you can either pay it to her or you can pay it to your creditors in a Chapter 13 plan. It doesn't make any difference because you get to deduct off of your disposable income what you're paying in a priority settlement or what you're paying in a priority debt. So why hurt that person? Give them, I mean, if you're going to get hit with the support and you're fighting over how much, who cares? I mean, why not help the ex-spouse and help the kids and put money into the family household and pay less money to your general unsecured creditors? Let's see here. So, yeah, we talked about the one person can do the Chapter 7. One person can do a Chapter 13. Maybe you have one spouse that doesn't file bankruptcy and the other one that does. There's all different kinds of strategies, good faith strategies, that could help one party or the other. If you can get them into let's say that they're just underwater, they're doomed, and they come in and they're all upset with each other, and he went out gambling and she did this and that and the other. I saw that last night. It's like, why don't you just file bankruptcy and be done with it? I know you're going to get a divorce anyway, but at least as to this issue, let's get rid of the debt. Let's just get rid of the debt, and then you're going to have some tax debt, and then you can pay. Then you guys can work out the tax debt. Let's reduce the problems that we have. Any questions on question number 2? The other ones get easier. Are there any differences, this is question number 3, are there any differences in seeking property settlement approval from a bankruptcy court between a 7 and a 13? No, not really. There's a couple things to remember. A Chapter 7 is pretty short in duration. It's 3.5 months, assuming nobody objects and nobody gets hurt. But a typical case, you file the case, there's an automatic stay that goes into effect. 3.5 months later, a discharge order is entered. There is no automatic stay. The divorce court, the state court, can go ahead and enter the divorce decree. Chapter 13, where they go 3 to 5 years, and let's say during that period the couple decide that they're going to get divorced, then at that point in time you need to seek court approval to proceed with the divorce, or to have the divorce court enter a decree. There's a copy in the materials of it's a typical order that the court issues. Now the parties can just stipulate to it if they both agree, let's just get relief from the automatic stay so that we can get divorced. If one party wants to be difficult, non-cooperative, either side can file a motion for relief from the automatic stay. There is no court cost with that. Normally it's $175 court cost, but Judge Mahoney, the former bankruptcy judge, thought that was unfair, so he waived it. So you can simply file a motion for relief from the automatic stay, and there's not even a hearing. It just like summarily gets approved. It's very simple. But that has to be done, otherwise the state court can't enter its final decree. I seem to get a lot of divorce attorney calling me on that issue when they're in the middle of a bankruptcy and they once a bankruptcy is filed, let's say that you're going in for your final hearing and you're going to have the decree signed next week, and then if one of the parties files bankruptcy, you can't do it. You can't get your decree entered. And so again, it's not really a big issue. It's just more of a procedural issue. Now, there's a limitation on what the state court can do. The state court judge, divorce court judge, cannot assign. He can determine, property rights. Who owns this asset? Who owns this car? How much equity in this house belongs to the wife? How much belongs to the husband? Only a state court will determine property rights. A bankruptcy court does not decide who owns what. That's the exclusive jurisdiction of state court. So sometimes that's necessary. It really gets messy. Let's say that there's a divorce that's filed and there's a lot of equity in the marital assets. So one of the parties files bankruptcy. And so the trustee, Chapter 7 trustee, he's getting all excited because he sees that there's a lot of equity sitting in the marital assets and he wants them. And you don't have enough exemptions. But really he can't do anything until there's a ruling from the state court as to whether that's the debtor's property or whether that's the non-debtor's property, which is kind of interesting. So maybe that paid off Mercedes is ruled to be and determined to be under state law to be that of the non-debtor spouse. So he can't get it. So those are some interesting things. Another thing to bear in mind is that if there is going to be a division of property and let's say a huge chunk of the assets in the marital estate is a 401k, but that one of the parties needs to file bankruptcy, I would advise that the person who plans on filing bankruptcy seek out ownership of that 401k. And don't try to go for the assets that's not protected, because when they file, so give the non-exempt assets to the party that's not going to file bankruptcy, and then the exempt assets, you kind of say, okay, that's how we're going to split it up, and then that person files bankruptcy. Well, that's an exempt asset. It's a 401k. It's an IRA. It's a 529 plan. So that's something to contemplate when you think one of the parties is going to file bankruptcy. You might be able to persuade them logically that it's to their benefit to take certain assets that they may not think they want, but really they do want them. Any questions on that? Okay. The last question is a very good practical question, but there's not a whole lot you can do about it. What do divorce practitioners need to know about the preference period so as to prevent the trustee of the bankruptcy court from disgorging their attorney fee? Well, the general rule is that if you pay the debtor within 90 days of filing bankruptcy, if you pay a pre-existing debt, an antecedent debt, to a creditor, including your divorce attorney, more than $600 or more, then the bankruptcy trustee can send a letter to the attorney that got the money for a pre-existing debt and demand it back. All of it. So you say, hey, you owe me $20,000, you owe me $10,000. I see that you got $10,000 in your bank account. Why don't you pay me? And that might be okay, but for God's sake, have him wait 91 days before he files bankruptcy. I mean, there's nothing wrong with a debtor paying a legitimate debt, but wait 91 days. And if you're going to pay a relative a legitimate debt, not a bogus debt, a legitimate debt, you got to wait a year. And it's not just the one-time payment, it's a cumulative. So if they pay you $200 month one, $200 month two, $200 month three, well, boom, you've hit $600 within 90 days. That triggers the preference. So knowing that, first obvious answer is wait more than 90 days. Get a retainer in advance, because the preference only applies to antecedent debt, pre-existing debt. You know, so if you're billing contemporaneously against a retainer, it's not an antecedent debt. Have mom or dad or somebody that loves them pay the bill, and then they can settle up with them later. And I tell this to people, and they sometimes really screw it up. So I say, go have your dad or mom or cousin or somebody that cares about you pay your attorney fee. And then the relative says, okay, and they give the money to the debtor. The debtor puts it in their bank account and then pays the attorney. That blows it up. You have to have the third party pay directly to the attorney. That's no problem, because that was never the debtor's asset. Quite frequently, but not always, I meet with clients that really, really like their divorce attorneys and they want to pay them. And they said, I don't want to burn my attorney. They've been very good to me. I'm going to pay them no matter what. I'm going to pay them even if I file bankruptcy. And that's not such a hard problem in a Chapter 7, because you can do whatever you want. You can voluntarily pay any debt in a Chapter 7 after discharge. It doesn't matter. So a lot of attorneys, I'll say, hey, if you trust the person, however so far that goes, and if they could pay you if they wanted to after the bankruptcy, or you could refuse to do any future services for them, or I don't know, maybe your rate like goes up really high after the bankruptcy. I don't know, but that's an option. Chapter 13 is more problematic because you cannot pay unsecured creditors. You can't discriminate. So why should my divorce lawyer get paid, but MasterCard and Visa doesn't get paid? How come they get it? But you know, so you're going to get an objection from the trustee, and so that becomes more problematic. That's kind of where I really like the third-party family stepping in and say, would you pay this, and then after my bankruptcy's over with, I'll pay you back. I mean, but there are, as you know, there are so many people out there that they couldn't borrow $1 from anybody on the face of the earth. I mean, they've used up every benefit they ever had. But there are some people that can do it. You know, another concept is file the Chapter 13 then file a motion to borrow from a 401k do a 401k loan and say I'm still in the middle of my litigation with my divorce, and my attorney requires this retainer, and he requires and it's an exempt asset anyway. That's another possibility. Number 6, I mean, just ask them if they would just pay it. They may or may not. It's an incentive to future services. I don't know what percentage of question. After discharge. Well, no, actually, I take that back. After the case is filed, assuming it's like from wages that you're earning post-petition, or assuming that you take it out of a 401k, I mean, you can't. I mean, if the asset belongs to the trustee, you can't take the trustee's asset. But wages earned the day after you file bankruptcy that's your money. That's not property of the estate. It'll get discharged, you know. And same thing with attorney fees. I mean, if I can have somebody say, well, I promised to pay you, and here's my promissory note, and my promissory note gets wiped out too. You can ask them to reaffirm, but that's kind of, from a bankruptcy attorney standpoint, kind of taboo. I mean, to have, for a couple reasons. One, in order to qualify for a Chapter 7, you have to convince the United States trustee that you're broke, that you don't have you don't even have $100 a month in disposable income to pay your unsecured creditors. So at the same time, all of a sudden you're filing a reaffirmation agreement to pay your attorney fees for services previously rendered. So it's like, well, how come you can do that but you can't pay anybody else? And then we get worried that, you know, like we get a client that really likes their bankruptcy or their divorce attorney, and then they reaffirm a big debt, and the next day they don't like him anymore. And it's like, well, and then we have to sign off on it, and we have to, as an attorney, bankruptcy attorney, we have to sign off saying that we think this is a good idea, and we think that this is not an undue hardship on the debtor, and we have to file that with our signature. It's like, well, I don't really want to do that. I mean, so, but yes, you can use post-petition assets, but you got to make sure they're truly not assets that belong to the trustee. Like if there was money in the bank account pre-petition, even if it's exempt, you still kind of want to wait till after the bankruptcy hearing until the trustees had an opportunity to take a look at it before they pay you. Other questions? In a 7? Nope. Because all Chapter 7s, property settlement, child support, alimony, now they might be dischargeable as to the attorney, him or herself, but as to the spouse, I mean, that's a good question. I mean, can you? I mean, you're not the spouse. You're the attorney, but the obligation to pay that debt per the divorce decree is still in force. So I guess you could file a motion. I don't know, motion for contempt, motion to compel payment of attorney fees, and then go in there and say that this decree is still in full force and effect. This was a Chapter 7 case. Nothing got wiped out. And then I don't think it affects it. So, and then even in the 13, it comes back to the old, is it in the nature of support, or is it just a debt that was ordered to be paid? I mean, if it's a $20,000 attorney fee and your client is making $15 an hour, you know, and again, there's wording in the decree, and it kind of suggests that that payment of that attorney fee was not just a property settlement. That was clearly necessary. Now, I could argue the opposite. Let's say she got a whole lot of equity. She got a whole chunk of equity, and so she could pay that attorney fee. So really, that was just a balancing of just an equalization of property. Okay, so I'm going to repeat the question. So this, as I understand it, this is a court order that Adam Astley is to get paid by the other side. Well, doesn't that get merged into the decree? I mean, is it just a separate order forever and ever, or is it just... Okay. Okay. I think Adam could use his client. I think you could accomplish the collection of the debt via, I mean, because ostensibly, doesn't your client, Adam, still owe you? So it's, but you're the one that's, so the order is to pay your client, not to pay you. Yeah, then for sure she could nail him. It's the client's money, and I think your client, if you're the divorce attorney, I don't care if there's an order saying that Mickey Mouse has got to pay it. Your client still owes you. There just happens to be an order that says somebody else has got to pay it. So if that's the way I would look at it, is that I'm owed a debt in a Chapter 7. I don't think you do, because property settlements are just non-dischargeable, period. Whatever that decree says, the decree says. It doesn't matter in a 7. I can do some follow-up research for you, though. There's so many issues. But yeah, I don't think you ever have to file an adversary proceeding to determine, to object to the dischargeability of a property settlement in a Chapter 7 because of the 2005 update law. We can expand beyond these questions too. Any other interesting twists and turns in your practices? Anecdotally, I believe that, you know, people say that medical bills are the #1 cause of filing bankruptcy. I don't believe that. I think, and I'm positive that 50% at least of bankruptcies are triggered by a divorce. And it may be a delayed reaction. It may be a 10-year delayed reaction or a 5-year delayed reaction. But, you know, ultimately, I think that is what is a huge trigger point for bankruptcy filings is what's going on in the divorce world.
John, could you possibly just go over the major assets that constitute exemptions that you can squeeze into a property settlement agreement that will get past the scrutiny of the trustee when you're trying to get the property settlements, and maybe if there's any creative but ethical ways you can get your client who perhaps is the non-filing spouse, get them as much property settlement as possible. So I guess it's a two-part question.
Well, if it's going to be, the real question is that is it truly a property settlement? Or is it truly a debt that's in the nature of support? And this is assuming that a party, one of the parties decides to file Chapter 13. So I think, as I previously was kind of discussing, the more foundational information following the 8th Circuit BAP, the more factors that they're looking at to determine that, the more information that you can provide to the divorce judge to look at. I think that is the key. But I would think that sharp and astute divorce lawyers that are representing the party that they think is going to file bankruptcy, they're going to be averse to wanting too much of that language in the decree.
Could you just briefly go over the major assets that are exemptions under the code that almost necessarily can be included in the property settlement, such as
you mean
retirement accounts and homestead equity?
Oh, okay, sure.
Thank you.
In Nebraska, depends on your state, in Nebraska, and there's been some recent changes in the homestead exemption statute, $60,000 is automatically exempt against non-spousal creditors. So we're talking just regular judgment creditors, and this is in your personal residence. So little tip here, don't move out of your house until you file bankruptcy, because when you move out of your house, it's not your homestead anymore. You know, I see people do that. They move out and then they got equity in their house, and it's like, well, I can't claim a homestead exemption because it's not your homestead anymore. So, you know, it's like, you know, timing's everything. So you can protect up to $60,000 if you have judgment liens against the property from creditors. Whether 7 or 13, you can file a motion to avoid the lien to the extent of $60,000. Another strategy that we look at is, what if let's say you have like $120,000 of equity in a house, but one spouse really isn't that deep into debt, but the other spouse is, and they're not getting divorced or anything, or maybe they are, but half of that equity is presumptuous, is hers. So we say, okay, there's $120,000 of equity in the house, but only one party is filing, and that equity equals 60 grand, so we claim the whole thing exempt. His half is 60. She gets her half of 60, but she's not in bankruptcy. Those are things to contemplate. Another change in the exemption laws, it used to be that you had to be the head of the household, and if you were a single person that was never married and didn't have kids in the house, you couldn't get your homestead exemption. So it was very restrictive. So single people could never protect a dime, and now that's all changed. Anybody can now get a homestead exemption for the house that they live in, up to $60,000. Other exemptions that are available, and they've been very much restricted as of the 2005 law, 401ks are just golden. They're just solid, as long as you don't stuff a whole lot of money into them, you know, kind of deliberately at the last minute. Just build it up over time. Nobody can touch them, except there's one creditor that can grab all the money out of your 401k. Well, it could be a court order from the court saying that they have to transfer, but there's also an outside creditor that can garnish and take all your money out of your 401k. IRS. They can take the whole thing. Did you have a question? I will. No problem with, yeah, I get your question. So let's say that one spouse, I think the gist of your question is if a spouse gets via a quadro a whole bunch of money and it's put into an IRA or a 401k or there's a split, that's not a problem. That's not anything that's going to be questioned. That's going to be totally protected for the recipient of those funds because it becomes her property as if it was always her property. She just didn't fund it. It was determined to be her property. Mm-hmm. Well, yeah, so the question again is, does the trustee take a look at the historical information of the loading of the 401k? Well, first and foremost, I mean, you can only put in so much money per year anyway. So if you're taking advantage of what the law says you can put in, then I would argue, well, that's what the law says you can put in. It's not like you can stuff $100,000 into a 401k. You know, the maximum is like, you know, what, $18,000, and if you know, very few people are doing that. I mean, I rarely see that, although I will say once, in a 13, you can deduct what you contribute to your 401k and you can minus that off your disposable income. So let's say that you're paying $500 a month into a 401k, then that means that you have $500, you can lower your bankruptcy payment by $500 per month. So I always feel kind of, you know, like pigs get fat, hogs get slaughtered, as Professor Volkmer at Creighton used to say. You know, if somebody's maybe in their 40s or 50s and they're not contributing anything, I wouldn't really have a hesitation to tell them to, hey, maybe you should start contributing to your 401k and then file Chapter 13. Generally, yes. KEO's protected. For 403B, IRA is interesting because there's two levels of protection. There's the Nebraska statute that's weaker, but under the 2005 law, they said the whole thing is protected. So your IRA is going to be protected, but if you stuff money into it, there's a look-back period. I think there's a 2-year look-back period on how much money, and also whole life insurance and annuities, there's a 3-year look-back. So like if you're overfunding a permanent life insurance policy to build up cash value, they look, any premiums that you pay into that permanent life insurance policy, they can take back the last 3 years worth of contributions. Because in Nebraska, you can protect up to $100,000 in a whole life or any kind of a permanent life insurance policy, which is not a bad, and in some states, it's unlimited.
John, can you be creative with the property settlement? Say that your example of the homestead where you have $120,000 of equity and you're trying to avoid the cost of drafting quadros. So in lieu of husband's interest in wife's 401k, you're going to give $120,000 of equity, with half of that equity being representative of
to the non-debtor spouse. So the non-debtor spouse is going to get the whole 120, and then he's going to get the 401. I like that.
That would pass muster with the trustee.
Well, I never guarantee anything, but that seems, again, who decides property rights? State law. And I worry about everything. I worry about big little things all the time. I'm a worrier. So we had a case where, and it was a very unusual case. It was a $500,000 tax refund. And it appeared very apparent that the husband was going to need to file bankruptcy. And it was really his business that generated the $500,000 tax refund. But creatively, they split that. So she got $250 and he got $250. Now, thankfully, we still haven't had to file bankruptcy because I avoid filing bankruptcy at all cost, just because simply the passage of time tends to sometimes resolve things, sometimes allow other options to appear. So I'm pretty conservative about that, and I feel I'm very careful about getting too aggressive. But that in particular, though, one gets the 401k and the other one gets all the equity. I think that's brilliant. But I've actually had conversations with consultations that come in, and they don't want to do that. They want their piece of the house. I said, you're not getting this. Other questions? Yeah.
I have a basic question, but when couples come in to me and they tell me that they're going to get a divorce and they're contemplating bankruptcy, I usually say go see Dr. Bill.
Well, thank you very much.
But is it really better for the couple usually to deal with those kind of things before divorce or wait?
I would think if they're both on the same page, number one, as to the financial issues. I mean, they might not be on the same page on child custody. They may not be on the same page on all kinds of stuff. But as to getting rid of this debt, they may be able to file bankruptcy jointly or individually and deal with that issue, which then I think makes the whole divorce process a whole lot easier. And I'm telling people that I'm consulting with that, well, this no good husband of mine, he's going to file bankruptcy and so on and so forth. I said, you know what, that's a good thing. Now he'll have more money to pay you because he won't have to pay all these debts. He's going to free up income to pay you. But I would say that it doesn't hurt to have a conversation, a consultation, and just to try to, I mean, every case is so unique. It depends on whether they have tax debt. It depends on whether they have a lot of equity. It depends on their income disparity, those kinds of issues. But if they're mature and you try to have a conversation with them, I think it's at least worthy of a discussion or a consultation to kind of lay out the options before. And I'd probably even file bankruptcy in that case if they're on the same page. Just file it. That's one less thing you have to deal with in the divorce. Or I even see it in some cases. The parties in the decrees, the parties will both file divorce or both file bankruptcy. I kind of like that. If anybody has any questions, my email is in my materials. If you want, again, I've already said this, but there's a lot of case law, Nebraska bankruptcy case law that we presented in our prior seminar. And that's all, it's a hot link off of our website. And if you ever have any questions, don't hesitate just to shoot me an email. Be happy to, give me a call. Be happy to help. Thank you.
All right, we're going to be having a break, but before we do, I just wanted to mention a few things. First of all, for all family law section members, there's going to be a free 1-hour webinar that's worth 1 CLE credit. I'm not sure of the exact time of day, but it will be on September 3rd. It will be on the various legal effects and issues that are arising out of the Obergefell case and marriage equality. And I believe that's going to be at least partial of the webinar instructor, at least in part, is going to be Marcia Fangmeyer. Again, that's going to be on September 3rd. It's free to all dues family law section paying members. So take advantage of that. It's 1 credit. If you're missing the credit, it sounds like an interesting webinar. Again, I wanted to mention we're about to have Mark Weber, so we're entering that phase of you're all going to get passed out a clicker after this break, and we're going to see how many of us would be sanctioned by Mark Weber and potentially disbarred, what have you. So after that's done, just please leave your clickers on the table as we head to lunch. We'll pick those up. We have 150. I think we're going to have, if someone steps out, I think we're going to have some extra clickers in the back. And again, just before we go to lunch, Liz Neely, the executive director of the Bar Association, is going to come up and talk to us about updates with regard to your benefits and other fun matters. So thank you. Have fun on your break. All right, if everyone could start grabbing a seat, we're going to start here in just a few minutes. Thank you. All right, well, before we get started, I just wanted to give a little bit of a teaser for Steve Floodman's case law review this afternoon. He just told me, and I read a little bit of it, that a case just got decided by the Supremes today, which some of you may be interested, some of the law nerds in the house. But it's called Counsel, and it's probably a decision that's a long time coming, having to do with retirement accounts and premarital portions. That was a big ruling, so that's your teaser. The next speaker here is Mark A. Weber, who is the newly minted counsel for discipline for the Nebraska Supreme Court. When Mark was a private practitioner, he worked at Wallenstein O'Toole as well as Carlson Burnett. His practice focused in the area of criminal defense and civil plaintiffs work. And he's going to go over the summary of advisory opinions affecting family law area, because this is an area where we see a lot of claims filed against family law attorneys relative to other areas of law. As I mentioned, please raise your hand, by the way, if you don't have a clicker for the Turning Point software. We have a few folks in the back of the room from the bar. If you hold up your hand, they can hand out the clicker if you don't have it. And with that, I'll hand it off to Mark.
Good morning. Thanks for having me here. It's a nice crowd. I wanted to touch on a few things that are pertinent to your area of practice. I did a lot of criminal defense, and second only to your folks' area is the highest area of complaints out there. No big surprise. Part of what I want to try to convey to you folks today is, look, I did what you did for over 25, almost 30 years. I get it. I understand the pressures of the day-to-day practice. I'm sympathetic to your cause. As I've said before, and I can say it from practical experience, if you haven't gotten a letter from my office, then you're not trying. So please, please just hear me out on some of these issues. Some of them, really are pertinent to what you folks do, and we'll cover some of these with some questions. I've been at this just shy of a year. I think I've been on the job 43 weeks, and I think this is speaking engagement 56. The justices wanted me to get out and about, and I've tried to do that, especially out in greater Nebraska, where maybe we didn't get out as much as we should have. So again, it's good to be here, and thanks for having me. General procedures of the office. That slide doesn't come off too well. Most everything on there is confidential. So that's what you need to know about a lot of stuff that goes on at our office. Matter of fact, I'll hazard a bet that there's a file in my office with your name on it and you don't even know it. We get complaints all the time with people complaining about anything from their doctor to their dog catcher, and sometimes even complaints about lawyers that don't rise to the level of a formal complaint. So people have said, well, I'd like to know that. Could I call and get that information? The answer is not yet. We've gone through an ABA audit of my office about certain things. Record keeping is one that we fell pretty short on. Our discipline history, your discipline history, my discipline history is on a Rolodex. Matter of fact, my assistant was so upset the other day, we're transferring that right now to an Excel spreadsheet after all these years, and she found 7 cards in the bottom of the Rolodex. She always told me when I first came in, if you're looking up attorney discipline history, you need to shake that Rolodex. And I thought maybe it was a technological term that I didn't know anything about. Well, turned out she found 7 cards, 7 of your cards at the bottom, and she said that's it. She went off to Best Buy or Office Supply Company somewhere and picked up a box and now your discipline history is in a box. And we're currently on the queues, I believe, and getting it transferred over to data. And one of the other things we're going to do is be able to track complainants and track respondents. That would be you. You'd be the respondents. And then we will be able to find out if somebody had a random complaint against you about kicking their dog a couple of years ago. Last year's statistics, we are down to myself and Kent Frobish and a part-timer, Jane Burke, who used to be in with UPL. John Steele's been out ill since last December, so in the event you didn't know about that, or even if you did, please keep them in your thoughts and prayers. We've got 6,200 licensed attorneys, active licensed attorneys. We have a bunch inactive. Just shy of 360 total complaints. And look at that, out of the total complaints, just over 200 were dismissed right away. And one thing I want you to take out of here is just address the complaints not as serious or serious, and generally speaking, they are going to go away. Even on the serious ones, when we dismiss them, they're very rarely appealed. So that's the process. If you have questions about that, well, the slides are in your materials, but if you have questions, make sure you call me. This is something as more of an apology than a question. Going into this job, I had an axe to grind with a certain group of attorneys that I figured were the ones that had most of the complaints filed against them. So go ahead and vote here on the years of practice, and I'll be very curious to see what the group thinks and if it's different than what I thought. Wow, all the numbers rolling in. Okay, we're almost to capacity, I see. What do you know? Well, first of all, for those of you in the crowd in the A group, I apologize, because I figured you were the ones that were the troublemakers. Fresh out of law school, know everything, didn't ask questions of anyone, or maybe timid to do it. But I'll tell you what really troubles me, for those of you out there in the D group, why are we the ones getting the most complaints? Think about that. Why? Don't care anymore, tired, want to get out of the practice, heard it all before, I don't know. We intend, when we approve our statistics, we intend to hone in a little more on what is going on. One of the things, and that's the category there, and this doesn't read very well. If you want the actual slide, I can email it to you, but the complaint by area of practice, look at that, that's other. But guess what? Family, criminal are the big ones, and that's where we got all our complaints. You're getting them, I got them for doing that kind of work. But this other category I find troublesome. As I've said before, it's somewhere between admiralty and zoning. And if you're doing either one of those, you probably don't know what you're doing anyway, so you're going to get a complaint. And I apologize. There probably are some people that do zoning and do a good job. Sorry, Fullenkamp, I guess, would be one I should apologize to. But we're gonna flesh those out a little better. I'm a month away from implementing case management software. Some of you use it because I've seen it in your responses. I was looking at something called Justware that was just beautiful. Angels sang when I tested it. It was beautiful. But it was a $250,000 package. Colorado has it. They also have 40,000 licensed attorneys and 40 attorneys investigating. I'm going with Time Matters, the LexisNexis product that costs about $25,000, and we are going to break down a little better these areas of complaint. Immigration, for example, is off of that chart, and it should be on there because we receive a lot of immigration complaints, a lot of immigration UPL. Okay, that's the letter. I've gotten them, you've gotten them. The key difference is what are you going to do about it when you get it. Now, my old friend Dennis, when I was chair of the advisory committee, I would get those letters, and I would still stand, and I'd open it, far away, like it was toxic. And I once told Dennis, I said, stop doing that. It's really annoying. I get enough 9C letters, the not so formal complaints, and this just adds to my angst. I don't need it. Well, I never really thought of that, Dennis said. So after the conference, it was on a Thursday or Friday, came into the office on Monday, and one of those was waiting for me. Opened it up, ha, 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 I can't believe how much that bothered you. I just thought I'd send you another one. Now, I have thought about crossing them out. You know, if I got my old partner Andy Ferguson's mail, and I thought, well, I'll put an X through it. That way he knows it's not a live one. But then I thought, well, what if I forgot? Or what if, unfortunately, I had to send in one where it wasn't crossed out? It isn't going to make any difference. So it sucks to get these letters, and I've had my share. These are the 4 types of complaints. Number 1 was the one I talked about earlier that you don't even know about. I hate my job, I hate my dog, and I don't like my attorney because he got a really crappy result in my divorce. We're not going to do much with that, okay? The trust account violations, I will tell you this, I guess, since I have to give up on you 5 years or less people, I'm embarking on a new crusade, and that's going to be against you guys that can't seem to keep your trust account in order. I think we're way too lenient. I'll say it again, I think we are way too lenient. And as a parent would say to a child, it's going to be harder on them than it's going to be on you. What I'm contemplating, I'll talk to the chief about this, is if you get 1 or certainly 2 or definitely by the 3rd trust account violation in 1 year, I'm going to make you attend trust account school all day. And it will be hell on you and me. But you'll get ethics credit and you'll get MCLE, so it won't be so bad. The vast majority of the complaints, honestly, are the 9 C's, and they're really tough. You know, as a defense attorney, my entire practice, the chief asked me what I thought about putting the other hat on and becoming a prosecutor. And this was in my interview. And I said, at the risk of offending anyone in the room who might have been a prosecutor, knowing full well that the chief was a former U.S. attorney, I said, I think prosecuting's easier because the defense doesn't have the resources. But I'll tell you, from an emotional standpoint, prosecuting you folks is the hardest thing that I've done next to capital defense. It gives me no pleasure writing those letters, and I'm prosecuting more now with John being out sick. But vast majority are the C's and then our formals, which I told you before. I'm going to give you every benefit of the doubt because I know what you've been through. I dismissed those 9 C's. They have a right, well, I dismissed the 9C. There is no right to appeal. And boy, does that hack off your clients when they know the buck stops there. They generally end up writing a letter to the chief anyway, which just so you know, procedurally, that generally gets referred to Justice Miller-Lehrman, who is the liaison with the Counsel for Discipline, and usually that ends it there. But the formals, they do have a right to appeal within 30 days of our dismissal to the Committee on Inquiry, and a great majority, 90+% of those dismissals are affirmed. Here's the 9C letter you're going to get. Please, for the love of humanity, respond to that letter immediately. I can't tell you how many of these I've sent out since last September, and you guys are blowing me off. There's absolutely no reason on the planet. If you just say, Weber, my dog ate it, I'm probably going to dismiss it. Any decent response will result in my dismissal, and there's no appeal. Get it over with. Respond. Don't look at it like one of your opponent's discovery, like, oh, God, I got those again. It'll take forever since it's the last thing you do. Don't do that to yourself because it will go away, and if you blow it off, that alone is grounds for me to elevate it to a formal. This is the letter that's serious, and you're going to know it's serious because it's going to come certified. And that's the easy way. You know, the old dentist letters that I talked about that freaked me out, well, you're still going to be upset when you get a letter from me. I get that because I was there. This one's going to come certified. I don't need to circle the confidential. I don't need to put exclamation points in either part of it. When you or your assistant signs for that letter, that's when you really drop everything. You cancel that trip, you move the hearing if you can, and the first thing, the absolute first thing you do is get another set of eyes on it. Don't ever take a formal and try to respond to it on your own. I wouldn't even do that with a 9C, honestly. Have somebody else look at it. If you're in sole practice, get a classmate or a colleague across the hall. Get somebody. Few advisory committee opinions. As I said, I was chair of that committee for about the last 5 years. I was on it for about 10. It served me well to be on that committee with so many wonderful attorneys and judges, and it really helps me when you folks call. And that's the other thing I want you to, the ABA doesn't like the practice that we've had for all these years of just call Dennis. They suggested that we stop doing that. Why? Well, go figure. They're afraid that we would turn around and use it as a shield. The respondent would use conversations with me as a shield to a prosecution later. We're going to continue to do it. We're going to ignore the ABA, and I have the full blessing of the court on that. So please make sure you call my office. I can find this stuff much quicker than you can. And I have the resources of the American Bar Association, all the state's ethics opinions, so I can generally get you in the right church, if not the right pew, much quicker than you will. One of the changes, Dave Mitchell, the Yost firm out in Fremont, is the new chair. He accepted that appointment reluctantly because he was on the committee, as was I, and he knew how much time it takes to do this stuff. When you send an advisory opinion request, do not expect an answer within the next week, within the next month. It used to be a year. Now we whittle it down, I'm proud to say, to 6 months or less. But if you're thinking about moving that practice or buying that practice or doing something and you're not sure about it, you need to be planning. And something that is a case of first impression in Nebraska, you're going to have to ask for an advisory committee opinion. The rules provide that you need to brief it. Makes sense, doesn't it? You're the one it's near and dear to your heart. We've taken it a step further with my blessing, and I've told the chief that we were doing this. Now you know what format those advisory committee opinions look like. We want you to draft and format your brief as if it were the actual opinion. Again, it serves the purpose. You're going to write the punchline in your favor, we would assume, and it's going to be a quicker turnaround for anybody that gets assigned that advisory opinion to have it ready to roll, and maybe all they'll have to do is shepherdize your authority. Okay, some of the stuff, I threw out a bunch, even more recent opinions, but this is stuff near and dear to my heart that I get calls on all the time with folks in your line of work. File destruction. 88.3 said, the classic law school answer, it depends. We can't tell when you can destroy your file. You just have to use your own good judgment. And that's back to 1988, and it was good. And it may still be good because that's the teaser. It's part of the question. What's the state of affairs of ethics rules on file destruction? 88.3 still good? Oh, I think 10 years, it should be fine by then. Is it after 5 years? Or the best practice is just make the client bear the burden of worrying about file destruction, come and get your file. What do you guys think it is? And I know there should be 100% because I know you're reading these ethics opinions as they come out and you're a Nebraska lawyer. So you guys have seen them all and you're up to speed on that, right? Okay. Well, that's pretty close. Why don't we just go with it? All right. The answer is C. But D is also a very good answer. You get second place, in my humble opinion. And why? 1207 changed the rule to bring it in conformity with the ethics rules on your financial records retention. Now it's very easy. 5 years, get rid of the stuff. Okay? And here's my suggestion. Again, do as I say now, not as I might have done when I was practicing. Set that in your fee agreement or your engagement letter that at the conclusion of the litigation, it's the client's responsibility to get the client's file. And I'll talk about a couple of things that I know are near and dear to your hearts on the client's file and who has a right to the client's file here in a little bit. But put this advisory opinion language in there. They will be destroyed after 5 years. The client is responsible for picking the client's file up. If you continually provide documents to your clients as the case is going on and you document it, and you'll be able to see that on your hard drive, enclose please find, enclose please find, if that's your practice, and even put this in your engagement letter, but by the time I'm done, the engagement letter will be 50 pages long. If you've provided the file to the client as the case progresses, you have no obligation to give them anything at your expense, okay? And you can call me on that, and I will back you on that. You only have to give it to them once. And this is, as I said, it comports with Rule 1.15, financial records. I know we probably will keep financial records longer, but the problem we're running into here is some of us are getting older, is that we're starting to keep files in our basements, and then we have spouses that don't know what to do with them, and it's going to be an increase in cost for the court that we really don't need to bear. So do yourself and your family a favor, your partners, get rid of that stuff. Okay, some of you do civil practice in addition to the family law practice. I was surprised, will be the hint I give you on this one. Oh my God, okay, statute's about to run, I can't find my client. Certainly, I don't have to file suit. If the client doesn't care, why should I? What do you think? Depends on the type of case, or you need to file. And the requesting party on this one was a friend of mine, and I was actually a bit surprised and disappointed. Very good. Yes, you probably have to file. And that's been me on any number of occasions when I was in private practice. I usually did stand on a couple of occasions. One happened to be on a death penalty case. I was running up and down the hall yelling obscenities for, probably a good half hour, until I reread the rule and found out I didn't blow it. You're probably going to need to do it. It's a dual responsibility to maintain contact with your client. And I hope that's in your engagement letters, that the client has an obligation to maintain contact. The rule of thumb, in my opinion, is never let the case be dismissed on your watch. File the darn lawsuit, make every attempt you can to notify the client, and then with the case pending, move to withdraw and have the court issue a show cause to your client. If she doesn't appear by X date, the case will be dismissed. That's the best practice. I probably didn't always do it that way, but that's free advice there. All right, this has been controversial for you folks. This and the next one, I think you guys will be all over it because you're up on it. It's been a hot topic. A disbarred attorney who's licensed under the Parenting Act can mediate. Can the most experienced mediator in the state do so if he's not trained under the Parenting Act? And keep in mind, the Parenting Act has no teeth in it whatsoever for anyone that thumbs their nose at getting licensed to mediate. There's no sanction. And I would even venture to say people who agree to the non-approved attorney are going to probably consent to whatever that attorney recommends. Okay or not? Very good. It's really one to indicate that out of respect for the law, being a licensed attorney, you should follow the Parenting Act. It doesn't make a lot of sense logically, I get that, but that was the conclusion of the advisory committee. So get yourself licensed if you want to do it. But the next business, I know you saw, it was an advisory committee opinion out of the unauthorized practice of law, and just came out in January of 2015. A non-lawyer is perfectly fine and capable of mediating, but may not negotiate and draft property and financial support settlements or draft pleadings, because that, in the committee's opinion, was UPL. Just my 2 cents worth on that. I think it was one individual. This rule, unfortunately, I believe was written to take care of one individual. I wished we wouldn't have seen that happen, because I know there are a lot of really good mediators out there that work for you folks, and you provide that service and you're supervising the person, so it's not UPL. But that one bad apple ruined it for a lot of people. Other pending requests that you will find interesting, probably will see over the course of the next year. That's another one that, all this detailed billing that's been required or requested. I'm in the loop now of the emails to the state senators, to the judges, of people demanding under blue sky that we provide all this detail of what you guys are doing as guardians. Going back to is it Hawkins at Von Mar, that mess, and they feel that the system let them down, and it's the court system's fault, it's the attorney's fault. The GAL didn't do her job, and that's why people ended up dead. There's a big push, and the ethics involved in that is violating client confidentiality, and it's something that we've got to do something about. Sadly, 2 and 3 are related. Attorney sits in my office, says, I'm losing it, I've got early onset Alzheimer's, and I don't have anybody to pick up my practice. My buddy down the road could use a part-time associate. I could use a part-time associate. Could we screen and share an associate? I will tell you that I view it in my line of work with the advisory committee, but also Counsel for Discipline. I will try my darndest to help you folks do what you want to do within the bounds of the rules. And we're obviously trying to be a little more forward-looking, as I believe the ABA is, in allowing part-time county attorneys, part-time defenders who have a need to make a living with a private practice. We're trying our best. Sometimes it's just too clear and those conflicts are there and we can't do anything about it. But generally speaking, we're going to try. And I think you'll see that by some of these a little more forward-looking opinions that have come out recently. I've taken a bunch of different slides. Some of this stuff is old news to many of you, but I think it bears repeating. You know, you need to know at the beginning of the case. I have people call my office, and it takes me back to my days of doing family law. And if I haven't said it before, I'll say it now. After about 5 years, I realized I didn't have the stomach for it. To the point is that I would rather have a nasty double homicide than a contested divorce. That's the way I looked at it. So that's my mindset. But you hear these people and they call in, I want my pound of flesh. I want my pound of flesh. I didn't get it in court. You're going to get it for me. Well, no, I'm not going to do that. So you know that. The famous Vince Powers had his top 10 that he issues, the bar issues from time to time for New Year's resolutions, and I thought the best one I ever saw was, if after your first meeting you don't like the potential client, don't take the client on. If you don't like the client, the jury, or in your case, the judge, isn't going to like her either. It's a really good rule of thumb. Okay, you can't be involved, you can't do indirectly what you do directly. This really gets involved more. Well, it's in your line of work too. Be careful what you're asking your investigators to do. One of you called the other day and wanted to send a PI out to a local tavern and strike up a conversation with the bartender who happened to be the soon-to-be ex of his client. Don't think so. I think your private detective could go sit there and listen all he wanted to and make all the notes he wanted to. But you're misrepresenting who you are to perhaps a represented person, but you're actually doing indirectly what you may not do directly, and that's violating the rules. Social networking, that was a big deal. They asked me to speak on it down for the young lawyers at QTAC, and it kind of perplexed me a little bit. And there was a national presentation on the social networking and ethics, but you know, the ethics don't change, and I've spoken about this repeatedly. I'm a big fan of Robert Fulghum. Everything I needed to know I learned in kindergarten. You know, don't lie, don't cheat, don't steal, clean up after yourself, and more importantly, take naps. Just because we have all these fancy devices, it hasn't changed anything in the ethics. So you can look on social networking sites all you want, but the minute you start friending, you're given a false impression of who you are. And that's where you go, if it's an unrepresented person, a witness in a case, you need to let them know what acts you are grinding and for whom, or you run the risk of getting a call from my office. And again, with private detectives, you can't violate the rules just because you're shielding yourself with your law clerk, your runner, your investigator. And these are just standard following the rules. You can access the site, and in your line of work, you know it too, you have an obligation. You have an obligation to your client to subpoena those social networking records to get the good stuff that isn't on the front page. And you will have the right to access that information. Whether you're going to get it, some of you have done it more than I ever did. Good luck on some of those sites like LinkedIn or even Facebook, because they're very proprietary about it. Even a subpoena probably won't get you a lot of the stuff you want. This one, you know, judges, it just makes sense. You shouldn't be friending lawyers. I just think it's bad practice. My advice would be for lawyers and for clients. It doesn't make any sense for clients to be involved with the stuff that you see on social media, even though I know you guys love it. It's great cannon fodder, great evidence to find out who the opposing party really is when the cameras aren't on. It's amazing the stuff people post. I've never ceased to be amazed by that. Judges Election Committee, that's not really applicable, obviously, here. You know, there's a case pending and the judge is communicating via social network with the attorney. That's a no-no for both you, the attorney, and for the court. Now, this one, some of you are mediators in family law and maybe elsewhere. Yeah, you can go ahead and do it, but I think you might end up with more of a burden than a benefit, because the other side sees that they're probably going to pass you by asking you to be the mediator if they see that you're a little too cozy with opposing counsel. Okay, you know, this maybe goes without saying, I don't know, I should ask for a show of hands, but anybody that's ever criticized a judge on social media, I'd suggest maybe not do that. Especially, hopefully this wasn't you. Stating on a blog a judge was evil, unfair witch, seemingly mentally ill. Don't do that. Social networking, jurors, very much the same. One case that was an example in this presentation was a juror took a liking to a very nice firefighter, and she asked him out during the pendency of the trial, and that was a little bit of a problem. It caused a mistrial. But don't communicate with your jurors via social media any differently than you would if you were standing on the elevator at Douglas County. Again, you can look at the public portion of your jurors' sites, and you should, because it will give you a little bit of an insight about whether you want him or her, but don't mislead them about who you are. And if, obviously, just like something you'd see or hear at the courthouse, if you see something on a social networking site about, wow, I'm going to blog about this upcoming trial, it really looks good, you probably have an obligation to notify the court. And if you're in doubt, just pick up the phone and call me. I'm not saying I'd know all the time, but I'd say I'll get you the answer. During trial, you know, seeing research, I actually had that happen as a young lawyer, and I was being second chaired, and it was a pretty big case. And I noticed that this one particular juror was down in the law library back when people used to use it for research, doing research. And when he walked away, I saw that he was looking at portions of the city code that were applicable to my case. So I brought it up to the court, and opposing counsel and chambers, and Judge said, well, it's your call. And I, of course, wanted him gone. And I was defending, by the way, on that one. And the seasoned veteran attorney said, God, I really like him, Mark. I really like him. He remained on the jury, and we got clipped for over $250,000. So if you have that opportunity, when in doubt, get rid of that juror. One thing why I don't like you spending your time blogging and being the attorney, we're all proud of our degree and all the hard work it took to get it, but sometimes maybe we should stop shy of offering free advice. My mentor, Joe McQuillan, his mantra was always, no good deed goes unpunished. You're on the website and you're giving out free advice on anything from breaking a lease to who gets the money in the property settlement. You're running the risk of creating an inadvertent relationship. Most of the cases that most of my partners got in trouble on were what we used a broad brush to call family law, and it rarely had anything to do with divorce. It was the neighbor with the kid that got the MIP. It was the landlord-tenant dispute. That all fell within the penumbra in our book of family law. And most of the bigger complaints were stuff you were doing for your friends and family and neighbors. And I just say, again, do as I say now, not as I did. Try to avoid doing that. To just, have less pain in your life. Advertising is a big deal. I'm not that old, but boy, when I started, it was really taboo. Ron Pelagi took it and ran with it. God love him. He made a great living doing it. And I will say, for the most part, in my humble opinion, the advertising in our state is very well done, tasteful, respectful. And then just go to Scottsdale or New York or Vegas and watch those ads from about 8 o'clock on, and you'll feel really good about being a Nebraska lawyer. But most of our stuff on advertising, social media is determined to be the same as if you were doing it in print. Do you need to say this is an ad on radio or TV? Of course not. Why? Because everybody knows it's an ad. It's a commercial. So I think we're at a point, okay. Something big, some big break on like the case today, and I did read about it. It's a good case. It was probably a long time coming, in my humble opinion. But anyway, next biggest thing comes out. I want to send out a mass mailing. Do I need to tell my current and former clients this is an advertisement? Go ahead and vote. I want to see what you think. Okay. The B's are correct. You do not. Matter of fact, current and former clients, you can send them anything you want. And then neighbor finds out from your former client that you're doing this next biggest thing. Neighbor calls, not a current or former client. If they ask you for it, you may send it to them. So that's a nice little niche there that you can do. Maybe not so much, I guess, in family law as you see like a lot of this stuff going on right now in Syngenta. By the way, I talked about tasteful ads. I'm convinced to a moral certainty that the Syngenta TV fake advertising or questioning panel was not created in Nebraska. That's all I'll say about that. If any of you were involved in creating that infomercial, I apologize. So our advisory committee opinions cover this stuff. You're okay, just like you would be sending out a mailer. If it's a former client, current client, or somebody that asked you to send me your blog on something that is of interest to them, go ahead and do it. You don't have to identify it as an advertisement. Just a little bit on trust accounts. Maybe not so much for you folks, but it certainly is for me in my new job. I always, and this is the disclaimer here, okay, I didn't corner the market on genius in running a law practice. I was never courageous enough to go out on my own. I never thought I could, but that goes back to my roots at Creighton University when I enrolled in the School of Business, and halfway through the first semester I was physically escorted out of the School of Business over to the Liberal Arts College because they told me I did not belong. So that always caused me to pause when I thought about running the books at a law practice or any other business for that matter. Trust accounts, interesting stuff going on. Don't go negative in your trust account. If you do, call me. I'm not going to open a file because if I don't get a letter, I'm not going to do anything. We're going to find a way to fix the problem so it doesn't happen to you again. But I do appreciate those of you who do call and say, I ordered a box of checks and I went negative $5.50. You guys know what this is. I'm going to move through this because we're moving along pretty well here. You have to have a trust account. If you're practicing in Iowa, you got to have a separate Iowa account. Free advice from practice, I would just use separate banks to avoid any possible confusion or commingling. Get a bank account across the river if you're practicing over there. You don't have to have the IOLTA account. You can opt out, but you need to get permission to do so. I'm a big fan of IOLTA because it serves a great purpose, and frankly, I think you can feel good to know that in some small way you're contributing to pro bono practice in the state. This applies in the family law context. You are declaring under penalty of perjury that you're going to deliver the widget, in this case, a final divorce and a change in name for $25,000. And you know this person, you went to school with them, so you trust them impeccably, and you just say, because you're so good and you're making so much money, I'm only going to bill you at the end of this case. Or you bill it at the beginning. I don't care. I don't need a trust account, do I? What do you guys think? All right. You do not need a trust account. Do I think that's good practice? No. I was trained in a practice that was mostly insurance defense, so it was by osmosis. Everything went through trust, everything. Criminal defense, you're down there and it seems unseemly, and I know Bianchi's been through this, and you're standing in the rotunda and the client's counting out the cash. And it probably does in family law too, and you just kind of feel uncomfortable, like, gosh, I'm going to run home and take a shower.
That happened once.
Okay, all right. Well, just run it through trust. You really don't have to. If you deliver that, and even if you don't, and we'll talk about this, this is something I mentioned earlier, you have promised you're going to deliver that divorce for $25,000. And God love you if you get it done in a week and it really only costs you $15,000. You've earned that fee because the client has signed it. You might, in that example, be a little bit on the edge of unreasonable fee. The problem occurs, guys, when the client fires you because she didn't like your advice and you haven't delivered the widget. You haven't delivered the divorce. Well, wait a minute. And I please don't call me and say, but I had an agreement for a non-refundable flat fee. Okay, that's like a unicorn. It doesn't really exist because there are exceptions, okay? So I say, even though you don't have to, if you're in the practice, immigration is a good example, bankruptcy is a good example, you get a set fee, and if you charge that fee and you put it in your operating account and you don't touch it and you've delivered the product, you don't need a trust account. Advanced payment of fees, advanced payment of expenses, or someone that gave you funds just to hold for them because they're afraid of what to do with it. Some account that's been liquidated that you've instructed them to liquidate because you know the X is going to take it. That's a good example too. You just leave it there, identify it, and move on. Okay, we touched on this earlier. You don't need an IOLTA account, but you do need a trust account for advanced fees that have not been earned. And this is more for the new practitioner. Now, in a non-IOLTA account, you need to, and even in an IOLTA account, if there's a huge amount of money, a personal injury settlement is a good example, that there's some ongoing fight, there's a significant amount of interest, you're responsible for getting that interest back to your client because that's her money. Commingling of funds does occur. Sadly, the examples, I could go on and on, they're horrible, they're sad, but try to avoid it, please. And you're putting people at risk other than the client whose funds you've taken. Now, you can commingle in a couple of ways. You have your own funds in the account, and I don't think I added slides on this. We'll touch about that in a minute. Or you have client funds in the office account mixed with yours. That's commingling. There's been a question out there. Colorado, for example, absolutely forbids cushions of any form. You've got to come down to the nut on what it is. I know from practical experience in Nebraska, you can't open a trust account without some balance, and that's not obviously going to be client funds. So we say a nominal amount, and by that I mean certainly something lower than $500. I think Kent and I disagree. I think he'd say probably 200 or less. Getting that big personal injury settlement and leaving $5,000 in there as an insurance that you're not going to touch that money so you have money at Christmas time, don't do that. When in doubt, just call me. I'm not going to prosecute you for calling and saying this is what I'm thinking of doing. Better than a year later finding it out. Unearned fees were put right into the operating account, and then spending the unearned money before it was earned is a no-no. And again, when dispersing, you're going to do it, I suppose, more on your property settlements. I always did a settlement statement, and more again on the personal injury side, and most of us do personal injury when it's offered to us, obviously. I include indemnification language that if you haven't told me about these bills, I'm not going to be responsible for them. You're going to be. You've represented that the above were the bills, and if that's not true, you're responsible. I don't know if that would be enforceable, but it sure made me feel better when the client signed off on it that the client was telling me the truth about bills. And that's another thing we're going to touch on here, time permitting. All right, time to participate again. You represent the seller, and the buyer gives you a $50,000 earnest money deposit. The deal goes south. Buyer says, well, give me my money back, and your client says, no, I want the money. What do you do? A, nothing, take your fee and hope the matter goes away. B, do what your client directs you to do. After all, he's the boss. Or C, be careful. I tried to make some of these fairly easy for you. But we'll see. Maybe I'm going to find out otherwise here. Okay, we're up there. Very good. Very good. The businesses, you're fiduciary to both of this in this scenario, and you must not violate the duty to either. Try to get it done. We do have through the State Bar Association fee arbitration, and just a little trivia, I didn't know this. If you've really hacked off the client or the third party that entrusted the funds to you, and they file a complaint, it's too late to go to fee arb. So when you find yourself in this situation, jump on it and propose it yourself, because if there's not a complaint pending, you can go through fee arbitration of the Bar Association at no, I don't think, significant cost to you. I don't know anybody here that, maybe some of you have done it, so you know, but I don't know what the cost is on it. Counsel for Discipline is investigating me because I'm not returning phone calls. Weber then calls and says, you know what? I've seen some stuff going back and forth. I'm now curious about how you're running your office. Show me your trust account for the last couple months. Wait a minute. Respondent says, you're investigating me for failure to communicate. I'm not giving you my trust account stuff. True or false? Half of you responded correctly. B is the correct answer. And sadly, it's tough talking on these because you end up citing cases, and there are people we know and we practiced with. But in Crawford, she was being investigated for not returning some funds that were advanced by a third party, and as the investigation proceeded, it just became apparent that there was some sloppy accounting going on, and that was a point of error raised on appeals, like, wait a minute, the thrust of the investigation was one thing, and then they went over into another, and the Supreme's clearly held, hey, open game on trust accounts. Something to cause you to maybe stay awake a little longer and toss and turn. There's really a push by the Bar Association and our Supreme Court that I utilize the non-utilized rule of random trust account audits. Ugh, I know. I don't want to do it. So what I say is, don't make me do it. For the most part, I should have gone back that original statistic on number of complaints since MCLE came out in 2010. The number of complaints overall has dropped. So I think what your Bar Association is doing is helped. I think the complaints on trust accounts has also gone down because it's, let's face it, folks, virtually dummy-proof with all the technology available with your banks and doing stuff online. It happens. And, you know, don't go nuts over it when it does. Call me. I'll talk you off the cliff, and we'll figure a way to fix it at very little recourse to you unless you're a repeat offender. And there are some of you that are. One, sadly, I looked and thought, well, this can't be right, what she tried to do. And I was researching on Westlaw for prior authority on the issue, and I came up with that attorney doing the same damn thing 5 years ago. Please don't do that. Reasonable fee, we've talked about this. My bugaboo, the famous non-refundable flat fee. You know, very rarely do I get complaints about fees. Usually it's on that flat fee business, and the one that I had to encourage the attorney to return the money, it was her fault for not accounting. When the client fired her, she had a great fee agreement. It said, divorce of your nature is going to be at least 20 grand. Probably 15 to 20 more if it really gets nasty. So it was a flat 20,000, and 17,558 of it was earned at the time of termination. She wrote up her bill, and I know most of you know what that means, but she had wrapped up the file, got it to new counsel, assisted in the transfer, assisted counsel getting up to speed. She earned that. But instead, she wrote it up instead of writing her time down. We wouldn't have had anything to talk about. Keep track of your time. And I know my colleagues in the personal injury area don't. They think it's a luxury. You don't have to bill. I did it because it was a way to determine whether I was profitable in a particular case. I always billed my time on criminal cases, even though I'd charge $2,000 for that DUI. I wanted to see if I did a good job. It made me feel good. If I got the thing resolved with a reckless driving in an hour because I found something in the records, the client was happy, I earned my fee, and I was very efficient. Other cases, more than I'd like to admit, you know, that $2,000 was eaten up before I got halfway through the case. I lost money. So that's just more practical advice than it is the stuff of my office now. Communicate, communicate. That's probably the biggest deal. My lawyer isn't doing anything, and I know that because I never hear from her. And I usually talk them down. I do. And actually, I enjoy those calls, not nearly as much as I enjoy talking to you folks about serious questions and trying to do the right thing. But I'll generally say, well, hold on. Tell me a little bit about the case. Where is it pending? Last name, first name. Look it up on Justice and say, well, wait a minute. Now, no excuse for the lawyer not to get back to you, but you need to know she's been busting her tail. I mean, you guys have gone down there 2 or 3 times, right? Yeah, but it's not moving on. The one I got that you'll appreciate is probably about one of you in this room. Case just isn't moving along. It's unacceptable. Well, when was it filed? April. So you do have the benefit of someone that's been out there doing it. It's like, hold on. In Douglas County? Yeah. It's a simple matter. It should be over with by now. Well, that's not going to happen. This was something from the Enza court they'd asked about, and you'll see it in the materials. These were questions that the very young lawyers and law students were asking. Least well-known ethical pitfall, and I think it is my complaint about the younger lawyer maybe, or even the older lawyer that's doing something that she hasn't done before. Ask somebody before you get involved. And I saw one, I put it in the family law. Auntie dies, and they asked the attorney to wrap up the matter, and he'd never done it. And it was a mess, and he ended up suspended over it. Use technology, use our website. I'm amazed. It's not the best website in the world, but there's a lot of stuff in there. Just go to supremecourt.gov, go to attorney services, look for counsel for discipline, and you'll see all those ethics opinions we've been talking about today. Oh, you know, the young attorney, what do you do when a partner tells you to do something you find inappropriate? Go to somebody else in your office, figure it out, or worst case, call me and say, you know, I didn't hear back from this attorney or the superior. Well, you know, I really felt uncomfortable about it, so I just called Weber, and he said, don't do it. And if you have any questions, call him. Well, guess what? I didn't get a call. And don't, and this is a real example, don't tell your associate to go to the CLE and have them sign in for you. Don't do that, because usually we'll find that out. And it's a little embarrassing. Okay, supervisory transitioning lawyers. This is a scenario that's too long, but I'll just say you got this wonderful job, and you can't wait to start. They want you to start in 2 weeks. Your trial is set in 3. Client wants you to try the case. Please. The attorney has an absolute right to go to a new job. Just tell the client to figure it out on her own. My partner and co-counsel has done a lot of work, ready to roll, or you find out in the course to get out that opposing counsel's got health problems and is going to have to withdraw, necessitating a continuance anyway. A little bit of a trick question I'll just start with. I don't know. I stopped the voting, I guess. But anyway, the answer is we're running close to out of time. If you don't have any significant adverse impact by your partner, the client probably doesn't have a right to force you to try it. If an analogy would be in the criminal defense, defendant is entitled to a lawyer, not the best lawyer, or the lawyer of his or her choosing. It's up to the court. But I would disclose to the court. I've seen cases, I've been there, where someone wanted to be a judge and wanted to start immediately, and it was a huge double, triple homicide, and one attorney just wanted out because I think he'd run out of money, and the judge was going to make him try it. And I know from personal experience, because I happen to be representing the guy on the state side homicide charges. But because I was willing to come in and try it, and the other attorney had gotten substitute counsel, I believe, the court went ahead and continued it briefly. But when you find out, that's closer to my example, is this C. There's going to be continuance granted anyway. It's not your fault that there's going to be a delay. It would have occurred anyway due to the health of your opposing counsel. So you're not significantly adversely affecting your client. It's an unfortunate thing. She wants to get to trial, but I don't think, I'm certainly not going to tell you to stay in the case and try it when there really is no practical need to do so. Trust account balance when you leave. You can't take all the money. Again, that's come up a lot in these immigration cases when people have transferred. The work is done, or the work is not done, but the fees have been exhausted because you have this set phasing of when fees are incurred, and you either got to finish the work after you leave. You got to finish it for free, or the old firm's going to have to reimburse some money. Generally, call me when that happens, and it does happen more than you think. Safekeeping property, we've talked about it. Notice on transitioning a new firm. By the way, in a Nebraska Bar Association near you, you're going to get a fabulous publication on selling a practice, moving on, retiring. Wonderful materials. I can't wait to incorporate them in my presentations. But when you have questions, people do call toward the end of the year when they're moving generally to a new firm or a new position. Oh, this is one some of us know something about. Firm A and B, they hate each other. This is one we'll end on. And actually litigation was going on for 15 years. But one of the grunts in Firm A wanted to go to Firm B, kind of like Romeo and Juliet, I think. Can you go over there while the case is still pending? Yes or no? I should add while you're voting, because it'll change your vote, the attorney from A didn't have anything to do with the ongoing litigation. Okay, we're going to... Are you giving me a D minus? Sarah, what do you think? Okay, we'll finish. You may. And that's part of what I promised you, that we're trying to be a little more open-minded about such things and let you do your stuff. This was a probate attorney, had nothing to do with litigation, and so we say, why not? And that's what the American Bar Association said, so we're like them. Thank you for being here, and thank you for your attention. Thanks.
Okay, before you guys head to lunch, and again, the lunch is in the atrium, which is outside this way, down the left, down the stairs. But before you leave, we have Liz Neely, who's heading up here, who's the executive director of the Nebraska State Bar Association, who's going to talk to you. And we have a great afternoon planned with great speakers, so we'll see you after lunch, after Liz talks to you.
Great, thank you. Actually, Sarah, could you come up and maybe pull the bar website up for me real quick? Good afternoon, everyone. Thanks.
Raise your hand if you are not frustrated with how alimony is decided in courts. How about raise your hand if you always know how alimony is going to play out in courts? So there was an article that came out in the American Academy of Matrimonial Lawyers. I believe the title was A Uniform Approach to Alimony, that kind of surveyed the 50 states on how each state is treating alimony. Some have statutes that provide a pretty objective criteria. Others, like Nebraska, do not. But in any event, we have the pleasure of having a great attorney who has been a great attorney in family law for many years, Pam Govier from Govier Maloney. And she is also a fellow in the American Academy of Matrimonial Lawyers, which is the organization that issued this article. And so it's a real honor to have her be able to do this, and this is what she's going to talk about.
All right. Thank you all for coming this afternoon. When I agreed to speak this afternoon, I thought it was nice that Philip was kind enough to put me on after lunch so all of you would just be dozing off, and I wouldn't have to really worry about anybody paying attention. My name is Pam Govier, and I have been practicing divorce law in Omaha since 1979. I was 11 when I graduated from law school, and over that period of time, I consistently struggle with the concept of alimony. And so when this article came out, I talked to Philip and I said, this is maybe something that we might have a discussion on. And so that's kind of what was behind all of this. So in their little speaker presentation information that they gave us, they said that we should start with a joke. So of course, I'm going to have a joke. So on the day this couple was getting married, tragically, they were both killed in this just horrible accident. I know this doesn't sound like it's going to be a joke, right? Anyway, and they end up in heaven. And they're up in heaven, and they're there for a while, and things are going real well. And they decide, you know, they go to St. Peter, and they say, you know, when we were down on earth, we were just about to get married, and, you know, we're up here, and we kind of think maybe we still want to get married. And he says, well, you know, we've really never had anybody kind of ask us that, so I think you're going to have to go to the big guy himself. So they went to God and said, you know, we really kind of want to get married. God said, well, you know what, yeah, I'm going to have to get back to you on that. So they wait a year, they go back to God again. This happens over and over, 10 years. Finally, they go back to God again thinking, oh, you know, nothing's going to happen. And he says, you know what? We're gonna arrange. You're gonna get married this Sunday afternoon, 2 o'clock. We've got this all arranged. Buddha's gonna do the flowers. We got Moses weaving baskets for him. We got Jesus in charge of the fish course. You know, this is gonna be great. And so the wedding happens. Everything is great. They're married. And then, well, they come back to St. Peter and they said, yeah, you know what? We kind of thought we wanted to be married, but it's kind of not working out for us. So we've kind of decided maybe we need to get divorced. He goes, you're really going to have to talk to the big guy about this one. So they go to God and they say, yeah, it's not working out. I think we're going to have to get a divorce. He says, are you kidding me? He goes, it took me 10 years to get a judge up here to marry you guys. Do you have any idea how long it's going to take me to get 2 lawyers to get you divorced? So that's my joke. All right.
Here is the difficulty that I have when I analyze alimony. Every time I represent the recipient of alimony, I end up feeling like they didn't get enough and they didn't get it for long enough. And every time I represent the payer of the alimony, they are paying too much and they're paying it too long, and as every one of them that pays alimony will tell you, it's like feeding oats to a dead horse, right? So with that, it's like, what can be done about that? So I started off, and you'll find in your materials, I just listed some of the things that I do, and if this works. Oh, page left intentionally blank. Okay, I just repeated the statute. Everybody's read this before. And this is as much clarity as they give us. We need the alimony to be reasonable. Oh, okay, well, that tells us a lot. We need to consider the circumstances of the parties. Okay, the duration of the marriage. Okay, who here's the rule of thumb? Well, it's going to be half the length of the marriage, but never more than this much. Or if it's under 5 years, you're never going to get alimony. Oh, wait a minute, there's a case. Okay, that one's not true. So, you know, history of the contributions to the marriage, all right? Contributions to the care and education of the children, interruption of personal careers or educational opportunities, and the ability of the supported party to engage in gainful employment without interfering with the interests of any minor children in the custody of the party. So it goes on to say, you know, read the head notes and it says, oh, the criteria for alimony is different than it is for property because they serve two different purposes, but we kind of look at both of those things all together. The property division is to distribute the assets and the alimony is to provide, the quoting, continued maintenance or support of the other party when relative economic circumstances and other criteria make it appropriate. All right. Again, the difficulty is defining when it's appropriate, when it's not. So I pulled up some of the random cases, and when you get to the back of my materials, you'll see that I kind of came up with a chart that I kind of used the format for the Willig article and tried to see if I could find Nebraska cases that dealt with it. And I am going to say up front that my pulling out cases was somewhat random. And what I mean by that was I tried to get most of 2014, most of 2015. There weren't very many, so then I dropped back and got a few of the 2013 cases thinking maybe that would help. What I was hoping to do and what I wanted to do with today's presentation, I wanted to come with you and say, boy, if you look at all these Nebraska cases, there's a real pattern here. And let me tell you what the pattern is and we can apply it. I'm going to tell you in advance, don't have a pattern. I don't have a formula. At the end of this, I'm not going to come up with the, okay, here's the magic answer, here's exactly what the situation is. Because what I did discover was a real distinct lack of pattern. It didn't seem that it was kind of dependent. It looks like cases in greater Nebraska, and I always kind of laugh at that because I'm from Alliance, Nebraska, and it's like, oh, that's about as great as it gets. But anyway, cases out west are vastly different than cases down here. We have, what are we up to, 16 judges here in Douglas County now? And I think if you gave all 16 of the judges the exact same fact pattern and locked them in a room, I think we would have 16 different answers to what your alimony case would be. And so I get calls sometimes from lawyers going, let me run this by you. What do you think is going to happen? And I have to admit, my answer is, beats me. And so that's the difficulty. And I think what happens is that I find, at least in my practice, alimony is something that you litigate more often than the other stuff. Because here's what's really easy. I can calculate child support. Thank you, Adam. I know how to put stuff down. I mean, I can kind of figure out, not to say that you don't ever argue about what the income is and what the input is, but eventually you can at least kind of have a bit of certainty on doing that. When it comes to the property, I can pretty much, you know, if you can trace the non-marital property enough, I'll give it to you. And so I just add the rest of that up and I divide it by 2. I can pretty much do that. And then we get to alimony. And I don't know. That is where I stub my toe, and that's where we don't have predictability, we don't have reliability. And I think one of the things that happens is that I think that when results are not predictable and not consistent, then I think it leads to kind of a mistrust, if you will, of the process. It's like, well, maybe you guys don't really know what you're doing. And the clients talk to each other, and it's like, my neighbor's hairdresser's parole officer's wife is getting this much alimony, and so I should probably get that much too. It's like, okay. And there are always these people that you never can identify, by the way. They're always the neighbor's hairdresser's parole officer's wife. And so what I do, I listed just some of the case law here, and I'm not going to bore you with reading through it, but some of the things that I pulled out was, one of the things the court says is, we look at whether they need alimony to bridge a period of unemployment or to get training. Or we look at, is it to assist the party in the same lifestyle they'd become accustomed to during the marriage? But we remember now, it's not to equalize the incomes. No, we don't do that. It's not to punish one of the parties, which anybody that's paying it kind of feels pretty punished, I think. And if you focus on need only, then that just ignores the relative economic circumstances like disparity in income, earning capacity, and just the general equities. Can alimony be longer than the marriage? Yeah, which I'm not sure how that makes any sense, but it does. And is there additional training required to resume their profession? Were there imbalances in the contribution and the sacrifices? And we know that it can't be 75% of your income, because there's a case on that one that says that's too high. So with that, I kind of included in here the article, and I'm not going to go through it, but there's an article in here. What I'm going to share with you is what I do, and I don't know that there's anything in particular magic about this, but this is how I approach when I'm looking at the alimony aspects of the case. One of the things that I like to do is I like to require my clients to give me a written narrative of, like, how did you get here? And I kind of outlined a little bit about what I asked them to do. And I'm going to tell you the reason I do that is it kind of serves 2 purposes. Number one, it's almost kind of cathartic for your client to kind of, sometimes when you don't have anything for them to do, it's helpful to give them an assignment that gets them kind of working on things. And I think that it's kind of a good experience for them to kind of work through how'd you get where you got. The second reason I do it is I'm a visual learner, and I do much better remembering things that I read and see than I do things they tell me. Because I have a really short attention span, and I just tend to, like, zone out. Squirrel. Anybody see Up? And so I like to read it, and so then I can go back and I can look at it on my own time. So this is just kind of an outline of the kind of things that I ask them to go through. And then, I kind of like to also let them know in terms of, at the end, it's like, what's your desired outcome? And I give them the choice of, would you prefer not to be divorced, because I think it's only fair to let that be a choice, even though that isn't going to happen, or I would prefer the divorce and I want the following outcome. For me, I think it helps me in dealing with my client to manage expectations. If I have somebody that says, okay, well, I've been married 3 years, and what I'd like to do is never have to work again, be supported for the rest of my life. We're going to have to manage those expectations just a little bit closer, because I'm not so sure we're going to be able to accomplish that. And so maybe we need to work on doing that. But I like to do that. And then I just kind of, just the boring, facts and figures and background and all of that kind of stuff. Okay, now we're getting into kind of the whole approach of the article that kind of started all of this. If you look at the you look at the background, there were some studies that were done on alimony, and not all of them have been successful. The ALI did one, and the American Academy of Matrimonial Lawyers, and those have been discussed in the articles, and so I'm not going to go through that. By and large, most of the efforts to come up with guidelines for alimony, at least up time, have been guidelines designed to restrict how much alimony. In other words, to limit the duration to, alimony can't be beyond this, or alimony can't be beyond this amount. That's where most of it has been. And if you look at the reason for that, it's because the alimony laws come from our legislatures. Our legislature is driven by lobbyists, by special interests, by whoever presents the issue. And historically, or at least recently, most of the we need to discuss the alimony issue comes from payors who are coming in and saying, hey, we need to put some boundaries on all of this. And so that's kind of been the background of where it's come from. So there hasn't been like an analysis of really what should we be doing, how should we be doing that, and what kind of things should we be looking at. I'm not going to go through and read all 233 pages of the article to you, but I got permission to reproduce it here. But I am going to scroll through really fast to get to his flow chart. There's some really good, while we don't have guidelines that we can actually apply, what I would ask you to do is there's some really good questions in there that you can rely on then in developing either a defense to an alimony case or developing a case in support of it. Okay, the chart that he has is all the way at the end of his. And so if I'm not making anybody motion sick, don't watch the screen while I scroll. I hate it when I'm looking over somebody's computer and they're running the thing and it's like, I don't know when they're going to stop. It gives me motion sickness. I think it's on page, oops, I'm not even close. I think it's 233, 232. I'll get all the way to that. And I would really urge you, because I'm kind of watching my time here, I'd really urge you to read some of those questions that lead up to this. If I had a jump ahead, oh, here, once it's, here's the conclusions, now, there. Okay. This was the chart that I thought, okay, this is a great analysis, and what I'm going to do is have you walk through all of this. The first thing is we look at it, is it even an alimony case? All right, things that you look at the length of the marriage, you look at the circumstances of the parties, and sometimes you just go, you know what, this is probably not an alimony case. If you have two income earners, they're really close, it's probably not an alimony case. And then the rest of these, as you go through, and I'm going to confess I can't read this one here in front of me because it's too small on the screen. But as you go through there and look at the questions, like I said, I think it gives you some really good information for calculating that. And so then what I thought would be a good idea would be to go through Nebraska cases, and I picked those, and I outright admit that I stole Mr. Willick's chart in doing the analysis. And so then I came to looking at all the Nebraska cases that I randomly pulled, and I am going to say that, as I did before, it's not all of the cases. And so what I've included here, and I know it's sideways, so it doesn't help to put it up there. But what you have here is an analysis of the Nebraska cases that I was able to pull and the factors that went in to each one of those. And I went through that and I thought, okay, so I'm going to look at his factors, I'm going to look at his chart, I'll come up with some kind of a pattern. Well, I didn't. I thought, okay, there's got to be. I mean, same similar facts. No. All the chart told me was we're less predictable than I thought we were. And what use is this chart to you? Well, if you got a case kind of similar to that, you might want to pull some of those out and look at it. All it said to me is we need to start a very serious dialogue about whether we need to have some kind of guidelines. Now, do I think that that's going to be a panacea to everything? No. Do I think that guidelines without an opportunity for judicial discretion to be applied? Of course we're going to need to have that. There are some, there are cases that fall into different categories. One of the categories the article talked about is alimony just because. And there are some cases that it's probably appropriate to have alimony just because. And so anyway, this concludes the material that I have, and I'm watching my time here because my little Fitbit just told me that I'm out of time. But the bottom line is I don't think that we have clear and consistent standards for alimony, and I think that some real serious discussion needs to go into, do we need to develop those, and if so, what components? So hopefully I've given you some things to think about. I've given you at least some cases that you can rely on when you're researching where alimony needs to be, and hopefully it'll help you in that regard. So, questions?
Yeah. In your research, did you discover anyone who was making a push to propose some guidelines?
Locally?
Locally or statewide?
I'm not familiar. I didn't reach out to anybody. I'm not familiar with anybody that is behind any kind of movement to develop guidelines or anything like that. I know Nevada is where this article was based, and they have some. I know New Mexico does some, but I'm not familiar with any movement locally to even consider whether we need to adopt guidelines. Mr. Floodman.
Why would you want to take away your advantage of being a great lawyer and being able to advocate for or against them and just put it in a guideline form?
I don't think I want to. I still think if you have guidelines, you have to put your facts in still before you can apply that. I think that what guidelines would do is, first of all, answer the question of, is this in fact an alimony case? And I think that would be helpful. And then I think guidelines would also help to provide some kind of more definition of what kind of evidence would be helpful for the court. One point that the article raised that I've always found kind of interesting, and by the way, I will tell you I've argued this before and never successfully, so just in case you want to know. My point, okay, so let's assume that you have the situation where somebody's a teacher and somebody is a business executive, okay? When you went into teaching, you kind of made a policy decision that you were going to be content to live on, what, $35,000, $40,000 a year? That's kind of what you picked. And so when you hook up with the business executive and the two of you together have this combined income, haven't you already benefited from the marriage because you would have been living a $30,000 lifestyle, but you got to live a $300,000 lifestyle? So didn't you get some of that benefit already? And Ben Belmont will tell me that that argument didn't work last time, Pam, and it's not going to work again. But I still think it's got some merit to it. Although Ben will tell you that it doesn't, and that didn't work. But yeah, I still think there is something to consider from that. And one of the things that the article mentions is something called the career asset. And so it's like, okay, in this particular marriage, there was a primary career. This one worked. And so we both contributed to that, but if you're the person with the career, you're walking out with the career, which is all the benefit associated with it, and I don't get my contribution. It also makes the point that in looking at the career asset, you have to remember that that contribution is a diminishing return, because you might have contributed up to this point in time, but once we get divorced, I'm still doing the career, and if it's still going well, you're not helping now. And so looking at the career itself as an asset kind of takes it out of the what do I deserve kind of realm into what's kind of a way to quantify this and then make a division, much like we make divisions of other marital assets. Questions? Does everybody know exactly how to calculate alimony? Okay, thank you.
All right, well, I'm going to, in the words of Austin Powers, I'm going to please allow myself to introduce myself. I'm the next speaker here. If you all give me a moment, I'm just going to set up the materials. And again, we'll get started in one moment, but I'm going to have someone grab this microphone. If anyone has questions as we go through this, thanks, Steve. I'd keep it off for me. Well, again, thanks for coming today. First, before I start the legislative update, I want to thank Jane Langen, who is not here today. She's done this for I don't know how many years. If anyone can tell me how long she's been doing it, as long as I've been coming to it, she did it every year. And my first year as section chair, I think I sent out an email where I said, well, we'll have our mainstays of Steve Floodman doing the case law review and Jane doing the legislative update. And she was like, I think I've done my time. So it was on me. But she did a wonderful job. She really kind of laid a good template out. As part of the family law section, we do have a legislative subcommittee. I'm kind of the self-appointed chair just because no one else was doing it. But we would meet and talk about the laws that were being proposed in the legislature that affect our practice area. We would discuss it, and then we would give our opinions as to yay, nay, or no. You know, there's 5 positions actually, but monitor, meaning don't say anything, support it, oppose it. And we'd give our position to the General Legislative Committee of the NSBA, who would then lobby that position on behalf of the NSBA to whatever the legislature is. This year I wanted to try to get people more involved, so we sent out a survey through the SurveyMonkey, and a lot of you participated, and it was interesting to see how practitioners around the state felt about the various issues. There were 13 family law related bills introduced in the 2015 this last legislative session. Of the 13 bills that affect our practice area, only 3 got passed into law. I'm going to discuss each bill, though, because some of them, as you may know, we have a biennium, so there's another legislative session coming up here, and all the bills that failed, unless they literally got killed, if they have the right critical mass behind them in terms of their supporters still wanting to push them forward, they could be reintroduced, they could be reconsidered, and perhaps get out of their respective committees and maybe make it into law. So the first law that I'm going to discuss is LB 27. This was a Vital Statistics Act that was supported by certain constituents, which some of you may know. But the idea behind this act was to require the clerk of district court to basically issue a form that would be promulgated and created by DHS that would be filled out by us as the attorneys. Actually, they say the plaintiff. So whoever the moving party is in the action would have been required to file, at the end of the case, file this statistics form saying what kind of custody you had, what was the proportion of parenting time. Really, because there are some lobbying groups, as you may know, that have really been having a push to try to change the Parenting Act in favor of presumptions of parenting time, 50-50 parenting time, things of that nature. And those groups, as well as some other groups, said what we do need to start to do is to hold the judges accountable, particularly since in some areas of the states the rulings of the judges are so different. As you know, if you're in western Nebraska, the ruling in custody in a farm town where perhaps husband is getting up every morning at 5 and work until sundown is different than it is here. So there are very different results. But this was just to be able to gather data so that we could really start to see a true picture of the custody rulings that the judges are handing down. However, it did not make it out of committee, so perhaps it'll get pushed through again. It did put the onus on the attorneys, however, to fill this out, and if no one filled it out, then the clerk had the option of basically saying, no one filled it out for this case. There was really no penalty for it. But there would be a way to track the instances in which someone didn't submit the forms. So that's that bill. The next bill is LB 44, and I'm going to try to get down to it. Excuse me. So LB 44 was to change the notice, the time one has to file a notice of objection to adoption. If you recall Susan Sapp this morning talking about the notice plus registry, putative fathers have the right to file a notice to objection anytime during the pregnancy up until 5 days after the birth. This would have extended that time to 30 days. It did not make it out of committee, and so it may come up again, but obviously the group behind this one felt like 5 days was not a reasonable time frame. And I think we've all had clients, or perhaps you've had clients that maybe they didn't have a reasonable expectation, or it wasn't reasonable for them to think that they might be a father. But anyway, this would have extended it, and it did not make it through. The next act, LB 219, you may have read some articles on it. I could spend a lot of time in this, so I'm going to try, and I'm going to spend a lot more than the other acts, but this did get passed into law. It is the Uniform Deployed Parents Custody and Visitation Act, and it will be operative January 1st, 2016. I wanted to give you a little background in that we were told, Senator, I believe it's Crawford, Adam, the senator behind this, was it Crawford? Yes, Senator Crawford out of Bellevue was the one behind this, but there was a committee that developed the law. Adam and Angela Dunn, who's the managing partner of my firm, both were, and I wanted to also say that Angela and Adam were both military brats, so being attorneys and military brats, they had a unique, being divorce attorneys and having that military background, they had a unique perspective. But Congress apparently, the ULI had prepared, the Uniform Law Commission had drafted this bill, and Congress was allegedly Congress was going to push this on the states, but you had the option of adopting it yourself. And so Crawford proposed it and was taking input, and Adam and Angela and some other folks gave their input on maybe some things, ways we wanted to change it because it didn't address everything. The basic premise of the Uniform Act, I'm just going to refer to as the Uniform Act, is that a deploying parent's custodial responsibilities through this act can be delegated to an adult non-parent for the period of the deployment in one of three ways. And I first wanted to tell you it has to be a deployment of 18 months or less. So if it's a 2-year deployment, that is no longer considered a deployment, and this act does not apply. But if you're 18 months or less, it's a deployment, and that person could potentially delegate their what they call custodial responsibility, so this could be decision making as well as parenting time, to a non-parent, which could be a step parent, a family member, or someone that qualifies under the statute as having a close and substantial relationship, and we'll get into that. But the three ways you can do it is by mutual agreement. So you can literally have a granting of custodial responsibility agreement. It should be filed with the court. If there is an ongoing case, you would be required to file it under that case number. If there is not an ongoing case, you would be required to file a new complaint requesting a granting or delegation of custodial responsibilities to whatever non-parent you are proposing. I think the typical situation most people envision this happening in is service member gets a divorce, there's a divorce decree, maybe a paternity decree that includes a custody and parenting time arrangement. They get remarried, they have a new spouse, they have new children, half siblings, the person gets deployed, and maybe the other person doesn't, you know, and they have, let's say they have 40% parenting time, 12 overnights a month, and the parent who is still in the States during deployment says, I'm not going to let you take Billy, you know, let your new wife have Billy for 12 nights a month. That's ridiculous when they could have me. But there may be a real close relationship there, particularly if they're siblings. I will tell you that Adam and Ashley and I recently met with the 3 district court judges here in Sarpy County, just because one aspect of this law is there is almost no practical provisions in terms of this law and into how it's actually implemented in local court. And so I'm going to be presenting on this at the annual bar conference in October in front of the military law section, and the focus of my presentation is how do you use this law? Only the law doesn't really provide how you use it. In fact, it's silent to service. It says that the non-parent, for instance, has the power to enforce, but then doesn't tell you exactly how could you have a non-parent who's a non-party enforce the agreement. I'm not going to spend a great deal of time on that. You know, how could you have a contempt, say, brought by the non-parent? Things like this aren't covered. You could talk a lot about how to do that, but I wanted to get the Sarpy County judges, since they were primarily going to be affected by this, their input before I got blamed repeatedly in open court for Philip Katz and Adam Ashley told me to do this. So anyway, if you have the first way you could delegate parental or custodial responsibilities is by agreement. The agreement needs to have the destination of the employment, the duration, the conditions of the deployment. The person who's going on deployment, the service member, has to give notice, I believe, within 6 weeks. Forgive me if I misspoke, but I believe it's 6 weeks before the deployment, or as soon as possible, give notice of the deployment to the other custodial parent. And if they get an agreement and they file the agreement, it should have the destination, the duration of the employment, the conditions of the deployment for the basis of the agreement, the allocation of caretaking authority among the deploying parent, any specific decision-making authority. So you may have an agreement where you say the non-parent could have a voice on what school the child attends or what extracurricular activities they're going to. So it would be decision-making. So if you're going to have a decision-making, a legal custody decision-making authority, you want to provide very specifically what decision-making authority you're going to give to them. I would not recommend just saying they will have the same joint legal custody and then just defer to the Parenting Act's language of mutual authority and responsibility. That would be a bad idea. So as it says, if custodial responsibility is shared by the other parent or a non-parent, you need to also provide a process to resolve disputes. Doesn't say what, so you could get creative. I think you could mandate, because it's an agreement, you could mandate mediation, you could provide mediation, you could provide that the non-parent, because they have the duty to enforce, has the ability to, is also subject to the court's jurisdiction, and you could have contempt as a possible remedy. You also need to specify the duration and the frequency and means electronic by which the deploying parent will have contact with the child, the contact between the deploying parent and child during the time the deploying parent is on leave. It states that you acknowledge that any party's child support obligation cannot be modified by agreement. Obviously, this is because the court always has the duty over the best interest of the child, so anything like that would have to be past scrutiny of the court. And you also are supposed to provide for when the agreement terminates and how it terminates. And I'll get to that later, but what I will tell you is the Act is not entirely consistent on how the agreement terminates or how, what I'll talk about later, a temporary order terminates. The three ways you can delegate is by this agreement, by limited power of attorney, and the limited power of attorney is going to be situations where maybe the other parent's not in the picture. So when they leave, they're going to delegate authority, say, to mom or dad, grandma, grandpa, and so you can do a delegation of a limited power of attorney. I did want to throw out the option that people always have the option not to file an agreement and do it all by agreement. I mean, I think the law in general wants people to get along. So if people can do this all without an agreement, the law certainly allows for that. But if you're going to do that, I think the limited power of attorney, obviously you would want to leave the party with that power to make decisions for the child in your absence. The third way that you can have this granting of custodial responsibilities is that you make an application to the court. And as I said, if you have an ongoing action, you'd file a motion for a temporary order. Another thing the law does not provide for is how the evidence is received at these hearings. And it's not governed by our divorce statutes in Title 42 or Title 43. The judges we spoke to just kind of said, we're just going to assume it's done by affidavit until the Supreme Court tells us otherwise. So, and I will tell you, I kind of assume the same thing. If the statute expressly provides for the ability to file a motion for temporary order. So the court, if they grant, it's discretionary, and if the court does grant a portion of the custodial responsibilities or a granting of custodial parenting time, it cannot exceed the greater of, they can't grant any more than what the deploying parent had. So if the deploying parent had 8 overnights, they can't grant 10 overnights. And if the deploying parent did not have joint legal custody decision-making, they can't grant the non-parent person decision-making authority. So they are limited in that nature. In evaluating whether or not they should grant the non-parent custodial responsibilities, I'm sorry, I forgot to. Excuse me, I'm just getting to my factors here. So in deciding whether or not whether they're going to grant this non-parent responsibilities, these are the factors you see up here that they're supposed to look at. And I think this is what Adam and Angela worked with the courts with, is the proposed law, the uniform one, was kind of devoid of specific factors the court should be looking at. And that was a concern because what if your ex-spouse lived 2 counties away? Should we be interrupting the child's extracurricular activities, events, and things like that? How is that in the child's best interest? And we wanted to, I think the concern was he wanted to provide the court some very specific guidelines of things that they should be looking at, and this is where I think Adam and Angela's background came in of. They were military kids, so they had that background, and then combined with our knowledge as divorce attorneys of here's what we see when this happens, the concerns we have. So you see one of the qualities is the level of involvement and the extent of pre-deployment parenting responsibilities, the quality of the relationship between the non-parent and the child, the strength of the ties, and the extent to which the delegation would interfere with that child's activities. As I stated before, the court can grant both parenting time and decision-making authority, but the court must specify the exact decision-making authority they're granting. And if so, a temporary order will be granted. Section 21 of the Act outlines that there are more specifics about what must be in the temporary order. Per Section 23, the court cannot modify the agreements subject to the Civil Service Relief Act, and that is because these agreements have to be signed by the parent, the 2 parents, and the non-parent. So obviously, if someone's overseas, perhaps they're not even out of contact, you couldn't try to modify this agreement. Other things, just kind of miscellaneous sections of the bills and concerns that I wanted to highlight. Any delegation of custodial responsibility will terminate after the deploying parent returns from deployment. In a proceeding for a custodial responsibility of a child of a service member, the court may not consider the parent's past deployment or possible future deployment in of itself in determining the best interest of the child. So basically this is saying is we're not going to take service members' service to our country and hold it against them in determining custody, how much they've been out. As I mentioned before, I referenced Section 9 gives the non-parents standing. It gives them standing during the deployment to enforce the issue. One concern I had when I was talking to the judges is, should we add the non-parent as a third party to the case caption? And their response was kind of saying, you know, if you serve a subpoena on someone and a third party and their attorney comes in, they don't have to be added. Just in whatever agreement you have or temporary order, just reference that they have a duty, they're able to enforce, and so they're subject to the jurisdiction of the court and have them sign it. The obvious one, Section 23, says that if the court will terminate the grant of authority upon the motion of the deployed parent. So deployed parent comes back if they're the one to file motion. I think it goes without saying they would terminate the rights. So there are other issues I mentioned, the enforcement issues and some of the things that are not provided. But what I would tell you is look really closely at the termination. Some of them just say automatically the agreement terminates upon within 60 days of returning. But how does the court have a way of knowing when the party did return, if there's not an affidavit, for instance, filed with the court? Also, the termination agreements, it says that no action is required of the court, meaning the termination agreements don't have to be signed by the court. We had the concern of if you had an enforcement issue but you don't have a court order signed, then that could be a problem. You know, if the non-parent calls up and says I'm supposed to have the child and shows an agreement that's not signed by the court, that's probably, the sheriffs are probably going to say get an attorney. So I think as a matter of good practice, it would be a good idea to have a one-paragraph order attached to the agreement or make it a stipulated agreement with a place for the judge's signature. So, all right, going on to the next act, the Adopt a Child LB 281. LB 281 was proposed. It was referred to as the Child Support for College Savings Act, and this did not make it out of committee. It can be reconsidered in the 2016 legislative session. It would have permitted a non-custodial parent who's owing in child support arrears but is currently paying, so they are currently paying but they have an arrearage, to open Section 529 college savings account, one or more, and make contributions to one or more of those accounts while they're still paying their child support. And the amount paid by the non-custodial parent into the college fund could reduce the amount owed by the non-custodial parent to the state. And that's by virtue of if the custodial parent had applied through the state under the 8 Dependent Children program, it could offset that owed. So a lot of people, I think the comments we got when we sent out the questionnaire is a lot of people felt we want us, the taxpayer, to subsidize people putting through the college because the child support payee didn't feel like paying child support. So not a lot of people were too hip on this, and it didn't go anywhere. And I suspect it won't go anywhere. Yes? You want to grab that microphone real quick so people can hear you, Bill?
Hello. I feel like Phil Donahue. That bill was patterned after a bill that passed in Kansas a couple years ago, and the reason or the rationale behind it isn't to take tax money away from other purposes, but to try to encourage people that are behind in their support that may feel that there's no point in paying their, trying to catch up, that maybe they would actually see some money going to their kids in the future. I mean, I think there's good intent behind the bill, and from what I heard when I met with some federal offices or people in Kansas City last summer, was that the bill seems to be working down there. I can't recall off the top of my head the number of cases where payments had all of a sudden been kick-started, but it did seem to be generating some positive developments down there. So whether it'll go anywhere next year, who knows? But it didn't. The idea didn't originate here in Nebraska.
Thanks for that, Bill. And Bill obviously knows a thing or two about child support for those of you who know him and miss his listserv posts. So he knows a lot about child support, and I will say there were some other folks who said this. There were some people who were also behind this bill who liked the idea of maybe they were concerned that the person who was receiving the child support really didn't spend it on the child. So even though they were behind, at least this ensured that if they put it in a college savings account, it definitely was going for the child since it has to by law. So. LB 338 did not make it out of Judiciary Committee. This was to add a docket fee for paternity determinations and parental support proceedings. It would have created a docket fee of $65 to be collected for each paternity determination or parental support proceeding. It didn't get pushed through. What I would say is the bill did not really, what we saw was the bill didn't provide clarity as to whether this fee would be in addition to all the applicable fees set forth under these statutory sections, which are all different. Some of these fees go to the Parenting Act, so there are fees. So people are like, wait, there are fees for these actions charged. Well, they wanted to create another one, perhaps a revenue producer, perhaps there wasn't enough money going to cover state costs, but they wanted to create this. It didn't get out of committee. The next law also did not make it out of committee, but I suspect just because of the subject, the nature of the subject, and I mean, it's one of these bills. It was for a change in paternity provisions for a child conceived as a result of sexual assault, and I think most people kind of feel like it's one of those issues. If you can't get behind something like this, then what does that say? But what the bill said was, if you were convicted of sexual assault under these two sections, for purposes of in a termination action where it says the state always has the purpose of reunification of family, we would not be trying to have a reunion with the family, and this person's right would essentially be terminated just automatically by virtue of the conviction. So it didn't make it out, but again, I suspect that there will be a push, and a fairly strong push, to get it through again. But the conviction would be considered conclusive evidence that the parental rights would be terminated unless the biological mother or the guardian of the child found that terminating the father's rights would not be in the best interest of the child. LB 415 was change provisions relating to the Uniform Interstate Family Support Act, UIFSA. Congress apparently finally got around to ratifying the Hague Convention, which is the international treaty with which all Western European and many countries across the globe are members of, on international recovery of child support. So if you've, Bill McKenzie could certainly speak to this too. It's a big statute that talks about child support enforcement units, that allows child support enforcement units across all the states working hand in hand to recover child support. This would basically add references all throughout the statute referencing foreign countries being considered states and so forth for purposes of collecting, and it allows, so it would allow foreign countries to help collect child support here and vice versa. And that was approved by the governor and immediately, and became operative immediately back in April 29th of 2015. This act, LB 497, was an act relating to the distribution of marital assets. Is Kent Schroeder here today? Okay, well, he posts a lot on the listserv too. I think he had a post last Friday of usually Fridays are my gripe session, and he just kind of posts his gripes. Today he'll be acknowledged because he was the appellant in the case that I referenced earlier that Steve Floodman will go over. But he actually prepared this bill. He mentioned on the listserv that he was really irked that, I think he said we were the only state that didn't essentially do equal, just 50-50, just equal distribution of the marital estate. and that everyone knows that 99% of the time that's what we do anyway, so why do we have this statute that allows for an equitable distribution, which could be anywhere from 2/3 to 1/3. He prepared a bill. He had gone to a senator and proposed the bill. The bill that he wanted, he later said proposed, was not the one that got proposed. So I've attached the bill to the materials that he actually prepared himself, and I think he's going to try to get it considered again. But it just basically said that in most cases, 50-50 is going to be divided equally, and if you do something less, you need to provide a reason as to why you're doing something less. But it just explicitly would say, let me get to it here. Well, I think that just about said it, that if they did something less than 50-50, there was a set of factors that they had to consider, and they would have to provide the reason why they did it less than that. And I think a lot of us do get a little frustrated, although I think most of us would agree that it's pretty rare when they do something less than 50-50 division of the estate. LB 502, we'll be wrapping up here soon. LB 502 was just a legislative intent statement to create a family court pilot project. It did not get out of committee, and it may be considered again. I think a lot of people's comments were that they could get behind the idea of a family law court where the judges and everyone is really knowledgeable in the area of family law. The problem was that it was a very short legislative intent statement, but there was this language where it said the legislature finds and declares that the family court programs are effective in keeping families who participate and compete and complete such programs together. So a lot of people read that and thought, is the state trying to do do mandatory marital counseling again? And they weren't. It was, I think, just an inartfully placed sentence that gave that impression, but it definitely soured everyone's reading of that, I think, so it didn't go anywhere. LB 566 is changes to the Indian Child Welfare Act, also referenced earlier this morning, ICWA. It provides that, and this was approved by the governor on May 27th and also became effective immediately. It provides that the determination of paternity by a tribe shall be given full faith and credit within state courts. As you may or may not know, tribes are considered these semi-dependent domestic sovereign nations. So this effectively just said, as this semi-sovereign nation, when these actions come out of their court, these paternity determinations, they'll be given full faith and credit in our courts. There are some other things that this act did. I know not a lot of people in this room probably work with ICWA, so I'll just let you read it, but those were the main changes that the law added. LB 648 was to provide for an adoption by 2 adult persons. It did not make it out of committee. It may be considered again. But this provided that any minor child may be adopted by any adult person or 2 persons regardless of marital status. It also provides any parent of the minor child that any parent of a minor child may consent to the adoption of the minor child by a parent's spouse or by another adult who will share parental responsibilities. I think most people would recognize that at least part of this bill was to address inequities in the adoption statutes that didn't allow same-sex couples to do step-parent adoptions or jointly adopt. But I think with Nebraska's libertarian background too, I think the hope was seeing, what if I just don't believe in the institution of marriage and I want to live in sin for 50 years? Can't we jointly adopt, or do we still just have to do one single person doing the adoption? Because the adoption bill as drafted would have prevented that as well. So this was an effort, I think, to serve both of those intents. The recent decision, the recent SCOTUS decision, obviously took care of a big part of that. So if this comes back, I think it will come back in a different form where we're just perhaps changing some of the language, but it no longer needs to be passed for the purpose of same-sex relationships and children. LB 416, which was to change provisions relating to the transfers of property upon death. This did not make it out of the Judiciary Committee. It may be considered again, and I will tell you that this was a bill that was being looked at not only by the family law section, but also by the estate planning section. And the reason for was it would have provided that, except as provided by the express terms of a governing instrument, a court order or a contract relating to the division of marital estate, so we're talking about a divorce decree, would basically revoke the beneficiary designations that people had attached to whatever kind of financial plans, insurance policies, things that have beneficiary designations. This would basically apply to the forgetful spouse who forgets to take their now ex-spouse off the life insurance policy, the 401k, a payment upon death designation. The problem is that the law would have treated these matters differently if it was under an ERISA-based plan or if it was not an ERISA-based plan, because ERISA was going to follow federal law, and federal law says under ERISA you got to follow whoever's on that designation. So the concern about the family law section and again the estate planning section, they were behind this, they disagreed, but the consensus apparently was we like to have uniformity and have all the assets treated the same. We wouldn't want some assets, some plans being given this treatment while the ERISA-based plans go to these parties. So I don't know where this will go, but it's sort of interesting. And I'm sure no one saw any debate, conversations that occurred on the listserv earlier this year about a Parenting Act bill that was pending before the legislature, and didn't see any arguments or people getting on soapboxes about studies of what this study says about parenting time and what this study says. But anyway, the bill that we're referring to, LB 437, was to change the Parenting Act, and this did not make it out of Judiciary Committee. It was indefinitely postponed. If it would have gone into law, it would have changed the Parenting Act in several ways. The one that got the most attention was that it provided that in no event would the court adopt a parenting plan in which one parent has less than 35% annual parenting time unless specific findings were specifically provided as to why they weren't. So it created not an entire presumption, because 35% under our current laws do not amount to de facto joint physical custody. But I think one of the concerns of the people that were working on this bill, that were involved in this bill, was the child support guidelines, which changes are going to come one of these days. The Child Support Commission had met. They were ultimately proposing pretty significant changes, more significant changes I think than we've seen in a long time. And some of the changes would have lowered the threshold if they're adopted, and we still don't know. They would have significantly lowered the threshold for what is considered joint physical parenting time, such that I can tell you that had they adopted those suggestions, 35% would be joint physical. So I don't know if that provided people from stopping to adopt these, but it didn't go anywhere, and this was one of the major concerns. The court would also be encouraged by the statute, not required, but encouraged, to adopt a parenting plan that provides for joint legal and maximizes the time of each parent, and also, I believe, discussed you could even break up decision-making and parse out medical decision-making with one parent and school decisions with another parent. It also, I think the bill did do some good things in that it added some specific best interests of the child in terms of what the best interests of the child require. And I mean, I could go through and just read these to you, but I think they're self-apparent, self-explanatory. The best interests of the child factors, I think, are the most significant at the bottom of page 9 here. It said that basically when parenting time, you got a custody case and you're putting on your evidence, the court should specifically analyze these factors. So as you may know, when we have a removal case, we have a whole body of law that says there are special best interest factors you need to look at when it's a removal. So that effectively did that. That's what this would have done. It said when you're looking at custody, if you look at the state statute that provides for the best interest of the children, I think you guys know there's about 80 factors, and it says the best interest of the children shall include but is not limited to. And what that means is know your judge, right? This would try to provide a little uniformity. The factors were pulled out of case law to say every court should be looking at these factors when determining the best interest of the child. It also added that they should be looking at a couple things of note. The geographic proximity of the parents, credible evidence that a parent has knowingly made a false allegation of abuse or child abuse or neglect. I think the idea there is if someone's willing to do that, that's probably not a parent that's going to be supportive of a relationship with the other parent. And then there's also the court should ascertain and take into account whether there's been credible evidence that the parent has interfered with the other parent's access to the child. And that if the parents can't agree on a parenting plan, I think most people provide a proposed parenting plan, but not everyone does. This would require everyone to provide one to the court as basically a suggestion to the court. It also provides, which obviously the court doesn't have to do now, that they shall, when rendering decisions regarding the parenting plans the court created, that they would have to provide written findings of fact and conclusions of law. Again, I think there were a lot of people who said, I get a custody ruling and the judge just didn't provide any findings, basis for decision. So I sure would like to get inside the mind of the judge, and it would help with the appeal, perhaps. And it would maybe provide some invisible hand of accountability to the judges, for the judges maybe who are de facto going too much one way towards one parent or the other. And it explicitly also said that when rendering a parenting plan, the court would not consider the effect a custody or parenting time would have on child support obligations. So this did not go anywhere, but it had a push for a very long time. Some people thought it was going to get out of committee. What I would say is, I think in each of the last 3 years there's been a custody bill, and I think what everyone recognizes is some changes probably are coming. There's been changes across the country. There's special interest groups all across the country that are making a big push, and I think the changes are going to, the bills are going to keep coming. So I would encourage you that if this is an issue that's important to you, to get involved in it, because the people who are proposing the bill, drafting the bills, they're not going to stop drafting the bills. And instead of just, if you don't want to see a bill come down that provides for automatic custody to mom or dad, I know our office, Koenig Dunn Divorce Law, we were like, well, what about a bill that's child-centered instead of centered on mom or dad? And so if you care about it, get involved in it, because I think there's going to be a lot more push for it. That concludes the legislative update. I thank you for listening, and we're going to take a 15-minute break, and then we're going to have Steve Floodman do his annual case law review. Thank you. And our next speaker is so kind every year. I don't know, Steve, how many years have you done this?
Over 20, but I'm not sure.
All right.
Too old.
He said he's forgotten he's too old, but he's done this for over 20 years. He has probably forgotten more law than I know. So he does this. Steve Floodman is a partner with Johnson, Floodman, Gwenzel, and Widger in Lincoln. He has been doing family law for a very long time. I think he's uniformly recognized as one of the best family law attorneys in the state. He's, like I said, he's kind enough to go through every single family law related court decision every year and basically provide us an old school law school case summary of it for us so that we have it in our arsenal. So with that, I'll introduce Steve.
Thank you, Philip. First of all, I don't know how many years I've been doing it, but it's been a long time. I want to thank Corey Wasserberger, who's now a partner of mine. He is primarily responsible for doing the written materials with the help of Adam Little, who should get some thanks as well with Blue Cobalt, who I think worked with Corey on some of the appellate cases. Obviously, with 73 pages of materials, I'm not going to be able to give you a clear and concise factual description of each and every case. My primary goal will be to give you what I think may be important from the case, and some of them will require reviewing the factual portions of the case. I was going to tell a joke, but on the way up, Corey admonished me that perhaps I shouldn't do that because he's heard too many of my jokes over the time period, and he wasn't sure that it would be an appropriate one. So I'm going to dispense with that. However, first and foremost, and this is not covered in my outline, but we talked about recent developments in family law. This morning, the Nebraska Supreme Court came down with the case of Coufal, C-O-U-F-A-L versus Coufal, 291 Nebraska 378, in which they made a ruling that I have felt should have been made for the last 10 years, but have not. And that is that a retirement plan that is brought into the marriage is premarital, which we all knew, but the increase in value of that plan is also premarital and is not to be considered marital property. To me, that should have always been the case because I can't see where the passive appreciation of a 401k plan should be treated differently than the passive appreciation of an 80-acre tract of land. And that's essentially what the case said. But if you have a case of that nature, you definitely want to go read 291 Nebraska 378. That was Kent Schroeder was the appellant in that case and secured an overruling of the lower court's finding that the increase in value is marital property. With that, we'll get on to the outline. Corey is going to scroll through the cases so that you'll get the site and the name of the case, and I won't have to spend a lot of time with that. My first case is a case where the lower court, Mr. Flores Guerrero, filed to secure a modification of custody. The lower court granted he and his former wife joint physical custody, and she appealed. The Supreme Court reversed the lower court, and the key to the case is that Ms. Flores argued on appeal that the lower court had failed to follow the mandate of 42-2932, which requires when there is evidence of abuse or intimate partner abuse that the court is required to include in any parenting plan or decree specific language as to how to protect the victim spouse or the child. And in that case, Mr. Flores Guerrero had been convicted of third-degree domestic assault, and the record contained the evidence of that conviction, the affirmance on appeal, and Ms. Flores had testified that she was the victim of the abuse. Mr. Guerrero argued that, well, 42-2932 shouldn't apply because any abuse or the conviction was prior to the divorce decree awarding custody to the mother. It was before all that, and therefore it shouldn't apply. This case stands for the proposition that timing of the abuse doesn't matter. But what it says to me is, I think we all need to be a lot more careful, because I don't know about you, but in about 1 out of 4 of my cases, there's probably some type of intimate partner abuse or protection order violation, something like that. And if you want to be careful that on appeal your decree doesn't get reversed, there needs to be something in the parenting plan that addresses it as suggested in 422932. In Schwartz versus Schwartz, the court granted custody to the minor child to Paul and ordered Christy to pay child support. The court ordered Paul to maintain health insurance for the benefit of the child, and that was never modified. About 12 years later, Paul moved to modify the decree, alleging that income had changed and asking for an increase in child support. The lower court raised the wife's child support obligation, but gave her credit for an obligation for a subsequently born child. And also, she had produced evidence that she was carrying health insurance on the child and the cost of the additional cost to carry that insurance. The lower court, in its order, set support, granting her a credit for child support for other children and allowing her a deduction for the health insurance premium. Supreme Court reversed, giving credit for the health insurance. Because what the court said is the initial order ordered Mr. Schwartz to provide health insurance. There never was an order that she carry the health insurance, and absent an order, she wasn't entitled to the deduction for the cost of that insurance. And I know I've had that come up more than one time, so if it does, you can point to this case. The court affirmed the lower court's granting her a credit for an afterborn child, citing the guidelines that say it is appropriate to as a defense to an increase in child support to use your support for an afterborn child. You can't use it to get a reduction, and they quoted the language from the guidelines. In this, in the appeal, the appellate court said that she had provided the lower court with sufficient evidence to make a determination as to what credit would be appropriate. And they suggested the guidelines make it pretty clear that there isn't an exact way you go about doing it. If you're reasonable and if it's based on sound reasoning, it's appropriate. Christy had provided evidence of her income, her new husband's income, and a basis for the court to do that. So that part of was affirmed. One thing that the case did not discuss, and I think it's still an open question, and that's what do you do if you have someone providing health insurance for the first child and the second and third with a different spouse? How do you attribute, because it's X amount for all additional children? And I've talked to Judge Merritt in particular, and he said, well, what he would normally do is if there are 3 children and there's only one in this action, he'd divide the cost by 3. And I think the guidelines in the court have given leeway to the lower court to figure out how to do that. And as long as it's a rational basis, they'll probably approve it. The Stacy M. versus Jason case is an interesting case. There was a divorce action. Father had 3 children and was ordered to pay child support for the 3 children. Sometime later, the father found out definitively that he was not the father of one of the children. I was the second child, perhaps. And the problem was he loved the kid, he treated the kid like his own, and he made it clear that that would never change. He wasn't about to try to disestablish his paternity, so I'm assuming he went to the lawyer and said, what do? I don't want to pay child support. This is my child. Well, they tried a novel approach and brought an action in equity to suspend child support. Clearly, Jason was not the father, but this court emphasized that he could have filed an action under 43-14-12.01 to disestablish his paternity. Whether he would have been successful is another issue, but the court wasn't about to give him his cake and let him eat it too. In other words, he couldn't continue to act like dad, treat the child like dad, who, by the way, did not know he was not the son of this gentleman and had never been told that. But the court found that there was no basis for suspending child support in an action such as that, because Jason repeatedly made it clear he did not desire to disestablish paternity, but simply wanted to suspend his child support obligation. Then we've got Johnson versus Johnson, which I had to make a little diagram for myself to try to figure out what had happened, because you've got a lower court ruling, then you've got the Court of Appeals, and then this appeal, which was on further review from the Court of Appeals. This was a situation where originally Elizabeth was granted custody of the party's 2 children. That was in, I don't recall the exact date, but he was ordered to pay $3,000 a month child support, and she received a rather tidy amount of property as well. Mr. Johnson was considerably older than his wife, and he was also receiving Social Security benefits as a result of his age, and I won't suggest that I might be, but that's possible. In any event, no one pointed out to the court that the children were eligible for benefits at all. Subsequent to the entry of the decree, which was by agreement, he filed an action for credit for the Social Security benefits toward his child support obligation. But at some point, he chose not to pursue that and instead pursued a request or an intent or application to try to get the court to set aside the entire decree based on no personal jurisdiction over him, which he failed to do. There was an issue. Ultimately, at some point, the parties agreed to share joint, a year or two later during the process, they agreed to share joint physical custody of the children, which obviously would result in a different amount of support. But there was an issue regarding earning capacity. Essentially, there were 4 issues in the case. One was, what was Elizabeth's earning capacity? 2 was, should he receive a credit for $63,000 worth of Social Security benefits the children had received to that point? Whether the court could give credit on future child support owed for an overpayment during the year or 2 that this was pending, which was a fairly substantial amount of money. And further, because even if the court gave him a credit based on the ages of the children, the amount he was asking for would run out, and he would still have overpaid by $30,000 or something like that. The lower court looked at the earning capacity issue. The only evidence before it essentially was that the wife hadn't been working, but had been a co-pilot or something at one point, testified that she had been offered her old job back, I think, in California at $18,000, but that would require her to go back to school, probably $10,000 to move, and really wouldn't work with joint custody. Some indication that maybe she could find something in the area for $15,000, $20,000, but not a lot of evidence. The husband was in the airline industry, and he said, well, you know, I'm not really an expert, but I've got a lot of experience, and I'm just sure she could get a job at $60,000 to $80,000. And he asked the court to use $52,000 as the wife's earning capacity. The lower court bought into that and used $52,000 as the wife's earning capacity. The lower court found that he should not receive any credit for the Social Security benefits since that issue had not been raised at the time of the original action. I think we got to be careful not to read into this case that a credit wouldn't have been appropriate, because I don't think the case stands for that. I think the court will look at Social Security for the children similarly as to how they look at Social Security benefits in disability cases, and there are a number of cases on that. What the court said is, look, you agreed to pay $3,000 a month, knowing you were receiving the, nobody brought it to our attention, and therefore you can't now, after deciding to abandon that in light of trying to get the whole thing set aside, you're not going to come back now and get credit. The court gave him a credit for overpayment for future child support on his future obligation after, of course, lowering it substantially. He had continued to pay the $3,000 for 18 months or something like that. In addition, the lower court figured out what the child support would have been and how much was left, and entered a judgment against Elizabeth for, I think it was $20,000 or $30,000 to take care of the overpayment that he had made. The Court of Appeals reversed the earning capacity finding, affirmed the fact that there should be no credit for the Social Security payments, but reversed the granting of a credit for overpayment for future child support, analyzing the Grease case, G-R-I-E-S-S, which is an earlier case that talked about if you make gratuitous overpayments, you may not be entitled to a credit for those. The Court of Appeals likewise reversed the granting of a judgment against Elizabeth. Essentially, on appeal, the Supreme Court adopted the reversal of the earning capacity, the not granting credit for Social Security, but they found that the Grease case really wasn't applicable here, and they reversed, finding that he was entitled to a credit for overpayment towards his future child support obligation. They did find, however, that it is impermissible to provide a judgment against Elizabeth, that would not be permissible. And they talked about the lump sum child support payments and how it would be impossible to know whether child support would have been increased or decreased during the remainder of the period. So they reversed that portion and said it was inappropriate to grant a lump sum judgment against Elizabeth for the balance. I think the Johnson case is important also in that the court talked about granting a retroactive modification, and how the general rule is that you do that to the month following the filing, which in this case was close to 2 years. One of the reasons that the Supreme Court found it was appropriate to give him a credit for the overpayments is he'd made numerous efforts during that 2-year period to lower his child support. He'd filed 2, 3, maybe 4 motions to abate, to temporarily reduce, made a number of applications with the court. In addition, the former wife there were several indications that she had really been dragging her feet. At one point they had reached an agreement, and then she backed out on that agreement. And so the court said, looking at all those things, he should not be penalized. Oh, I think also there was a judge that changed judges that caused some delay. And they said, all of these things together are a basis for making this retroactive and granting him a credit. Then if we go to Despain versus Despain, I call that my de minimis case. We're talking about a case involving about $5,000 maybe or something like that that's getting appealed. The lower court granted Abigail a judgment. They'd only been married a couple of months. I think this case is important for a couple of reasons. One, the Abigail had used premarital money to put down on the house and to pay the closing costs and a couple of other things, about $6,000 worth. The lower court announced its decision by sending an unsigned journal entry to the attorneys saying Abigail gets credit for roughly $6,000, let's say, for the money that she brought into the marriage on the house. And the balance, the house had sold prior to the trial, or the balance will be split evenly, and sent that to, I believe, Williams' attorney, or no, to Abigail's attorney, and said do a decree. At some point, Williams' attorney, no, excuse me, Abigail's attorney, I may have that mixed up as who was to do it, but anyway, there was a motion to alter or amend the judgment filed before the decree was actually entered. And I think that was filed by Abigail's attorney to point out to the judge that the way she divided it wasn't proper, because the decree provided that was entered eventually provided that Mr. or William was to pay back $5,000 or something like that, give her $5,000, and that the parties had already divided the $12,000, so each of them had $6,000. And I'm off a little bit on the numbers. But in any event, on appeal, there were really two issues. Probably by far the most important issue is William attempted to have the appeal dismissed on the suggestion that more than 30 days had run from the entry of the decree when the appeal was filed, and that the motion for new trial that was filed prior to the entry of the decree. And therefore, the appeal was filed about 30 days, 28 or 29 days after the ruling on the motion for new trial, but substantially more than 30 days after the decree was entered. Supreme Court found and pointed out that there is a savings clause now, as of the last several years, that it's 25-1141. And 25-1141 says that if a motion for new trial or a motion to alter or amend is filed after the decision is announced, but before the order or judgment is entered, that shall be considered as filed on the day of the order or the decree after the decree was entered, but on the same day. And so the savings clause was a protection here. And the court also discussed what an announcement of the decree was, and they said, well, an announcement of decree might be an oral ruling from the bench, it might be a letter, it could be an unsigned journal entry, and there could be other things, but basically when the judge announces the decision, if a premature filing of a motion for new trial, there's a savings clause now. Before that, there was a savings clause if there was a premature filing of a notice of appeal, but it didn't include filing of a motion for new trial. Now there's both. Judge Counsel admonished in a concurring opinion, admonished attorneys to understand that if you're going to be relying on the saving clause, you better make sure that the record includes some evidence of the announcement of the opinion and when that occurred. Supreme Court overturned the division that the court made, said, well, what they did, they didn't divide, the lower court didn't divide it correctly. What the lower court should have done is take what the parties got from the sale of the house, which was, let's say, $12,000, it was approximately that, subtracted from that the $6,000 that Abigail had brought into it, and divided the rest, which would have meant she would have received $9,000 and he $3,000. And the way the lower court did it, she actually benefited a couple $1,000s from the appeal. I just wonder what it cost her to take the appeal, if those things were really worthwhile. In Anderson versus Anderson, this involved a marriage of 4 years. Mr. Anderson got on the internet and found him a Philippine bride. He went over for a 10-day period. The bride ended up pregnant, and a year or two later they got married, and he brought her back to this area. Olive, which was his wife, gave birth to the daughter in the Philippines, and Wade did provide some support there and also brought her back. Wade was making about $30,000 a year, and her income was under $10,000. They'd been married about 4 years. The evidence was that Wade testified that they were getting along pretty well, but then things waned, and she had an affair and was pregnant with another man's child. Interestingly, in the discussion, and I don't want to make too much of it, but if you read the decision, and there must be more to it than what the decision says, but it said, well, the parties stipulated the second child was not Wade's. I hope there was more than just a stipulation, because the law is pretty clear that parties can't bastardize a child. So maybe there was an attached DNA testing or something like that. Yes? Was it? Was that part of the evidence then? Okay. I assume there might be more than that. My concern is when the Supreme Court simply talks about stipulating, that they're giving perhaps a false impression that that's enough, and it isn't. Anyway, the lower court used minimum wage for Olive, which would have resulted in, it gave custody to Wade in a divorce decree, ordered Olive to pay $50 a month rather than $169, which would have been the amount required using minimum wage, ordered Wade to pay 60 months at $600 a month for alimony, ordered the parties to alternate the exemption for the trial, and ordered him to pay $4,200 towards his wife's attorney fee. And he appealed that, particularly arguing that there was no reason for the deviation and that the court hadn't sufficiently announced its reason for the deviation, and that obviously paying $600 a month for 60 months was a rather burdensome amount since he had only been married for 4 years. Supreme Court affirmed all of the lower court decision with the exception of the alternating of the exemption. In doing so, the court said, well, the lower court had made a sufficient finding that a deviation from $169 to $50 was appropriate based on her financial circumstances and other conditions, and that would be sufficient. The court also suggested that it was appropriate for the lower court to have relied to some extent on an affidavit of support, I-134, which is an affidavit that Wade had signed agreeing that he would provide support for his fiancée on bringing her to the United States. Court went on to discuss why they believed that the alimony was appropriate, talking about how Olive didn't have a degree, had been promised that he'd help with her education, she had left her family, she had no support system, And I think this case goes to why I'm not so sure I'm in favor of guidelines and alimony. Every case is different. Every case, there are different nuances. You know, normally you would never get a 5-year alimony award, but here, this is a lady from the Philippines with no education, basically no job, very little job, and in this case, it may have been appropriate. In Binder versus Binder was an interesting case. We had a couple of old fogies, they're 95 and 94, and they got themselves a divorce because Ma's in the nursing home. And she'd been in the nursing home for 2-3 years and had used all her money. And Dad, she had about $3,000 a month in income between Social Security and some minimal retirement, but her nursing home bill is nearly $6,500. Mr. Binder, perhaps more concerned about his inheritance for his children than his wife in the nursing home, was sought to get a divorce. The lower court entered an order of spousal support, basically the amount of the unpaid nursing home bill every month. And Mr. Binder appealed, saying that was excessive and terribly excessive, and this was Judge Bryan because his income was only about $2,500 a month. I could be off a little bit. It was $2,700 with his Social Security. And then he received he got some money off of a trust that owned $550,000 worth of land. Anyway, he appealed, and the appellate court affirmed the decision. And from this court, well, there are a couple things that they pointed out. First of all, they said, you know, this land, this $550,000, $600,000 worth of land was premarital land, and the wife had no interest in it, but certainly the court can consider premarital assets or income from premarital assets in setting support. The court obviously found as well that Mr. Binder was substantially under-renting the land to, I believe it was his daughter and son-in-law. He was getting $100 a month for the land. It probably could have got double or triple that. But they pointed out he likewise could have sold some of the land. You know, at $5,000, $10,000, $15,000 an acre, he probably wouldn't have to sell too much. The other thing that the court talked about is the fact that these were two folks that were a little bit hard to, they both must have testified. It appears they testified in open court, but they said that the record showed that their communication and the judge's ability to figure out what was involved was a little bit hampered by their age. And so if there's any case where we follow the admonition that we give credence to the lower court, they've seen and heard the witnesses, this would be one that would really fit that mold. Schrog versus Spear is a very strange case where we have a lower court opinion that was reversed by the appellate court, and the appellate court on further review was reversed by the Supreme Court. In this case, the mother, Lillian Schrog, had a child with Mr. Spear, and over a period of several years, she fashioned herself to be a folk singer, and whatever it was she was doing, she wasn't paying a lot of attention to her daughter, Ember, because Ember ended up for a period of years living with her mother, Mr. Spear's parents down in Kansas, and at the time, at one point, she moved then to Iowa with the child without permission of the court. There'd been a decree here in Nebraska. She moved to Iowa without permission of the court. That case got settled, As part of that settlement, it was agreed that she could move, I believe, in Kansas, Missouri, or Nebraska, and that Nebraska would maintain jurisdiction. The stipulation specifically provided that, and it's important to know that Mr. Spear lived in Kansas and had lived there continuously in Kansas. Well, shortly after the settlement and the order continuing custody with her and providing for parenting time, Mr. Spear had his summer visitation, came back with the child, and they met in Iowa where they exchanged the child, and a day or two later he got a telegraph or an email or something saying, oh, by the way, I've moved to New York, and it'll be in the best interest of your daughter. And so once again he filed a complaint to modify custody, which was heard by Judge Burns, who found that Ms. Schrag had no legitimate reason for moving to New York, and it wasn't in the best interest of the child, either one. The Court of Appeals, and I think she'd been there nearly a year by the time the case got tried. Hal, I think, was involved in the lower court decision, so he'll remember a little closer, but something like that. The appellate court reversed the decision to everyone's unbelievable, remarkable surprise, and on further review, the Supreme Court reversed and reinstated Judge Burns' order granting custody to Mr. Spear. And what you have to understand is the court found that there really wasn't a legitimate interest to move, or legitimate basis. When you got two factors, is there a legitimate reason for the move, and is it in the best interest of the child? In this case, if you have that, it goes through all of the factors to consider in Farnsworth and all that, so you got that. But essentially, the facts are a bit surprising that there'd even be an issue about who would have custody. She went to New York to meet a guy who she'd known a couple months, got divorced in Iowa. Within a month or two, she was off to New York, living with a guy who was 20 years her senior. She had no job. She admitted that she didn't know what she'd do if he kicked her out. Oh, by the way, he was married as well. His divorce wasn't final. She hadn't given notice to the father that she was moving. And even though she had just gone through an action, so she clearly knew she had to have permission of the court, she didn't get that either. And so it doesn't, at least doesn't surprise me, and I'm sure it didn't surprise Hal, that the Supreme Court overturned the lower court granting custody to Mr. Spear. The court did touch on the fact that neither of the parties lived in Nebraska, but they suggested that because the original order was here and because the parties had stipulated in the earlier case that any modification would be heard here, that that was certainly appropriate. They also talked about the fact that although the child was doing well, it would be inappropriate to consider the most recent evidence that would have been gathered by her surreptitious move to New York without permission of the court, similar to the type of language they used when they said we discourage granting temporary custody or temporary permission to move because that's unfair. Once you've done that, it's hard to rescind it. So they didn't pay, they found it wasn't necessary in order to prevail for Mr. Spear to find that the child had suffered any harm, that they looked at, there was no legitimate basis for the move, and it wasn't in the best interest of the child, either one, to remain in her custody. Her lack of judgment considering those issues and her going without getting permission of the court were enough to justify the change of circumstances. The original order very specifically provided that she had permission to move to Iowa, Kansas, or Missouri. Is that correct, Hal? So I think with that kind of an order, clearly you would have to, and I think if you're going to move, I mean, maybe I'm wrong, but I think you need to get permission. Don't you, Hal, if you're moving a different distance, a different state? Right, I think you do. Right. Husky versus Husky will actually be changed with LB 219 that Philip talked about. Basically, that was a case where a mother who had gotten orders to go to Georgia filed for permission to take the kids to Georgia. The lower court had originally granted temporary custody to the father. After a trial, however, he found that I think somebody must have done some research and realized that 4329.29.01 that if the orders to go to Georgia were for less than a year, that the court couldn't change the original order. If she had had the military orders prior to the request to modify, they couldn't modify unless the father prevailed and made it very clear with substantial evidence that it was his burden to show it wasn't in their best interest. And after a trial of, I think, 2 or 3 months into her deployment, it looked like, found that she should have custody and permission to move to Georgia. Mr. Husky appealed, and the court found that, well, this is a temporary order, and under 25-1902, you can't, it's not a final appealable order, and therefore they dismissed the case having no jurisdiction. I think LB 219 probably changes this case. I mean, it makes it a little different. There may be other factors, but you just need to be aware if you have a military case, there is specific legislation that may make a modification much different than in the normal case. Ryder versus Ryder. In the Ryder case, the parties entered into a property settlement that Mr. Ryder he was going to get the family home, and the wife was going to purchase property, a piece of real estate on Ash Street, and the agreement was that he would bring it into marketable condition by a certain date and assist her with securing financing. Now, Mr. Ryder brought a motion to vacate and modify the decree under 25-2001, suggesting that there was a real conflict between the two of them about what assisting in securing financing had been. They had gone rounds. He was not willing to put his name as a co-signer on the mortgage, and he wasn't willing to assist with an additional down payment that the bank was going to require to make the loan. Now, the problem is the purchase agreement had allowed them to make improvements, so he'd sunk $20,000 or $30,000 in the property. And so he went ahead, after the wife couldn't get it or chose not to get this property financed and purchase it, he purchased it. He then offered her the ability to buy it from him on a mortgage. He would carry the note, and she would pay him what he was paying. She chose not to do that as well. The lower court granted his request to modify the dissolution decree. Court concluded that his obligation to assist Deborah in obtaining a loan was too vague to be enforceable. And that was appealed. Ms. Ryder appealed that, and the Supreme Court said, when you voluntarily enter into a property settlement agreement, which is approved by the court and incorporated into a divorce decree, its provisions will not thereafter be vacated or modified, absence, fraud, or gross inequity. That certainly ambiguity is not a basis for modifying the decree. Court can't selectively vacate a portion of the agreement on the basis of ambiguity. A property settlement agreement differs in this respect from a mere contract, in that a contract may be deemed unenforceable due to a lack of definite terms or mutual understanding between the parties. When ambiguity arises under a decree, the court must be asked to resolve the issue as a matter of law in light of the evidence and language of the agreement. The Supreme Court remanded the case to the lower court to determine whether he had satisfied his obligation to assist, and in doing so perhaps suggested that in their opinion, assist didn't mean sign on the loan, put down money for the down payment. So that the one thing about that case, though, I think as practitioners, we all need to be a little bit more careful about, drafting language more precisely. What does assist mean? Does it mean he will agree to pay a portion of the down payment? Does it mean he will sign as a co-signer on the loan? That could have been more properly put together at the initial stages. Whitesides versus Whitesides is an interesting case in that the parties agreed that they owned 6% interest in a partnership known as 2020 Partnership. And the agreement was that they had offered for sale this 6% interest to the other partners at $60,000. And if the partners bought that, then they would simply divide the money. But if they didn't buy it, that they would just split their interest, and the wife would receive half of the money generated by that interest. The husband filed a motion to alter or amend the judgment 2 months after the lower court decision, which obviously is past the 10 days that they would have had to file that. So the court said, well, we don't necessarily look at what it's called. We're going to interpret that as a motion to vacate the order. What happened is the husband, the partners said, no, we're not going to pay $60,000, and no, we don't want your wife as a partner. Now, on the motion to the husband filed a motion to allow him to offer the property to sell for $40,000, and the lower court overruled or would not allow that, but made a number of findings. And they're finding, because they pointed out you can only vacate or amend case of gross inequity or fraud, but they made several additional findings. And those findings were that the operating agreement doesn't require existing members to accept a member, suggesting that Dwight assigning half of his interest would be equally untenable. Linda would be entitled to a distribution of profits, but may not have the corresponding obligation in the event the partners elected to make capital improvements. Anyway, the district court made a number of these findings which really exacerbated or made Linda's interest worthless if you actually followed that reasoning. Supreme Court reversed, finding it was a violation of due process to be making all of these findings when all was ever asked for was permission to sell for $40,000. And so this violated the wife's right to due process, and that's discussed in some detail. One thing, though, that I want to point out, and in fact, I'm dealing with it right now in a case. be real careful if you have partnership agreements or LLCs, commercial partnership agreements. I've got a case right now where the offer was, well, we have like these 6 properties, they're generating all this income, we'll offer that we'll just divide them. The wife can have half of them. Well, that's all well and good, but those are partnerships. They're partnership agreements. Are those partners going to want a disgruntled ex-wife as a partner? Probably not. Is there an agreement that says that they have the right to not accept a new partner? Very possibly. What I'm saying is be very careful in entering into that kind of an agreement, that you have a much better understanding of what that partnership will allow and whether it makes any sense. I would suggest to you that it normally may not. It's being pointed out that I need to speed it up. Friedman versus Friedman, an interesting case. The wife, Mr. Friedman lived in Nebraska. I think it might have been in Douglas County. The wife registered a foreign judgment from Colorado, and in doing so, filed an affidavit and sent the notice. Unfortunately, she sent the notice the notice was sent to the wrong address. I suspect it was a typo, although Mr. Friedman suggested it might not have been. It may have been intentional. But in any event, she registered her judgment and then filed a garnishment. And Mr. Friedman got a hold of the garnishment, found out about it, and filed on his own a number of motions to quash, said he didn't have notice, but he also made a fatal mistake. He also asked that the court find that the amount of the judgment registered was not the right amount. He wanted the court to look at the amount. The lower court found that the registration and the garnishment was proper, even though the notice was sent to the incorrect address, and that was affirmed on appeal because even though he was not served, by entering his general appearance, he in essence gave the court jurisdiction. Court held Friedman failed to preserve his objections relating to service when he appeared at the hearing to argue that the amount of the garnishment was incorrect. His participation in the hearing constituted a general appearance, which under 25-516-01 is the equivalent of service. My guess is that it truly was a typographical error, but if not, somebody was fairly clever. Blake, Charlene J. versus Blake G. is a case that talks about the doctrine of judicial or jurisdictional priority. The District Court of Boone County entered a paternity order against Mr. Blake, but no custody was ever addressed in that. Charlene filed a complaint to establish custody in Madison County. The court initially gave her temporary custody. Then after a hearing, during the hearing determined that, well, he didn't have jurisdiction. There was no subject matter jurisdiction because there was a case in Boone County. And then he was going to grant her a request to transfer the case back to Boone County. But at some point before he sent out the judgment, decided if he didn't have subject matter jurisdiction, he wouldn't have jurisdiction to transfer the case to Boone County. The bottom line, there are 2 or 3 things, and I've got to get through some of this fairly quickly. Where a court issues a paternity order, it has priority to issue custody orders unless granting a change of venue. Until a child turns 19, the original court retains priority to decide custody issues or other issues. Although the lower court's dismissal of the case was appropriate, the reasoning was not. Both courts had subject matter jurisdiction, but under the doctrine of judicial priority, where there are two cases, the first case is the one that has jurisdiction, and therefore what should have occurred is the case could have, he could have transferred it back to Boone County. My only question, and I don't know the answer, is why, rather than taking this extensive appeal and spending the money for an appeal, the wife wouldn't have filed in Boone County and paid $150 and refiled. I have no answer to that. Must not have liked the judge there or something. State on behalf of Connor versus Blake G is a case that you definitely need to read if you have a name change case. In this case, both the natural mother and father filed the request to change the child's name from the mother's maiden name. Her request was to change it to her new husband's name. His request, of course, was to change it to his. The lower court, after hearing the evidence, said, well, the court doesn't find there's evidence to change Connor's surname to Amanda's married name. I think that's like a de facto adoption. I'm not going to do that. That would just simply be wrong. Now the evidence here is that Dad has a good contact, natural father, and he's kept contact with the child. There's no reason to be changing the name to stepfather's name. And did grant the husband's request, and the mother appealed. And in this case, the Supreme Court reversed and found that the kid's name had to stay what his original name was. But in doing so, there are several pronouncements that are of some significance. One, no preference should be given to either mother or father. And secondly, there's no preference given to a custodial parent. Mom suggested, and some courts take the position, that as custodial parent you have the obligation to provide what's best for the child, and therefore you ought to have some preference. Court rejected that. The court talked about the 10 factors to consider when you're doing a name change. Judge Miller-Lerman in a concurrence talked about it might be very important to have an expert witness testify about the effect of the name change. Then they said the burden of someone seeking to change in surname has the burden of proving that the change in surname is in the child's best interest. Cases considering this question have granted a change of name only when the substantial welfare of the child requires the name to be changed. The Supreme Court said they couldn't find sufficient evidence that either party had met that burden. Although they did suggest that the lower court's suggestion that this would be kin to an adoption was misplaced, and they failed to recognize, the court failed to recognize that mom's new name was that as well. The Monty S. versus Jason W. case was a private adoption where a couple of neighbors, two neighbors, the one neighbor couldn't have kids and the others felt sorry and agreed they would have a child and then let the neighbor adopt, and it'd be kind of an open adoption. They went and signed relinquishments shortly after the birth of the child, and then, as one might expect, the neighbors started having problems, and the neighbor that got the new baby, that was going to adopt the baby, quit letting the birth mother and her husband see the child. And in litigation, the district court judge pointed out that there is no such thing as the ability to have a private adoption or an open adoption in a private adoption. The relinquishments were vacated, and the child went back to natural mom and her husband and father. They talked about the fact that you can have communication agreements and open adoptions, but that's where the child is placed with Health and Human Services and the agreement is approved by a court. The Supreme Court suggested, I think rather clearly, that they thought this might be an area for legislative change, that it might be appropriate for the legislature to consider this situation, but they were not going to. Okay, Barth versus Barth was a case where the parties lived out in North Platte. Mom moved back to Lincoln, and a few days later, she lived here. They were married in August 2010. Child was born in 11. She moved to Lincoln, filed for divorce. A few days later, husband filed for divorce out in North Platte, and the judges there was evidence that the judges had discussed who was going to hear the case, and the judge out in North Platte apparently drew the short straw, and by agreement the case was heard out there. Dad was granted custody, and he was also granted permission, or he was said that he could allow overnight visitation with Mom if no male was present, that he'd have the ability to make that decision himself. Ordered child support of $305, ordered that the parties share the psychologist fee that the husband had ordered, and then deviated Mom's child support from $600 to $300. I'm off a few dollars, but about half. Mom appealed, first arguing that under the doctrine of judicial preference or priority that the court in Lancaster County should have heard the case. The Supreme Court said no, that would be correct. Both courts had jurisdiction. They did discuss it, so the reason for the judicial or the priority was no longer there because they had agreed and there weren't going to be two cases going at the same time. And so it was appropriate. Either of them had jurisdiction. They also affirmed granting Dad custody and essentially pointing out Mom had many drinking problems. She had been tried to commit suicide. She was living with a guy who had 3 DUIs. She had been ordered not to drink in the temporary order, admitted she'd been drinking. She occasionally had psychotic episodes where she was Joe periodically. So there was a sufficient basis to affirm the custody decision. The court did not found that the lower court had made an error in giving Dad the right to affect parenting time, that it was the duty of the court, not Dad, to make those kinds of decisions, and they could not delegate that decision to the psychologist, to a caseworker, and certainly not to Dad. They also, Dad had appealed the reduction in child support from $300 to $600. Court found that they reversed that finding because Mom had not presented sufficient evidence that would be a basis for the reduction and had not requested a reduction at the lower court, either one. Now, and I know I'm out of time pretty much, but I will point out that the parenting plan of the state of Nebraska, absent parent, says each summer, provided the non-custodial parent provides reasonable notice and advance request to the custodial parent, and the custodial parent agrees with the non-custodial parent's request. Now, that's their proposed parenting plan. Now, if that doesn't provide the decision to the custodial parent, I don't know what does. So I'm not sure that what they're sending out is appropriate based on this case and also the case of Mark J. versus Darla B. at A13394. I think they might want to look at that. Which one? I'm just going to do a couple more here. Let's skip to page 52. In Bonet versus Bonet, father had custody of the daughter and moved from Lincoln to, I think it was Sioux City, about 140 miles away. The mother filed a request for custody, and the mother's attorney asked the court to apply Farnsworth, which is the case for removal, to intrastate moves, pointing out that Farnsworth has been applied in moves of 20 miles from to Kansas, or a lot shorter distance, and it made no sense to not apply Farnsworth for an intrastate move of 140, 150 miles. The appellate court refused to apply Farnsworth to intrastate removals, but suggested that that might be something for the legislature to look at. Rommers versus Rommers on page 57. Elizabeth and Aaron were married. Elizabeth moved to Arizona and filed for temporary custody. She got an emergency temporary custody order in Arizona. Dad then filed for divorce here, and the lower court found that because mom had moved to Arizona prior to the filing, that this was similar to the paternity case of Coleman versus Kaler, and that therefore that Farnsworth determination as to whether she had a legitimate reason really didn't have to be applied. Supreme Court reversed that, saying that for us to, in a paternity case, that may be correct, but with married folks, if we adopt that type of a approach that one of the parties can leave with the children and be gone for a day or two and file somewhere else and get an emergency order of custody under the Uniform Custody Jurisdiction Act, thus making it unnecessary to get an order allowing the removal. 67. Oh, that was a contempt action brought by mother with respect to telephone parenting time. And the court in that case, the lower court found Clayton in contempt for not assisting in reasonable telephone parenting time. And he also decided he needed to modify the order as well, suggesting that one of his proposed modifications was the parties go to breakfast once a month and talk nicely about each other in front of the kids. And they needed to share one joke and one human interest story. Anyway, Mr. Schroeder appealed that decision, and the Supreme Court reversed, finding that the language of what his assisting with the telephone parenting time was too ambiguous for him to be found in contempt, and that the court could not modify a parenting time order as part of a contempt. Now, and I'm done, but Judge Bishop questioned whether the facts of the case would have survived an abuse of discretion standard review if the court had imposed the breakfast meeting as a coercive sanction. Judge Bishop also, and I frankly agree with her, said that she could easily find a sufficient basis for a finding of contempt because the evidence was he would hold the phone out and say, do you want to take the call? And that certainly wasn't assisting, that he they may be ambiguous as to how often or how long or those things, but that his actions clearly were such that he wasn't assisting telephone parenting time. More importantly, she said under 42-364-15, the statute clearly allows a judge to make modifications to parenting as part of a contempt action. And I agree with her 100%. Thank you.
All right, thank you, Steve. The last presentation of the day I'll talk about in just a moment, but before I do, I just wanted to again mention just a few things because after this last presentation, CLE is over, optional reception. I just wanted to point out that the reception, which was going to be held in the atrium, is now literally going to be held in the room that's on the other side of that wall, just to the left of the registration tables. It's open bar, which includes alcohol and beer. So enjoy. And there's hors d'oeuvres from 4:30 to 6. So if you'd like to stop by, we'd love to have you. And if you'll just give us a moment to get set up. The next speakers are going to be Angela Dunn and Bill McKenzie presenting. This was supposed to be on the changes that have been adopted to the Nebraska Child Support Guidelines. As many of you may know, every 4 years the Nebraska Child Support Guidelines are reviewed by the Nebraska Child Support Advisory Commission, and usually the changes are adopted by July 31st. So when we determined this topic, we thought for sure we'd have some changes, but as Bill and Angela will talk about, the changes that were recommended were pretty substantial, and we're still waiting for the Supreme Court. So instead, they're going to visit with you today about both of their experience of serving on the Nebraska Child Support Advisory Commission as the only two attorneys on the commission. So.
No, we're not. We're just going to say we don't have child support guidelines. Let's go home. No, I'm kidding. Do you want us to share this?
Yeah, just 1 second. So anyway, I did want to mention Angela Dunn is a managing partner at my firm, Koenig Dunn Divorce Law. She is also, the third member today between Pam and Steve that is a fellow of the American Academy of Matrimonial Lawyers. And Bill McKenzie, as you know, ran the Child Support Enforcement Unit at Sarpy County for quite a long time. Had probably the most educational posts on the listserv, and now as a result of his new position as statewide referee, had to retire from the listserv, and he'll be missed. I'll let them take it away.
I still read it, though. Is this working? Well, a funny thing happened on the way to talking about the new guidelines. We turned the guidelines, the commission met last summer and last fall. There were 12 of us, and we met, I think, 8 or 9 times. We have a deadline. What? Hold it closer. Maybe I'll do this. Does that work? Okay. People in the back just move forward. We had a deadline at the end of the year to get our recommendations to the Supreme Court, which is set by statute. As Philip mentioned, every 4 years states have to review their guidelines, and they don't have to change them, but they have to at least review them and determine whether or not they're still in the best interest of minor children. So the commission, the setup is contained in statute. We had 2 district judges, I believe 2 state senators, a custodial parent, a non-custodial parent, a representative of the state treasurer's office, the 4D director from the Health and Human Services office, you and me, prosecutor, divorce lawyer. We had good times. It wasn't quite like the Duggars, but in any event, we did a lot. We chewed over the guidelines, as has been mentioned earlier this afternoon. There's been a lot of discussion on parenting issues in social media, in the regular media, letters to the editor and whatnot. And that wasn't our job. Our job was not to address parenting time per se, or whether the judges are fair or unfair in the way they handle custody issues, but we certainly heard a fair share when we had public testimony on two different occasions.
You want me to?
Sure.
So one of the first things, so I should start and say this. The commission hired an economist who had worked with the prior Child Support Commission, and the first thing that she let us know was that we could choose not to make any changes to the guidelines and they would still be economically sound. Is that a fair? So we understood that there wasn't anything fundamentally flawed about the existing child support guidelines. So we then kind of delved into issues that were raised either by the public or commission members, and the first question we wanted to answer was whether or not our existing guidelines should be updated with current economic support and reasoning, because it was, what, 17 or 18 years old. So our numbers had been based on tables from 1990s. We looked at updating those tables, and the commission did make a recommendation that we update the tables to the current data. We also then looked at, should we be making an adjustment in our guidelines to the tables based on the Nebraska cost of living, which is at about, what, 90% of the national average. So the commission also made that recommendation to adopt the Nebraska cost of living into the guidelines. So that was the first recommendation that the commission made, was simply to adopt, and the charts are included in the materials. You can see that the adoption of the updated tables doesn't make very significant swings in the child support amounts. It changes it, but it wasn't a drastic departure or improvement or negative application, whichever way or whichever client you're representing. But I thought the commission had good reasoning around making it specific to Nebraska. So are there any questions about the first recommendation that the commission made?
What regarding the tables?
Huh?
The first
to update the tables.
What we saw, well, first of all, we had the financial ability as a commission last year, unlike 4 years earlier, to hire an economist for $40,000 or $50,000 to assist us. The 12 of us couldn't have done it ourselves and kept our day jobs. So she had a lot of information she brought to us. We asked her specifically to look at our surrounding states and see how our guidelines differed from the surrounding states. And when we were presented with that information, it was fairly clear that Nebraska's guidelines were toward the upper end of what our neighbor states were setting support at for like incomes. I think Colorado might have been the only one higher than us. So and we certainly heard a lot in the public testimony. Individuals said, you're the highest in the nation, you're way out of whack, et cetera, et cetera. That really wasn't true, but we did think that our numbers were based upon, it's about 17 or 18-year-old economic data, and we thought it was time to update that, to go with something more modern. And we went to data, I think, as recent as 2013. There are so many different ways of determining what it costs to raise a child. I mean, every time you turn on the TV, there's some other statistic out there. It's going to cost $200,000, $180,000. I don't know where those numbers come from, but there's so many different ways of analyzing it. And we looked at 3 or 4 basic philosophically different ways of doing that. And we, as a commission, voted ultimately to adopt the one we did, which was going to result in generally lower support figures for especially medium and upper incomes, not so much the lower incomes. There were 5 basic recommendations. We touched on the tables, being one of them that the commission has recommended to the Supreme Court, new tables that generally lower support. But we got to put an asterisk on that, because those changes come with other changes that may mitigate or lessen the amount of that reduction. One of the more possibly contentious issues that we dealt with was child care. Up until now, Nebraska does not include child care in its child support worksheets. Many states do, we learned, and we're maybe an outlier in that. So one of the criticisms of the way we're doing it now is that people who have child care in their families with younger children, they can't enforce that child care provision if there's a problem through the 4D county attorney's offices or child support enforcement offices, because it's not considered a 4D function. Ironically, other states do that, and if a party moves to Nebraska, we are actually now enforcing child care orders in other states for other state citizens, but we weren't able to do it for our own citizens. So one of the recommendations is that we include child care, and it would be treated like the health insurance is. It's going to be prorated between the two parents.
So we spent a lot of time on the recommended language. We pulled from several states that surrounded us. And so if the Supreme Court adopts this, it will require you as practitioners to determine the annual average. And yeah.
I noticed when I was going through the new recommended revisions that we're going to have to determine an average child care amount, but my understanding from most of my clients is once or twice a year a child care provider is raising rates, which would mean we're going to have to go back in there and modify child support every time there's a rate change for your provider.
That's right. Well, that's right, and that is the recommendation. One of the more common, it wasn't necessarily the increase in rates, it was as children age out or summer, and that's why we settled on what most other states do, which is to annualize the expense. So you take into consideration if you're going to have a child age out of a 0 to 2 daycare room to 2 and 4, and so the daycare cost is going to decrease. Parents know that in advance because they usually have set rates attached to age of children. Parties generally know what their summer daycare expense would be, but you're absolutely correct that this will require potentially modification. And we looked at, isn't it, did we finally adopt the affidavit? Parties could.
Yes.
Yeah.
The language is contained in your materials in the guidelines that propose changes. Basically, parents would be looking at coming up with an annual estimated figure for their child care costs, and then also included in their order would be a worksheet that didn't include child care, so that if the child care were to end, the court would have something to fall back on, and the parent who was paying the child support, which would include the child care, could file an affidavit with the court, send notice to the custodial parent, and I believe it's 30 days that parent would have to file an objection to stopping the higher support figure with the child care. So we tried to make it as easy as possible for parents to do that on their own without having to hire attorneys. We realize that child care is fraught with loose ends and whatnot, but other states have been doing it for years, and it was the consensus, not of everybody on our commission, but the consensus in general that was the best route to go.
So it would be similar to in our current orders where you're setting out the support, and as children age out, you're going to have a similar, Judge Noakes and I actually wrote out a proposed order to see if it would work. And it's going to be very similar to that, where you're just going to have to say, this is the cost for 4 kids, this is the cost for 3, whatever it might be, and it will graduate out. Yes?
I noticed when I was going through those revisions that there was no reference to what age a child ages out of childhood. Aren't you then going to have to leave out a difference of opinion between the parents as to 9 years old versus 13 years old? Aren't they going to have to go back and forth and litigate that issue as well?
Possibly. We talked at length about including the age, and most states don't include an age, so we didn't have, I mean, our guess was as good as anybody else's about what would be appropriate. There wasn't any guidance in any of the other guidelines that we reviewed to provide support to us in that area.
Are you expecting a judge to look at it, or are no factors given at all for how this is determined?
Well, if the parents don't agree, that's probably where the decision will be made by the court.
The judge to make a decision when there's been no guidance or the guidelines or visions as to what factors the judge is to consider, and the legislature has to spoken.
Well, all I can say to answer, is judges make hard decisions all the time, and they're guided by the best interests of the child. They may take testimony on the maturity level of the particular children, the circumstances, and whatnot. Hopefully, at least in many cases, the parents may agree on that. One of the statistics we saw was only about 20% of cases involve child care, so the vast majority of cases before the district court won't handle this issue.
And to be fair, those issues already come up. Judges are already having to look at it. You already have parents where they have a 14-year-old and there's a daycare provision. We haven't said in our decree when does it age out. Parties are already fighting over it, and judges are having to make that call. It doesn't change that some parents will not agree about how long daycare or aftercare will extend. And we just simply didn't have information as a commission to make a determination or a judgment on what an appropriate age would be.
Part of our problem was we were limited by the calendar. We had to work and finish our report basically over the holidays. So we did what we could.
Yes.
With respect to the affidavit to let the court know something's changed, was there any discussion about how that gets served? Is this like other actions where it's personal service?
I think it's contained in the...
I think it is spelled out, but we tried to do it similar to how a parent requests an abatement for summer childcare. In fact, I think we adopted very similar language to when parents qualify for an abatement because they've had X number of days during the summer months. We just followed what we had done in similar circumstances. And
It's contained in section 4-214.
what page is that?
Well, it's on page 18 of the, I believe, the appendix. But in any event, or actually in the main part.
The next area that we looked at was the now requirement that parents obtain and maintain health insurance for themselves. So we made a recommendation to the Supreme Court that the cost of the parents' health insurance also be included in the worksheet as a reduction to arrive at your actual net income. Health insurance wasn't required, it is now, so the commission thought it fair because a lot of parents don't have control over how much they're required to spend for their health insurance premium, and it does have an impact on your net pay and your ability then to subsequently pay child support. So that was a recommendation that we made. Adam Astley, who develops the software, came and testified before the commission to answer our questions about, can we do this? Will this be really hard to figure out? And he was supportive in letting us understand where it should come in the worksheet. And so now, as practitioners, we'll need to not only determine what is the amount of the premium attributable to the child or children, but also what is the portion or what is the expense to parents for their own individual health insurance.
Which actually may be easier because you only have to look at the total figure. There was a cap, though, placed on the health insurance plan that the parent may have for themselves. We capped their deduction at 5% of their gross income. There was some concern that someone may buy some, they called it a Cadillac plan. I'd probably call it a Mercedes plan, but we wanted to make it more of a Buick plan. So that was one cap on that health insurance deduction being overly high.
What would you do if the person was providing health
Well, you're going to do what we do now to determine the child. You're going to have HR give you single, single plus family, single plus child. They'll get the single credit. They're not going to get credit for what they're providing if it's a new family. It's the same analysis that we use to determine the child's portion in the green shirt. And then we'll go to the blue.
With healthcare increasing each year, the same caveat with that, childcare increasing every year. Also, remember, not the first of the year,
well, great. I'm glad. That was why you'll also see one of the recommendations to the court was that we increase the threshold amount that modification qualifies. So we increased that from 10% to 15% with the hope that we would think most insurance, like the deduction off of your income, is not going to be so dramatic that it's going to change the child support upward or downward by 15%. And that was one of the reasons why we looked at increasing the threshold. I get you. So in the blue.
A couple things. I've had clients that have situations where, like, they're modifying child support, they've got a second spouse, they've got children, they've got stepchildren, they're all on health insurance plan, they've got through Obamacare, and it's almost impossible because that determine breakdown that whoever's running it attempt to get the answer as to how much it is. It won't get enough risk. It's almost impossible to get an answer how much it is for the dad, how much it is for the step-parent. And then along the same lines, even on regular plans, there's always an issue of the stepchildren. The other parent's going to say, well, yeah, stepchildren are on there. So children in this case, it doesn't cost anything extra. How do you deal with that?
Well, those are issues that you face now a lot of times, and different courts will handle those differently. I don't know that there is a specific right or wrong way to do it. I think as long as the court uses some sort of logical way of approaching that issue, and hopefully the parties will have those figures that they can give to their attorneys or to the court. That's what I used to see as a prosecutor. They would never come into court with the information. They'd say, I could get that for you next week, whatever. Well, the trial's today. But I think that's an issue that basically people are already facing in court. No, they don't. They don't now, and we didn't propose that be changed. One other health-related change that we are proposing is that right now there's a $480 annual, I don't know if credit's the word or offset, that the first $480 paid by the custodial parent on the health care needs of the minor child or children they're stuck with that. Our proposal is to change that to $250. It came up in our meetings as where did the $480 come from, and nobody really knew. It was way back in time. No other state used $480 as a figure. Most states use $250 or something similar, and all the economic studies basically built that $250 figure into their work. And so if we were going to stick with the $480, we were going to have to spend a fortune and take months more time to come up with the new economic data, so we didn't have the time or the money.
We were a clear outlier. There was not another state in the country who used 480, so we thought it appropriate to make a recommendation that was consistent with the rest of the country. Yes?
So you are actually factoring into the new tables $250 per child per year?
No. We're reducing the first 480 to the first 250. No, it.
Oh, okay.
The question was, are we factoring in 250 into the child support amount? The answer is no. So similarly, now the custodial parent, if you're under worksheet 1, pays the first 480 of uninsured medical expenses. that threshold will reduce to the first 250 per child per year. It doesn't change how we're doing things, it just changes the amount. And that was because we asked, yep.
Included an amount that would take care of it.
Well, yes, to that extent, you're right. The tables, the current ones and the new ones, take into consideration that the first 250 or 480 now would be paid by the custodial parent. So in that extent, yes, it's already in there. The one issue that we got the most.
We had two.
Oh, I'm sorry. Go ahead. We have plenty of time.
Yes. Similar to, it's in the same section where they deduct their retirement contribution. So it comes before you're arriving at the net income of the parties.
Right. Well, I guess that's up to the court to decide. It's not, that issue is not specifically addressed in the guidelines.
Yes. Yes.
Well, yes, and what we were told is that other states that have dramatically changed their tables or relatively dramatically changed their tables expected a tsunami of modification actions, and they never came. One thing we decided to recommend, again, as we mentioned, was that you'd have to meet a 15% threshold to justify a modification. Pardon me? We weren't told otherwise. Nebraska is the only state that has a 10% figure. Most are 15 or 20%. Oh, you can file for anything.
Absolutely. We weren't tasked with resolving the court's dockets, and it's still a rebuttable presumption of 10% or 15%. We didn't say it's mandatory. It's similar language. It's the percentage changed.
Now, those were the non-controversial
Yeah, those
issues.
were the easy ones. Yes, Kathleen.
Okay.
I know, we got to get to the good stuff here.
Mom doesn't make any more money, and of course she's supporting the child. She's paying 100%.
We talked about that at length, which is, well, that was the reason that we decided to share the daycare in the calculation.
Okay, the question was, when you have parents at poverty level guidelines and you can't, the non-custodial parent doesn't have enough to pay child care now, and the mom is stuck with the full amount. Is that basically your scenario? Right. Right. Well, you get down to those poverty levels, the court may determine that child care can't be afforded because of the poverty guidelines. And if that's the case, that's the case. And those guidelines keep going up. Or the poverty level goes up every year generally. So the court would not order it in those cases.
But to the point, what we evaluated was the inequity that you described, which is we couldn't go in on enforcement, or you can't do automatic income withholding for the daycare expense. And so if you have parents with like compensation, or even if you don't, if you have the parent who's earning less who's responsible for the daycare, they have to hire a private attorney to go and enforce that. If we included it like several states did, you could do it through the state when you're collecting on your child support. You could garnish. You have other remedies available to equalize the fairness of who's being stuck with the majority of the daycare expenses. That's why it was raised as an issue to begin with. Okay, are we ready for the
Physical custody?
hard part?
Yeah. As I mentioned earlier, we took, I don't know, 30, 40, 30 people or so came in to testify before the commission in, I think it was September. And there was, I think, a bit of an organized group of people that came in. And most of the people that did testify complained about custody, not getting enough custody from their judges on their cases, and we heard all manner of stories. And even if you sift the wheat from the chaff, I think we felt that there was a legitimate concern amongst enough of the public to look at that issue as to whether the guidelines were worded the way they should be in terms of when you look at a joint custody versus a straight custody situation. Right now, if I get the numbers here, right now it's a rebuttable presumption that you would look at. That would be a straight custody at 142. Let me get it right here. Oh, there's a rebuttable presumption if it's greater than 104 days that you'd use of parenting time overnights with the other parent, that you look at the joint custody worksheet. Right now it's 142 days. The 104, that number comes from 2 nights a week. I thought to myself, and as a prosecutor, I didn't have to deal with custody and parenting time issues, and I thank my lucky stars every night for that. But my analogy was, if someone had my car for 2 nights or 2 days a week, would I consider that a joint? Would I consider that I'm the only owner of that car? I have joint ownership. I would feel that I wasn't the only owner of that car, and that someone else should be sharing those expenses. So we settled on the 104 days as a new figure for the rebuttable presumption. And
I'm going to butt in here because I was the one commission member who does deal with custody and parenting time on a regular basis, and I argued till I was probably purple in my face that this was a bad idea. It was.
Correct.
Huh?
Incorrect, because 10-4 would result in every
Yes, and
it would change child support by 50%.
So for all of you who are practitioners who are rattled by this, please know that the divorce practitioner on the commission was very rattled by this, to the extent that I brought in charts of samples to say this is what the result would be. I talked at length about post-decree issues, about because this for all 100 cases in our firm that we handle would put everybody in worksheet 3, which then puts everybody in expense sharing. And my head was about to explode every time we talked. Every case. And so my guess, and this is only a guess, I don't have insider information, I've had no conversation with the Supreme Court, but my guess is this might be the issue that they're held up on. But you have to understand, it's the makeup of how we review this. And so we had a commission of 12 people. Everybody disagreed with me. We had the custodial parent agreed with this, the non-custodial parent agreed with this, and I couldn't say it enough that I thought this would dramatically change how we're looking at the Parenting Act and the subsequent child support orders. So I'm not, Bill and I disagreed during the commission. We know that, we understand that. I just hope that some of you know, whichever way you land on it, the voices were represented, because there was opposition to it, there was support for it, and we debated it at length. So you have a question again from?
Those overnights, they were asked for the purpose and the
sole purpose of reducing the non-custodial parent's child support obligation, and then that person vanishes into the mist, and the custodial parent and the children are then subsidizing that non-custodial parent's life.
There wasn't any statistical data that we could evaluate. So no, and my answer to that would be, I would hope that that would be qualification for an application to modify. But again, you're sticking the parent who's not done anything wrong, who's supporting the children, having to go to the expense. I mean, I get it. So I just. Right, but I think the courts, I do think that the courts would look at, if we've made child support decisions based on the assumption that you're going to exercise your parenting time, that the courts would be fair about it, or at least there's a great argument to be made. But again, we're talking about real people who have to fork over the $2,000 retainer to bring it to the court's attention. So I agree with all the head nodders in here.
The other side of that coin, though, is that they're required to share expenses.
Which is so terrible.
Which is, as Angela pointed out in the commission, she may recommend to her clients don't go for the joint custody because it may be more of a hassle and financial than it's worth.
I know, and I gave you guys, I gave language where I said, here's what parents will fight about. And these are all real cases. And I provided this whole, these are horror stories that we came up with where it's, well, mom bought $50 jeans from the Gap for daughter age 13. Dad says, well, no, you could have bought jeans from the child at Target for $20. I'm not reimbursing. And the commission's like, no, people don't do, I gave the example of the parties were supposed to share the educational expenses. So there was $6 spent on the materials for the poster board for the science project. So mom goes and delivers $3, her share, in pennies to the mailbox of dad. Oh no, people don't. Yes, they do this all the time. And I said, you're going to make me a wealthy woman, which is a great thing because we're going to have so much post-decree litigation on these issues. But that's not what we want. We're good lawyers. We don't want our clients to be involved in litigation until these children are 19. But I'm preaching to the choir here. I know that.
I wanted to say.
Okay, so we had 2 judges that never used Worksheet 3. We had a judge from Lancaster County who was not familiar with the use of Worksheet 3, and I'm not going to, and then the next judge said that she always, in fact, I think it's her testimony, and this would be public record, said that she awarded joint custody in all of her cases with mom with primary decision using Worksheet 1, child support to mom. Doesn't sound like they were as familiar with the ramifications of when you switch how much, and I gave the charts of how much does the child support reduce, just going from Worksheet 1 to Worksheet 3, not even including the disaster that is expense sharing. Yes.
Angela, if I could butt in here just a little bit. No, it's okay. The time is fine. The great irony of this as well was if this is adopted and we have all these people pushing for equal parenting time, presumptions of equal parenting time, the irony is that this change would actually probably have the opposite effect because the judge across Nebraska would be like, hey, I gave joint custody. 28% time. Enjoy your joint physical custody.
Yeah, so I kept trying to argue with the non-custodial dad who didn't like me one bit and wasn't shy about that. But I kept saying, I don't think you understand what you're going to do because now all the judges can pat themselves on the back and say, well, I gave you your 2 nights every other week, and now we're going to call it joint. You'll get a now. To be fair, in the guidelines, it'll be based on the number of days. So it won't be the dramatic leap that we see from Worksheet 1 to Worksheet 3, 50-50 time. But it will still decrease. But I kept trying to say to him, you're hurting, if this is your aim, and I didn't care really about his aim, but he wasn't able to understand that I think that's exactly right. The courts will say, well, we're a joint custody state. We hand it out like candy. But that's not really what it is. And it's contrary to the case law that talks about continuous time with the children, blocks of time. Yes?
Was any consideration given to increasing the number of cases in which the state is going to be those records, whether mom has to even answer, whether he's supposed to find that out. I mean, it's going to be a day, maybe a 2-day trial to get there. And the state level, they actually have to put a lot into this case as a party.
I will tell you that college expenses is not a 4D function. It's not something that would be enforced through a county attorney's office.
Well, this is a private legal.
Okay.
But if the state somehow pays certain health care expenses, child care expenses, because there are some disabilities and things involved, under case law, I believe the state would be a necessary party, especially if mom assigned her right to payment over to the state of Iowa, but she's now seeking the same money that the state of Iowa paid out from my client who is dead.
You get some really difficult cases. I'm glad I don't have it. That sounds very hard. Any other questions, or do you want tomatoes at us? Or yeah, the comment period
ended April 3rd.
And here's what I don't know, but here's what I will say about the process. So this was my first time serving on the commission. I was, I think, the only newbie.
No,
except the custodial dad. But get involved. There wasn't, so Myrnie Haney from Legal Aid came and presented really brilliant testimony on, she was looking at the poverty level of clients. She was the only lawyer, absent Adam Astley, who came kind of to support us in almost an advisory role. But no, so it's me turning blue in the face and them saying, Angela, calm down. But I do this work, we do this work, so I would encourage you in the legislation or when the commission's convening, pay attention to when the public hearings are held. Send letters into the commission. We reviewed any letters that came to us. I was just surprised in the process that there were 12 of us to make these very important decisions, and there was a lack of, I don't want to berate you, but there was a lack of leadership from the legal community to come in and give thoughtful commentary. So I really do encourage you to get involved because your clients rely on you to do that.
There's a hand way back there. Hi, Edith.
No, Edith, start and go, hey, sis.
I got Bill's she and I have 14 parents who live in house in different destinations. So maybe I represent Virginia, so I'm just, I see the two judges here today, and I've always used, or ever, often these use what you really, I don't look at the place on the other foundation here, or how they saw it. And I can also speak to one other issue. I just concluded the 10 period and my exhibit was nearly this big for expenses of it. And that's 3.5 years shared expenses of all the thing on client. That was a link that the county pays or index that city pays 194, which was the subscription as well. 19 pays. So I have done that kind of serious review for $20,000 in expenses over 3 years because the city got that account. I didn't think it was really contribution.
You're welcome. The commission heard testimony from several non-custodial, I think they were all dads, maybe one mom. Yeah, it took all day. And they came repeatedly, story after story, and talked about how they could not afford their child support obligation and they could not afford their own household. There was no testimony from custodial parents who were receiving child support about the impact the child support has on their household. The custodial mom who served on our commission had joint custody. I'm not sure if she received child support. She didn't contribute to the dialogue that way, so there was just a complete lack of any evidence from custodial parents who rely on child support. we talked a lot about moving into, well, I tried everything. So part of what I was trying to look at was, okay, well, let's just look at the non-duplicated expenses between households. You know, how do we get fair about the things that there's a one-time expense? And so I was trying to deter them from going into expense sharing and say, well, okay, maybe let's just talk about this category. And they didn't favor that. So all I can say is there was no voice for parents who receive and what impact. So, but we would look at the charts. I provided several hypotheticals, and their response was always, well, dad still has to support their household too, and which is accurate, but there was no testimony from people saying, well, if my child support dropped from $750 for my 3 children to $100, no, but I did. I argued, I said, you're going to have children then switching out of schools potentially, they're going to have to be moving because you're going to dramatically upset the arrangement of the, at that time, custodial parent, because I guess then they'd all be called joint. And the commission just didn't agree with me on it.
Adam, I think you were there when the public hearings were held and the cattle call people came up. Do I recall that right? Yeah. It was quite a parade of people, and there were no real voices on the other side. See, some were more moderate than others, but you know, and actually we took some public testimony at a later hearing. Briefly, we weren't required to, but we did, and it was more of the same.
Any other questions about, so we're not sure what the Supreme Court is going to do. Their options are they can disregard our recommendations, they can adopt them in their entirety, they can pick and choose. Fundamentally, some of the things that the commission recommended, the health insurance for parents, the lowering to $250, they just made sense based on the information that was provided to us by the experts. So we followed recommendations that way. Yes?
Yes. We considered, our analysts gave us different options. I think a few states do like just a straight percentage of income, but the trend is definitely toward the income shares formula to be used by the states. I think Nebraska is one of 39 states, and 4 years ago it was like 35 states that used it. So the trend is in the direction that we're already there with the income shares formula. We didn't find any reason to deviate from it.
No, to be honest, she explained it to us. But
it's been 6 months, or almost a year ago. So.
And it was, we listened attentively. A lot of it was like, woo, there, you know. But she explained why there was the national trend, and I believe we looked at the tables from states that did it different, and the differences were really marginal. It just wasn't enough for us to, and then we thought, we're not going to have enough time to do this. So I know it sounds like a lot of things we were saying, well, we just didn't have time, but we didn't have time to completely revamp. I think at one point we had talked about we should have the next commission set the timeline well enough in advance so that they could give more thoughtful consideration. So yes, we talked about it. So we started our work in July, had to be complete by December. We talked about the head of the commission starting it maybe in January or earlier in the year so they would have more time to give some thought to that. But we did follow national trends, and it didn't seem to make a huge difference, but the point was discussed.
You know, one thing, the legislature waited till they were out of session to start this, and that was summer.
Bill and Angela, is there a provision in the recommendations as to applicability if the changes are adopted for instance, the economic tables that would cause everyone's child support to go down some, whether that could lift the gate of, all right, the guidelines have changed, everyone go get their child support changed.
This is ironic that I was the one person saying you have to apply this prospectively so that we don't do that, which is to open all, right, and I'm the one who would benefit from that. I mean, I concede that. So the commission didn't adopt that. So there is there was no recommendation made that you couldn't, as soon as the guidelines go into effect, you can go in. And part of the commission's reasoning was, look, we're updating the tables. They are what they are. People should have accurate child support based on the economic data. So I got that. And I'm not sure how much whatever they adopt will be publicized, but I don't know that parents will know they can go, well, that's not true. We can't say it's in an advertisement.
Steve, you'll have to say it's an advertisement if it's not a current client.
So, yes.
The guidelines are not, the poverty guidelines should not impact on their pay, then having to reimburse for expenses.
No, well, we didn't.
They shouldn't. And so what may happen is people may have to channel through mediation to roll the house remedy without having to initially go to court to try to hammer out some of the
Philip, do you want to?
So again, the saving grace may be the expenses as much as possible.
I'm going to have you repeat that so people in the back can hear.
All right, I'm going to hand you my phone. Angela, would you pull that one up?
Yeah, I'm Lynette Boyle, and my comment was, despite all the promises that healthcare costs wouldn't go up, they're of course skyrocketing, and that with the healthcare costs, it may put child support at the poverty guidelines, and so the saving grace may actually be the expenses that are shared. As much of a nightmare as that at least is going to be initially, and if a good mechanism to collect can be found, that may be the saving grace for this. So there may be a lot more work for mediators. Most of the counties have the mediation centers that do sliding scales. You can mediate pretty reasonably to try to hammer out at least as much as you can as it relates to those things, with the understanding that there's always a percentage of people that nothing's going to help. Nothing short of going to a full-blown trial will help because they have other issues rather than trying to look at what's best for the kids. But we may have to market mediation more. We may have to do a variety of different things differently. But the expenses may actually be our saving grace for people that are low and middle income.
Any other comments? Questions?
I did want to mention one case that's related to child support, and forgive me if I was out of the room and Steve mentioned it, but for many of you who maybe do negotiate the sharing of college or parochial private school expenses, as you know, the court can't force those, but and I've spoken to a lot of attorneys about this, if you agree to it, you put it in a court order, I always told clients, this is above and beyond child support, sharing of uninsured medical expenses and other expenses, and that thing's never going to change. You're always going to be on the hook for that. So if you lose you're always going to be on the hook for it. And that case came out, and I can't recall the name, but it said all of those forms of support are for the support of the children, and they're all modifiable. And I was like, oh. Because everyone I know that I respect in this area that I talked to about that said, oh yeah, that's what I always advised. And that was the first case that said, oh no, your agreement to pay for Johnny's parochial school at Brownell Talbot is, the court can look at it. Now whether the court will or not, I don't know if they'll really, in practice, allow you to modify that. But this case said you can. So I just thought I'd mention that since you're talking about these.
I can't believe everyone's still here at this hour. Especially Mike, in the front row here. He's still here.
All right, well, are there any other questions for Bill and Angela?
Thank you.
Okay, well, thank you very much. Again, everyone, the evaluations will be sent out to you on Monday. Please give us the feedback so we can know what, so that I can know and the section can know what you do like, what you don't like. And we've got that free webinar on September 4th. And please come join us for drinks and food. Thank you.
So there's the little clock. I didn't see it till this. We're great. I figured there'd be